Well, good morning, everyone. Welcome back. Welcome to Friday. Oh, we're going to hear the magic words today. Your Honor, the Commonwealth rests. We've been waiting so long for this, guys. I've been going back through my notes. Here's where we're at so far, plus the one I'm actually writing in. We have endured a lot here. Getting through this case from the Commonwealth. And, you know, I think we've tried to be generous. I really do. I really do. I haven't been here trying to look for excuses. We've just considered what we've seen with a critical eye. And if questions have come up, we've asked those questions. But it's just still pretty amazing to me after all this time we've put in that there's still just so much that isn't answered. So many things that just don't quite fit. So it's likely that we will get a motion to dismiss, motion for directed verdict, something along those lines from the defense today. Very, very common and frankly just routine to do that once the prosecution rests their case. It's almost never granted. I've said many times I don't expect anything to be granted. In this case, it's just such a favorable legal standard to the Commonwealth. But it is going to be an opportunity for the Commonwealth to really steelman its case in a way that I don't think we got in opening. Really didn't get a lot of commitments at all in opening. So I've been thinking back over this. I've been going back over all of these notes, trying to pull out what really is the Commonwealth's case here. What's the best argument for the Commonwealth's case here? And here's what I've come up with. Karen and John had a toxic relationship. I mean, that's really key to all of it. They got to explain to us why this happened. And that's it. That's it. They had a toxic relationship. They fought, had this big blowout in Aruba. Karen had some maybe jealousy towards other women. So all was not as it seemed on the surface. And on the night that they went out to 34 Fairview on January 28th, they'd been fighting that day. Fighting about the kids, the future of the relationship. Where's it going to go? Just kind of basic levels of compatibility, really. Different attitudes towards the relationship, towards each other, towards how to argue and how to make up, how to parent the kids. But neither seemed really willing to let go. Both recognizing, yeah, there's issues here, but nobody was willing to let go. So they were fighting that day on January the 28th when they decided to go out to first C.F. McCarthy's and then ultimately to the waterfall, where they met up with Jen McCabe, Matt McCabe, Julian Chris Albert, Nicole and Brian Albert, Caitlin Albert, Tristan Morris, and Brian Higgins. Unbeknownst to John, Karen had even been exploring options outside the relationship with Brian Higgins. She was looking for her escape hatch. She thought he was going to be it. And he was there at the bar that night. But she was there with John. Couldn't really go through that door. And everything seemed good on the surface, but There was a lot of alcohol being consumed, a lot of drinks. Karen always had a drink in her hand. Now, just because the Commonwealth's witnesses said, didn't seem like she'd been affected. Nobody seemed like they had any concerns about her ability to drive. People have tolerances to alcohol that they can develop through their drinking habits over time. And Trooper Buchanan testified. He watched that video and he saw 9 drinks that Karen Read consumed, starting from when she arrived at C.F. McCarthy's at just about 9 o'clock that evening and midnight when they left the waterfall shortly after midnight. So everybody is getting along at the waterfall, having a great time. Nobody's really ready for the evening to end, even as the bar is closing. So they decide they're going to go ahead and go back to the Alberts house at 34 Fairview. And everyone is getting along so well that Karen and John are invited. Never been there before. These aren't really their friends, but they have a professional connection since both Brian and John are police officers with the Boston Police Department. So they're invited back, and they seem interested. They seem interested in going. In fact, to such an extent that John and Jen McCabe are communicating on the drive over about how to get there, to make sure that they're able to find the right place. And so they do arrive. We know that not only do the people in the house see Karen's SUV arrive and park out front through the front window, multiple people at the party, but also completely impartial third parties. Ryan Nagel, his friend Ricky Danton, and Heather Maxson, Ricky's girlfriend at the time. Don't know any of these people. No reason to fabricate anything, but they see that SUV arrive. They follow it right down the street and park out in front of 34 Fairview. But something's happening in that car because John never comes inside. Karen never comes inside. And Jen McCabe is watching out the front door and texting John, "Are you here? Pull up behind me." She sees them waiting out front, thinks maybe they don't know where they should be, so she tells him, "Go ahead and pull in behind me." But they don't get a response. She doesn't get a response. And so she's attending to the party. She's not stuck to the door trying to pay attention to them, but she sees the car creep forward towards the edge of the property where there is a fire hydrant and a flagpole. And she sees the car stopped in that area, but still nobody gets out and nobody comes inside. And despite her communications with John to try to clarify, make sure he knows it's okay to come in, he doesn't. And eventually, when she makes it back to the door and looks outside, the car is gone. Well, they think nothing of it in the house. It's been a long night. Everyone's had a fair amount to drink. They just assumed Karen and John decided not to come in after all. They were going to go ahead and go home. Maybe it was just a longer night that they had really anticipated when they had left the waterfall. So nobody thinks anything about this. No reason to call. No reason to check in. They just continue with their night. And as the night winds down, the snow is picked up. And it's begun to fall. It's begun to stick. It's starting to accumulate on the cars, on the grass, on the roads, and on anything that would have been lying in that front yard at 34 Fairview. And as everybody leaves, it's just a normal night. Just a normal night. Nobody sees anything out of the ordinary. Nothing appears to be amiss. But as they're driving by, Jen McCabe and Chris McCabe, or Matt McCabe, they're taking Julie Nagel and Sarah Levinson home for the night. And it's a light environment in that car, having fun, casual conversation, chit-chatting, laughing at each other, making fun of Jen McCabe having sandwich materials in her car. But as they're driving by, Julie Nagel just happens to catch out of the side of her eye, there's some kind of a black blob there in the yard. She's never seen it before, but really thinks nothing of it. There's a storm going on. I mean, it really could be anything. No idea. No idea what it could be. But no reason to think it's anything alarming. Until the next morning, when at just after 4 o'clock, Jen McCabe is awoken in the morning by a frantic phone call from Karen Reed. Frantic phone call. She can't find John. John never came home. So Jen gets up, begins to make coffee. She's thinking, where could John be? Thinks of some friend's house that perhaps he went to, and she makes some phone calls to see if they can find out where he is. In the meantime, Carrie Roberts also receives a phone call, a frantic phone call from Karen. And what Karen tells Carrie is, I think John's dead. I think a plow hit him. Clearly very alarmed. Carrie doesn't know why she thinks this, why she's saying this. But she agrees. She'll help Karen. Help her look for John. And so everybody convenes at Jen McCabe's house that morning. A little bit right around 5:30. And first they decide we need to double check at John's house. Karen is clearly frantic. Maybe she hasn't seen something. Maybe he's come home in the meantime. So they carpool in Carrie's car and Karen's car. Karen and Carrie's cars over to John's house. And when they arrive, they notice Karen's got a broken taillight on the back of her car. Her taillight's cracked. In fact, she even points it out to them. They go inside, they look around, can't find John. He's not there. He's not there. They look through the entire house. He's not there. So at that point, they decide to go back to 34 Fairview. And they go there in Carrie's car. They leave Jen's car. This time, all three of them piled into Carrie's car. They leave Karen's car at John's house. And they drive over to 34 Fairview, where, as they're passing by the front, Carrie and Jen, they see nothing at all. But Karen screams, I see him. Stop the car. And she jumps out of the car and she runs to a lump in the snow there at the corner of 34 Fairview, near the flagpole and the fire hydrant, right where Jen McCabe and the other people in the house had seen Karen's SUV the night before. And there is John in the snow, grievously injured, not breathing. Jen calls 911. First responders arrive within minutes. And they get John into the ambulance. They get him to the hospital, but they're not able to revive him. Not able to ever get a pulse back, to get him breathing again. And so John passes away, and he's declared dead at just after 8 o'clock in the morning. Maybe just a little bit before. Well, in the meantime, this scene has been chaotic. The scene has been chaotic. Everyone is trying to sort out what happened. The first responders looking for information, and Karen tells them spontaneously, I hit him, I hit him, I hit him. And this is heard by multiple people. Karen is so frantic, and she's saying such disturbing things that as Carrie is driving her away to take her to the hospital, the police are contacted again and notified. She's threatening to kill herself. She's making suicidal statements. So police contact Carrie, have Carrie return Karen to the scene, and they section her. They take her to the hospital for evaluation because she is so distraught, so alarmed. And while Karen is now at the hospital, police come to be aware that John's niece and nephew, the children that he's been raising like they're his own children, they could be home alone. So police decide to go out and do a welfare check at the home, not suspecting anything else, not looking to see anything else. And it just so happens well, that was weird. Just so happens that when they arrive, the car is there in the driveway.
Well, first is Karen Reed.
All right. Good morning, Council. Good morning, Ms. Reed.
It's got a cracked tail
Good
light.
morning, jurors. I have to ask you those same 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, read anything about this case since we left here yesterday?
Well, thank you.
Everyone said no.
We are still manning. We're trying to give them the benefit of the doubt. Because the defense, of course, is going to come up in their closing and point out hole after hole after hole after hole after hole that we've pointed out with all of this. The problems with the timeline, the problems with the taillight, the problems with the witnesses and their recollections, the problems with the injuries.
You solemnly swear the evidence of the court and jury in the case now to answer the truth, the whole truth, and nothing but the truth, so help you God.
But that story I gave you, that's approximately what the Commonwealth is going to give Judge Cannoni in response to a motion to dismiss. And that's why it's going to be denied. Because that's going to be the standard. You don't consider all of the problems that the defense has brought to light with this
Whenever
case.
you're ready, Ms. Tallali. Good morning, Doctor.
Good morning.
Morning, Doctor.
Good morning.
Dr. Scordi-Bello, if I could ask you some questions, just turning back a little bit from what you were testifying to about yesterday. You had mentioned in your testimony yesterday that you had received some, in addition to the internal and external examination that you conducted with Mr. O'Keefe, you had received some other material that you had reviewed, correct?
Correct.
Now, included in that material was some material from the state police as far as the investigative agency investigating Mr. O'Keefe's death.
Correct.
Now, is that is that typical? Is that abnormal? If you could describe sort of in general terms.
Describe
as
sort
far
of
as
in general.
What, if any, communication would you
Please
typically
don't be
have
specific,
with the
Doctor.
investigating body or agency in relation to any sort of autopsy or examination you do?
Yes. In Massachusetts, under Massachusetts law, the medical examiner's office is responsible, and our role is to determine the cause and manner
She
of
said
death
all
by doing
this
an
yesterday.
autopsy. The scene
Ellie's just gotta take
or
up some more time.
the scene of death or the place where the decedent is found is controlled by the district attorney's office, and state police will do an investigation. When we accept a case into our office, we request reports, police reports, to explain and describe the circumstances of the death. It could be a house, it could be somewhere else, it could be outside. Every case comes with a police report, and we review that police report, and if we feel that we need more information, then we contact the investigating body and ask for more information, again, depending on the case.
And specifically in this case, in regards to Mr. O'Keefe, did you reach out to get some more information?
I did reach out, yes.
Was that in part in relation to what you were talking about in your testimony yesterday as far as the diagnosis of hypothermia and trying to sort of better understand the circumstances?
Objection, Your Honor.
Sustained.
Why did you reach out?
I reached out because when the case was presented to us, and after I did the autopsy, I did not have all the information that I needed in order to certify the manner. The cause of death to me was, I was able to determine the cause of death from the autopsy. When an event is unwitnessed, we usually reach out to the investigating agency and ask them whether they have any more information than they did on the day that the autopsy was done, because investigations sometimes take some time. So in the days and the weeks following the autopsy, I reached out and asked if there was any more information than what I was originally presented with. Was there any video from the surrounding areas? Did anybody come forward to say that they actually witnessed whatever happened? Again, by the time I was ready to finalize the case, and we have approximately 3 months or 90 days from the day of the autopsy until we issue a report, I was not provided with enough information for me to be able to determine the manner.
Now, Doctor, do you recall specifically who it was that you spoke with from the state police?
Yes, I documented that I spoke with Trooper Proctor, I believe, twice.
And with reference, not asking you anything as far as what that conversation consisted of, but as far as the tone of that conversation, did you feel pressured or coerced to come up with a certain determination?
No, I did not.
And even if you had been, what would your response have been in reference to that?
My response was that I am responsible for what goes on the death certificate, and unless I have enough information, clear and convincing evidence, I cannot determine a manner.
So hardly
Yes.
compelling evidence, wasn't even clear and convincing. She's not getting into specifics about what exactly was insufficient here. What was the shortcoming?
Doctor, I'm showing you.
Don't know
Five
that the defense
photographs
is
that I,
really going to explore that,
gave you
but
yesterday. Do you recognize those?
I certainly notice it. It's very vague.
Yes, I do.
And what do you recognize those to be?
I recognize these as photographs of Mr. O'Keefe's body. I believe these were taken at the hospital. One of them is a photograph taken at the time of autopsy.
Thank you. May I approach again, Your Honor?
Yes.
I'm going to seek to introduce in the minutes the next exhibits.
Ms. Little? No objection. Thank you.
She does say a lot. I'll give her a lot of leeway because she's not a native English speaker. That seems pretty clear. And speaking isn't her job. It's part of the joke about pathology is the patients. They don't talk back to you. You don't have to have the chit chat with them. So maybe just not her strong suit.
Thank you very much. May I have a moment? I just want to make sure they're in the
Yes.
right order.
Still not getting a whack job vibe. Whatever else we might think of her. Not getting whack job.
May I approach again?
Yes.
Your Honor, with the court's permission, may I publish these for the jury?
So jurors, remember the instruction I gave you yesterday on these photographs, okay?
Ms. Gilman, if I can have photograph 2853. Doctor, do you recognize what's up on the screen?
Yes, this is a picture taken of Mr. O'Keefe's body.
And doctor, if you could, using the laser pointer that you have there, direct the jury's attention to what, if anything, you observe of significance in this photograph related to the injuries that you were testifying about this.
Yes, so first thing you notice is the medical intervention, which I talked about yesterday. There's defibrillator adhesive pads on the chest. There is what's known as a C-collar, a cervical stabilization collar for the neck, and he has been intubated prior to going to the hospital. The injuries that are obvious in this picture include the abrasions on his right forearm and arm. And you can see here, there is discoloration of the upper eyelid of the right eye with some blood that's dripping. That's the orbital or supraorbital ecchymosis that I described before with we're too far to see the very, very small laceration that is present there, but that's what's causing the bleeding.
Don't know why the camera is having us stare at Karen while the photos are up. That was weird. Sorry, guys. Let me bring it back up. Things are being a little glitchy today.
Yes, this is a picture of the abrasions that I described in my report. Posterior upper arm and forearm. You can see that they have some sort of pattern to it. Anytime we see a pattern, we try to document it as best as we possibly can.
The camera is definitely not going to show the autopsy photos. It's just they could be showing us the witness.
What kind of role would that play as far as your determination, as far as cause of death of Mr.
These
want the
are
drama.
superficial abrasions to the skin. They are not lethal. They're not contributory to the cause of death. The trauma that I observed on the head along with the hypothermia are the two factors contributing to his death. These are present, they're noted, they're described, they're photographed, but I do not know how they came to be, and I did not contribute them to the cause of death.
Ms. Gilman, if I could have photograph 2860. Doctor, returning to the exhibits or the photos that you have before you, do you recognize what's up on the screen here?
Yes, this is a photograph of Mr. O'Keefe's right hand. This is the dorsum or the dorsal aspect of the hand as opposed to the
You're going to show
palm.
us the hand?
And you can see that there are some contusions or bruises. There's a larger one here and two very small ones here. This particular contusion has two pinpoint small defects associated with it. I believe this could be due to attempts at gaining IV access during the many attempts of resuscitation, but I cannot be absolutely sure.
No, because he was asystolic. He had no heartbeat.
Gentlemen, if I could have
He would not be
photograph,
forming a
please.
bruise.
And Dr. Scordi-Bello, if you could, again, using the ways of point of direct jury's attention to what, if anything, of significance you note in this photograph.
Again, this is a slightly closer view of Mr. O'Keefe's face. You can see the discoloration, the ecchymosis on the right eye with a slight amount of bleeding. You can see here that there's also some discoloration of his left eyelid.
And doctor, with reference to the other injuries that you were testifying about yesterday, as far as the small cuts or abrasions or lacerations, are those visible in this photograph as well?
I can't hear your question. If you could just repeat it and a little louder.
Sure. My apologies, doctor. With reference to this photograph, as far as your testimony yesterday in regard to the other smaller injuries around the nose and eyes area of Mr. O'Keefe, are those visible in this photograph as well?
You can see some discoloration of the nose, but this is not a very good picture of it. I think there's a linear abrasion on the left side of the nose that I described, and it's probably this.
Ms. Gilman, could I have photograph 2877? And doctor, if you could, again, using the laser pointer, direct the jury's attention to what, if anything, is significant you observe in this one.
Yes, this is a view of the left side of Mr. O'Keefe's face. You can see the discoloration of the left eyelid, and now you can see this linear abrasion on his nose and a small abrasion more towards the middle of his nose.
Ms. Gilman, lastly, from this set, if I could have photograph 9488. Saying, Dr. Scordi-Bello, if you could, using the laser pointer, direct the jury's attention to what, if anything, is significant you observe in this.
This is the laceration to the back of Mr. O'Keefe's head. You can see this defect here. It's ragged. It's a typical classic blunt impact injury, and you can see the abrasion, the scrape that is adjacent to it.
Thank you, doctor. Ms. Gilman, you can take that. And doctor, we get out the lights. Thanks. Now, doctor, with reference to what you were testifying yesterday as far as the subscapular bleeding, bleeding under the scalp, was that more or less prominent on one side versus the other side of Mr. O'Keefe's scalp?
Yes, it was more prominent under that laceration that we just looked at.
Plus, he
So
had to
would
go
that be
through it
more
all in
prominent on the
general
right side, is that
terms.
correct?
Yes.
What do these things mean? And then ask her specifically how they apply in this case. It's Lally being Lally.
And you
Gotta suck up
testified
all the time in
yesterday
the
about
room.
a blunt objects injury in relation to the injury to the back of the head and leading to the fractures and the bleeding in the brain, correct?
Correct.
And then further leading to the ecchymosis, is that correct?
In the eyes, yes.
Now that blunt objects, what if anything can you say about what that blunt object could be?
Could be any blunt object.
Now, from your training experience with reference to the number of autopsies and examinations that you've conducted over the years, would that blunt objects possibility include the ground, especially if it was frozen ground?
Objection.
Ask the question differently.
That makes sense if the idea is they're keeping the blood moving through his
The-
body.
Injuries that you observed
The
to the
IVs
back
are
of Mr.
central.
O'Keefe's head, skull fracture, would that be consistent with a fall to the ground?
It could be.
Would that be consistent with being projected by an object, say in a pedestrian collision, and then striking your head on the ground?
It's possible.
She didn't seem to want to accept that.
The arm injuries that you observed, would those be consistent with scratches from either glass or a piece of plastic or a piece of metal?
It's possible.
And the injuries that you observed, would that be consistent with injuries that you observed in other cases of a pedestrian collision?
They're not the classic pedestrian injuries that we observe, no.
And to that point, as far as when you say classic, as far as a pedestrian collision is concerned, you've conducted autopsies on a number of different pedestrian collisions over the course of your career, is that correct?
Yes, I have.
Do they all sort of mirror each other? Or is there sort of a disparity depending on how the person interacted with the car?
Projection.
Sustained. Watch the form, Mr.
Quite
Lally.
vague
What, if anything,
and compound.
are every injuries from a pedestrian collision the same?
No.
And why not?
It depends on many factors. It depends on the position of the body, of the pedestrian or the person being struck. It depends on whether they are moving or standing still. It depends on the speed of the car. It depends on whether brakes were applied or not. There's a lot of factors that come into play.
Would another factor be sort of the shape of the vehicle that strikes a pedestrian?
That's
I think
also
that's what she
possible.
meant
Yes,
by
that's a factor.
manufacturer.
And did you have occasion to see any photographs, or have you seen any photographs in relation to the defendant's vehicle in this case?
I have seen photographs, yes.
And
I kind of remember
the
that from the
size or
testimony
shape
too.
of that vehicle, what, if any, significance did that have to you as far as your examination?
Projection.
I'll allow it.
When we have a potential vehicle, clearly we look at the height, because one of the things that we do in most or all pedestrian or people struck by a motor vehicle is look at the legs, because in the majority, we see injuries to the legs from the bumper of the car. Again, depending on the kind of car, the size of the car, and the height of the bumper. So in Mr. O'Keefe, I did not see any injuries in the lower extremities. And looking at the car, I did note that it was a much bigger car with much higher, I would say
Not that
much
big or
higher
high.
tail light bumper. It was not a sedan or a car that's low to the ground where the
It's just a
bumper
normal SUV.
would be at the level of, let's say, the knee or slightly above or slightly below.
It's not like, some big lifted truck. Big 36-inch
Again, I believe
wheels.
you-
It's not
yesterday in
bad.
your testimony, you indicated that the skull is a pretty thick bone, is that correct?
Yes.
Sustained.
With regards to the thickness of the skull bone, what if any significance, or what if anything you say as far as the type or amount of force that would be would be necessary to cause the fracture that you observed?
Projection.
Overruled.
She said she couldn't testify to that.
I would consider the amount of force to be significant, again, without being able to quantify it.
I have a moment, John.
Yes.
She said they're not consistent with the classic injuries. Let's go through what the classic injuries are. Let's lay out that distinction.
Now, doctor, from
Anything else
the internal and
besides
external
leg
examination
injuries?
that you conducted in regard to Mr. O'Keefe, as well as the other materials that you reviewed, were you able to come to an opinion to a reasonable degree of medical certainty as to the cause of death of John O'Keefe?
Yes, the cause of death
already
was due to
said-
blunt impact injuries of the head and hypothermia.
Thank you, doctor. Your Honor, I have no further questions.
All right, cross-examination?
Let's get it.
Good morning, Dr. Scordi-Bello.
Good morning.
Ms. Little, keep your voice up.
Absolutely. You testified regarding a number of injuries that you referred to as blunt impact injuries, correct?
Yes,
And to be clear, blunt impact injuries are a very, very large category that includes contusions, lacerations, abrasions, and fractures.
correct.
And you testified similarly that a blunt object can also refer to a large range of objects. Is that right?
Correct.
And I think yesterday you gave the example of a microphone being a blunt object.
Correct.
It could also include something like a baseball bat,
Correct.
a dumbbell,
Could be.
the ground,
Yes.
or a German Shepherd's claws.
Claws. Possibly, yes.
You'd agree that John O'Keefe had a number of blunt impact injuries on his face, on his head, and his right arm.
Yes.
Besides his right arm, which we'll discuss in a second, taking his body from the neck down, he did not have any significant injuries.
From the neck down. Not significant, no.
Let's take those one at a time. No injury whatsoever to his shoulders.
Correct.
No injuries whatsoever to his chest area, aside from sort of the CPR-related injuries that you discussed.
Yes, correct.
And that was in the sternum, is that right?
It was in the ribs, just adjacent to the sternum, yes.
Okay. No injuries to his torso, other than that.
No,
No injuries to his back.
no,
No injuries to his hips.
correct,
No injuries to his pelvis.
correct.
No injuries to his thighs.
To his,
Thighs.
no,
No injuries to his knees.
correct,
No injuries to his shins.
Bev
Correct.
hates this.
No
She wants
injuries to
Lolly
his
to object.
ankles.
correct,
No injuries to his feet.
correct,
From the neck down, he did not have a single broken bone, again, aside from those CPR-related injuries you discussed, correct?
that's correct.
Not a single fracture.
Other than CPR, correct.
And you spoke earlier about how the bumper was a little higher than on, say, a regular sedan, correct?
Correct,
And so usually in a pedestrian collision, you would see injuries to the knees, is that right?
Objection.
I'll allow it.
Yeah, you open the door,
depending on the
Lolly.
kind of car, depending on the speed, depending on the height of the individual and the car, you might see injuries to their lower extremity, yeah.
But in this case, you didn't see any injuries to his thighs, to his pelvis, anything even at the height of the bumper, is that correct?
Correct, at a very minor abrasion to the side of his right knee.
So surely you'd agree that John O'Keefe's injuries, or lack thereof, are inconsistent with having been struck by a 7,000-pound vehicle at 24 miles per hour and being projected 30 feet.
Objection.
Sustained. Break it down, ask it differently.
Whether you agree that John O'Keefe's injuries, are, or lack thereof, are inconsistent with having been struck by a vehicle at 24 miles per hour.
I would say it's likely and unlikely at the same time, depending on the position of the body and the
What does that
vehicle in question.
Well, let me give you a hypothetical. Let's say the person were standing with their arm like this, and they were struck by the rear taillight of a vehicle at 24 miles per hour. Would you agree that his injuries are inconsistent with that scenario?
Objection.
Sustained.
Maybe
There's no basis to sustain that. Yeah, so now she's got to ask for clarity because there's nothing wrong with that question. You get to ask her. She's volunteered opinions about the mechanism here. She's volunteered that she's seen motor vehicle collisions. She's done those autopsies on pedestrian impacts. These are not typical injuries. So why can't she ask about the mechanism the Commonwealth has proposed? And is that consistent with what she saw?
You are unmuted.
Yes, Lally opened the door to this.
Would you agree that John O'Keefe's injuries to his arm, let's start there, are inconsistent with having been struck
is
by
the
a vehicle
problem?
at 24 miles per hour and then causing him to spin around and be projected 30 feet?
Okay, so you need to break it down.
The compound. We're going to go into
Would you agree
compound
that
after
John O'Keefe's
Lally.
injury to his arm are inconsistent with having been struck by a vehicle at 24 miles per hour?
I don't know. I am not a reconstruction
Let's
expert.
explore that.
I'm not a biomechanics expert. I never
Is that what we would
personally
need, doctor,
inspected
to answer
the
those
car,
questions?
so I can't offer an opinion on that.
You did examine John O'Keefe's arm, correct?
Yes,
You observed no significant bruising,
correct,
no fractures,
correct,
and no broken bones.
correct.
Got to follow that up, Little. Ms. Little, go into it.
I'd like to talk about
Don't
the
let
injuries
it
to John
pass.
O'Keefe's face. You testified that Mr. O'Keefe had a laceration on his right upper eyelid.
Correct.
You also described multiple abrasions on his nose.
2, yes,
Although these injuries may not have been the ultimate cause of his death, you'd agree that less severe injuries can still be very important in interpreting the manner or the context in which that person died, correct?
correct,
And in furtherance of that, you've been taught that when doing an autopsy, details matter,
correct,
no matter how small.
correct,
And that's one of the reasons as a medical examiner, you have to notate every single injury you find on a person. Is that
correct.
If I could show you. May I approach, Your Honor?
Yes. Show Mr. Lally.
She needs to really hammer on that. You are not qualified. A biomechanical engineer is who has the qualifications to offer that type of opinion.
Do you recognize that photograph?
I do.
And is that a photograph that was taken in connection with your autopsy?
Yes, it was taken at the time of autopsy after the face was cleaned.
Move to admit.
I'm sorry, after what?
The face was cleaned up.
Okay.
I move to admit, Your Honor.
Any objection, Mr. Lally?
No, Your Honor.
Okay.
Exhibit 650.
Permission to publish?
Yes.
Are these the facial injuries that you were testifying to earlier?
Yes,
And could you kind of describe in that photograph what injuries you observed to his face?
Schrodinger's car accident is both
the
likely and
orbital
unlikely.
ecchymosis on both eyes, the small laceration to the right eyelid, the abrasions on the nose.
And you testified that the injuries to his face were also the result of a blunt force trauma.
Correct.
So that's the laceration to the eye and the 2 abrasions that we see there on his nose.
Correct.
And you agree that those injuries don't just manifest out of nowhere, right?
Absolutely.
They have to originate from something.
Yes.
Would you agree that his injuries to his face are consistent with having been punched?
That is a possibility.
Mr. Bates. Thank you. Your
Indeed.
internal examination notes also cite a tongue laceration on the right front of the victim's tongue. Do you recall that?
Yes,
And you'd agree that a tongue laceration can be also caused by blunt force trauma.
correct.
And that could also include something like a punch to the victim's face or jaw.
That's a possibility.
In addition to the facial injuries, you described that Mr. O'Keefe had a significant laceration on the back of his head.
He had one laceration to the back of his head, correct.
I believe we saw a photograph of that a
Yes.
little bit earlier. You testified that the skin around the laceration on the back of his head was also scratched. Do you recall
Yes.
that?
I do.
But you did not testify as to how you opined that might have happened.
No,
Would you agree that someone could certainly get scratched on the back of their head if they were, for instance, dragged on the ground?
it's possible.
You described the open wound to the back of his head as a laceration, which is sort of a blunt force injury that's not the result of sharp force trauma. Is that right?
Yes,
And you'd agree that Mr. O'Keefe's head injury came from some sort of blow to the back of the head, whether it be an object or the ground. Is that
Yeah.
right?
yes,
Objection.
And that injury could be the result of falling backward from a standing position onto concrete.
it's possible.
It could also be the result of being struck with a large object such as a baseball bat or a barbell.
It's possible.
In other words, it was an irregular laceration that resulted from some blunt force trauma.
Correct.
I'd like to sort of circle back to those injuries to Mr. O'Keefe's arm. You testified that there were, again, no fractures, no broken bones, no significant contusions.
Correct.
But you did describe the wounds to Mr. O'Keefe's arm as having discrete linear abrasions, which were caused by some sort of blunt object, correct?
Yes.
What does discrete mean?
It means each one is an individual injury as opposed to confluent where it would be all meshed together.
Your Honor, if I could publish what's been previously marked as Exhibit 19.
Okay.
And these are sort of the linear wounds that you're referring to.
Yes,
And you testified that these also sort of appear in clusters or groups. You call
Yes.
them pattern abrasions, is that right?
yes, I did.
And you'd agree that, for example, road rash does not result in this type of discrete linear wounds.
It could, but not exactly like this.
Well, typically road rash covers sort of a large area of the skin. It would be a large abrasion. I mean, you've seen numerous cases of road rash.
It
in
would
your
be
Yes.
career.
confluent, like she
And-
just described.
It doesn't look like that.
Correct.
Blunt force trauma can include injuries from various objects, as you testified, including an animal claw, correct?
Correct.
And you'd agree that these discrete linear abrasions are inconsistent with having been struck by a smooth rear taillight at 24 miles per hour.
Objection.
Can you answer that, doctor?
I can't. By
Okay.
a smooth, no.
All right, next question.
By a smooth rear taillight, you said that is not what you would see at 24 miles per hour, correct?
Objection.
Sustained.
She said no.
As you testified earlier, you've indicated that based on the facts that were presented to you, you don't know what caused those significant scratches on Mr. O'Keefe's right arm.
I do not.
Have you seen any dog bites, doctor? Just go there. Go all in. Go all in, Ms. Little. Have you seen dog
May I
attacks?
approach, Your Honor? Sure.
You already know your own expert's going to give it to you, so if she disagrees, it's no big harm.
I could just see what was,
Oh, I'm sorry, Mr. Lally. Do you recognize that photograph?
I do. It's a photograph of Mr. O'Keefe's right hand.
May I mark that as the next monitor?
Is there an objection?
may we approach?
Okay.
Yeah, she said she can't answer, and then she said no. And so it wasn't clear, was she just emphasizing that she couldn't answer, or was she said no smooth taillight. It seemed like she was saying, no, it wouldn't be consistent with a smooth taillight. It could be consistent with a broken taillight. But then they just stopped and wouldn't let it go any further. Boy, if Lally came back and redirect on that, that would be super annoying. Yeah, I think Ms. Little is doing well. She is clearly inexperienced, but she is doing very well with this. It's something that I think she would get with some more experience, is just a little more confidence in when and how she can push. It's best not to take too many risks when you're green. Just because you're not necessarily going to know how to handle those. But things like, were they dog bites? Have you seen dog bites before? This, you can do this because you already know you've got your own expert lined up. So it's okay. And she's been very agreeable with a lot of these things you've put to her about, is that possible? She is willing to concede it's possible. Is she going to say for this, no, it's impossible that a dog caused those? I kind of doubt it. I didn't even remember hearing about a tongue laceration up to this point. Yeah. Yeah, you get punched in the mouth. Bite your tongue. You don't have a mouthpiece in. And Ms. Little, she's clearly prepared for this, right? She's put in the work. She knows where she's going. She knows what she's raising, and she's being disciplined about that. And that's a good thing. It's just that when you get openings like, oh, I don't know, we'd need a biomechanical expert for that.
Well, we need to mark it first.
That's where you can pick up
So we'll
on
mark it for identification,
those opportunities.
And then when it's appropriate, it will be transferred to being an exhibit,
Thank you.
but yes, you can publish. Is it all set to be published?
So they're going to
appropriately?
publish something that
Yes,
hasn't been admitted yet. No foundation for it. It'll come in through a defense witness.
Okay.
Dr. Scordi-Bello, you indicated on direct examination that at least that one of the bruises from Mr. O'Keefe's right hand could potentially be attributed to an attempt to get IV fluid into the hand. Is that correct?
Correct.
During the course of your conducting your autopsy, you reviewed records from the Canton Fire Department and EMS, as well as Good Samaritan Hospital. Is that correct?
I did.
And do you recall reviewing records indicating that the IV fluids in this particular case were administered through the tibia and then later through a catheter at the hospital?
Yep, I remember
Yes,
that.
they were administered through intraosseous lines in both legs, shins, and at the hospital, they were administered through a femoral central line. Yes.
And you'd agree that bruising to the backs of hands is also consistent with defensive wounds.
Yes, that's correct.
Mm-hmm.
And there are actually 4 separate distinct bruises outside of the one that you discussed earlier on Mr. O'Keefe's right hand, correct?
Yes, I would say 3, but I can see how you would say 4. 1, 2, 3. That might be 1 together.
And
But
then up
yes,
there
I
on
can
his
see how you would say
knuckles.
4.
And you testified yesterday that there was also an injury to Mr. O'Keefe's left hand.
There was a vague contusion on his left hand, correct?
You were asked by Mr. Lowry.
Can we take this down now, Ms. Little?
Yes, Your Honor.
She can be a partner without having a lot of trial experience, was all
You
I was going to
testified
say
on
in
direct
response to that comment.
examination. You didn't see any sort of obvious signs of the fight because Mr. O'Keefe's fingernails were intact and you didn't observe any fractures on his hands. Is that right?
Correct.
But broken fingernails and fractured hands aren't the only observable signs of a fight. Isn't that correct?
That's correct.
In fact, you noted a laceration over his eye.
Yes.
You noticed multiple lacerations on his nose.
Abrasions on his nose, yes. Yes.
Multiple abrasions on his nose.
Correct.
You noticed a laceration to his tongue.
Yes.
You noted the contusions on the back of his right hand,
Correct.
the injury, the contusion to his left hand as well.
Correct.
And as you just testified, bruising on the back of hands may be consistent with defensive wounds.
It could be.
So in fact, if you have a body that presents with a laceration to one of the brows, a laceration or abrasions to the nose, an egg over an eye, contusions and abrasions on the hands, and a laceration to the tongue, these injuries are consistent with a physical altercation, correct?
Objection.
Sustained.
Are
That's so
those injuries
stupid.
consistent with a physical altercation?
Objection.
Sustained.
They're
Your Honor, may we approach?
Sure.
she's trying. They're not letting. They're calling this compound, but the whole point is that this combination of injuries. She's not asking the witness, does each singular injury make it consistent with the fight? She's saying this whole collection, when you look at them together, kind of looks like somebody's been in a fight. It's not compound. This is so annoying. She handled that IV really well. Yes, I remember now because I remembered there was previous testimony about some weird way of delivering the IV fluids. And then I remember, oh yeah, they stuck it straight into his bone. I didn't know you could do stuff like that. I really didn't. Honestly, medical science, it blows my mind every time. No idea you could just drill into somebody's leg and give them IV fluids that way.
Shifting gears for a second, you indicated on direct examination that you reviewed some photographs from law enforcement that showed no footprints in the snow. Do you recall that testimony?
I do.
Were those provided to you by Trooper Proctor?
Yes.
Do you have those photographs with you?
No, I don't.
Do you recall what was depicted in those photographs?
Yes. If I remember correctly, it was the area of the fire hydrant and the area where Mr. O'Keefe's body was discovered.
Was there any blood?
It's the front of the house, the area of the fire hydrant, and I believe the flagpole.
Thank you.
Was there any blood in the
You
photos?
testified that Mr. O'Keefe had multiple fractures to his skull, but that they seemed to be originating from a single point of impact on the back of his head. Is that correct?
It appeared so, yes.
Are you reasonably certain that all of his injuries were the result of a single impact to the back of the head?
It could be a single impact.
But it also could be multiple impacts, correct?
It could be, yes.
Because as you just testified, Mr. O'Keefe suffered multiple injuries to the front of his face as well.
Correct.
In other words, he could have suffered a trauma to the face and then fallen and sustained the injury to the back of the head, correct?
That is possible, yes.
And you testified before the state grand jury that the areas of bruising to the brain were likely due to a fall. Is that correct?
Yes.
In your expert medical opinion, is it possible for someone to get punched in the face hard enough to lose consciousness and fall backward?
Objection.
I'll allow it.
It's possible.
Indeed it is.
If I can have one more.
Sure.
We'd really like to know more about the blood and why it isn't there all over the scene with that big laceration to the back of his head.
May I see the exhibits that were just marked, Your Honor? Your Honor, if I could have permission to publish what's been previously admitted as Exhibit 19.
Yes.
Is this the photo that she showed, that
Dr.
Proctor
Scordi-Bello,
showed
it's kind
her?
of hard to see in this picture, but there's some redness that you observe on the body by the ribs
No.
that we observed in some of the other photographs that were presented by Mr. Lally.
Do we have just a moment, Your Honor?
Yes.
Your Honor?
Yes.
I'd like to show you what's been previously marked as People's Exhibit 648. Ms. Gilman, would it be, Mr. Bates, could you take that down? Yeah. Ms. Gilman, would it be possible to display Exhibit 648? 648.
Photo number.
May I approach, Your Honor?
Yes.
2853. Thank you. Dr. Scordi-Bello, you were shown this photograph by Mr. Lally on direct examination.
Yes.
Do you see the redness sort of next to his rib cage on the bottom? Correct.
Yes.
What is that?
That is livor.
Lividity?
Lividity. Yes.
Can you describe for the jury what lividity is?
Yes. Lividity is the pooling of blood to the dependent areas of the body after someone is deceased.
So even though it sort of appears to look like a bruise, that's lividity, correct?
That is lividity. Yes. It goes all the way down.
And it's not the result of an injury.
No.
Thank you. No further questions.
Okay, the lights, please. Thank you.
Okay.
Mr. Lally?
Good to cover, but I really would have liked more about blood. Maybe it doesn't matter. But the fact that there doesn't seem to be enough blood at the scene to line up with these injuries that he had, maybe that's just common sense that they can
Dr. Scordi-Bello, you did
argue.
observe a minor abrasion to Mr. O'Keefe's right knee, is that correct?
Correct.
And what part of the knee was that on, if you recall?
It was on the side, on the lateral side of his right knee.
And by lateral, sort of the side that faces away from the body, is that correct?
Correct.
We were asked whether or not the small injuries on Mr. O'Keefe's face could possibly be from a punch, is that correct?
Correct.
We said that's one of the possibilities, is that correct?
Yes.
What are some of the other possibilities?
Could be impact during a fall. It could be coming in contact with any blunt object in the snow.
Would glass be a possibility as far as a blunt object?
It could be under certain circumstances.
piece of plastic under certain circumstances as far as a blunt object? Would that be also a possibility?
Correct, yes.
Now, as far as the abrasion near the laceration on the back of Mr. O'Keefe's head, you were asked some questions about whether or not that could be from drag, correct?
Correct.
Now, as far as injuries or abrasions concerning dragging, would it be typical to see just one isolated abrasion in the area of a laceration?
Not typical, but possible.
Could that also be a result of the blunt impacts or, as one of the possibilities you testified before, from hitting the ground?
Yes.
Now, you were asked about hitting the ground and specifically hitting concrete. Would that impact injuries to the back of Mr. O'Keefe's head also be consistent with striking his head on frozen ground?
I'm sorry.
No, I'll allow it.
Can you repeat the question?
You were asked a question on cross-examination about the laceration and abrasion to the back of Mr. O'Keefe's head being consistent with striking his head on concrete, correct?
Yes.
Would
I
that
don't know,
also
we
be
have a
consistent with striking his head
Foundation
on
that the
frozen
ground was frozen.
Could be, yes.
Very just starting to stick.
You were asked about certain wounds as being a possibility of defensive wounds. What are some of the other types of defensive wounds that you would expect to see that you did not see in this case?
Like maybe a bunch of lacerations on your
I
arm.
would expect to see, or I have seen, multiple bruising to the, again, posterior aspects of the forearms. I have seen cuts, lacerations, depending on how a person might be defending themselves, the position of their arms.
And would that also includes breaks in the fingernails and fractures to the hands?
Objection.
Watch the form, Mr. Lally, sustained.
What, if anything else, would that include?
It might include bruising to the knuckles. It might include broken fingers.
Now, with reference to the injuries that you were asked about with respect to Mr. O'Keefe's right hand, would those also be consistent with impact from a blunt object as well?
They are blunt impact injuries, yes.
Now, again, if I could, just with reference to, you were asked about different possibilities with the skull fractures and bleeding in the brain. What is your opinion as to sort of how that was caused and sort of, if you could again just go through
Again,
your opinion as to the head injuries, the skull
That's,
fracture, and bleeding?
that's an objection. Asked and answered.
Ask it again, Mr. Lally, in a different way.
You were asked about some possibilities. What is your opinion as to how those injuries were sustained or manifested in this room?
I don't know how they came to be. I described them and I stated previously that they are consistent with a fall to the back of the head.
And so I'm sorry, Doctor. My question is more geared towards as far as the single impact to the back of the skull and then sort of radiating fractures in the skull. If you could explain that in reference to the subdural hemorrhage, subarachnoid hemorrhage, and the ecchymoses that you're observing.
Again, a single impact with a fall could cause all the injuries that were seen in the brain and the skull.
Thank you. I'm not.
No further questions.
All right, doctor, you are all set. Thank you very much.
You are all set. Magic words, please. We're all on the edge of our seat. I'm on the edge of my seat, ready to explode. Enjoy.
All right, Mr. Lally.
Thank you, Your Honor. Commonwealth rests.
Yes! Yes!
All right.
Your Honor, the defense would move the court for,
So I'm going to stop you right there. A short recess.
if the court needs one.
I don't need one, but I will see you at sidebar.
She's going to handle the motion to dismiss at sidebar. Not even going to excuse the jury to do it. Karen's in her lovely white blouse. It's the kind of thing that, is good to wear if you're going to testify. Please, please, please. Jackson is ready. I don't need time because she's going to summarily deny the motion. We already know. I gave you my case for the Commonwealth at the start of the show. Didn't even get to the taillight and how they were able to find all the pieces and carefully reconstruct them and so on and so forth. Find the little shards of taillight pieces in his clothing when they carefully vacuumed his clothing at the lab. It's going to be enough. It's going to be enough to overcome this type of motion because you don't weigh the defense case in this type of motion. You don't weigh the problems with the evidence. You just weigh the upsides of it. Oh no, now they are going to let the jury out. He wants to make a record. "29 days in, and that's where the Commonwealth decides to leave it." Oh, what? We're having an actual full recess now? Okay. Well, we're not going to stare at the fan. 29 days in, and that's where they decide to leave it. Yeah, it's consistent with a lot of these different things. She was doing good there. That could be a punch, right? That could be, and people can get punched and passed out and fall back. It's good because it's medical and you're making it clear that it's medical, but it's also common sense. Anybody that is on the jury that has watched a boxing match, they've seen a knockout. Yeah, they've seen that this kind of thing can happen. Oh man. So glorious. The Commonwealth rests. Finally they're done. I would have liked a little more about the blood. I hate to harp on this. I really do, but it's not consistent with what we've seen. We've seen at the scene that there was enough blood to be dripping. That the conditions were not such that he died instantly and his heart stopped, so he didn't bleed. The conditions were cold, and so the blood thickened, and so he didn't bleed. No, he bled. There's evidence that he bled. So why did he only bleed a little bit? It just doesn't make a lot of sense, because that back of the head, there should be blood all over that snow. And I mean, again, you talk about blood is warm. Blood is your body temperature coming out of your body. It's going to melt that snow. So I don't know. I'm just saying, me personally, I would expect to see more of that. Maybe the biomechanical guy is going to get into that. Oh, I really, maybe it's enough, but this is Bev. You can't just take these kinds of things on faith that she is going to accept that door was opened for biomechanical testimony just because the MD said, I can't answer these kinds of questions about the amount of force it would take to cause this kind of a skull injury. I really needed that fleshed out, just in terms of injury analysis and reconstruction in general. Really make it clear what the difference is between these two types of expertise, because that's the only way we're going to have a good record of the limit of what the MDs can even say anyway. Bev is saying all this stuff has to come from an MD, and the MD is saying, I can't give you that. It's beyond my abilities. So I really would have liked a better record for that, because we know if the door is not kicked wide open, she's not going to let it go. And I'm just not sure that one response to that one question about the force to cause the skull fracture is going to be enough to kick that door open. Well, we'll see. Let's look at some of your questions and comments, guys. James Brown, good morning. Like a kid at Christmas today, the day we open the presents. Good morning. And a repeat, like a kid at Christmas today, the day we open the presents. Well, good morning to you too, Mr. Brown. Good to see you back. Welcome back. It does feel a little bit like Christmas, doesn't it? Dude McGuy, morning, Andrea. Longtime EDB fan here. Me too. I love me some EDB. That girl is fabulous. Your coverage of this trial has been stellar. Thank you. Well, thank you. Appreciate you joining us here. Yeah, I'm a big fan of some Emily D. Baker myself. John Duncan, love watching the trial with you, Andrea. Your comments are wise and measured and always keep me thinking outside the square. Thank you, Jeff, for moderating. Much love from a hermit in Tasmania to you both. Well, thank you and welcome. What a exciting place to be calling in from. My goodness. We got people from all over the world here in this chat. It's just amazing to see. Pine Rider, holy cow, an 11.5-hour live stream yesterday with only a brief break. Hopefully you are still getting your exercise time. Thanks, Andrea and Jeff. I'm not at my normal pace. I've not been making it to the gym like I normally make it. Tomorrow I'll get back to boxing. Can't wait. Really looking forward to it. Yeah, man, it's a lot of sitting, but we do what we got to do. We're in the final stretch here. This trial is a bit of a marathon, but we've made it. We're getting there. David Yanetti, I saw that he said on the way out of the courthouse yesterday that he's not expecting they'll need all 5 days next week. So even though Judge Cannone has set it up for us to have full days every day next week, he doesn't think we're going to need them. So yeah, we're getting our rest time, but yeah, I go out, I mess around in the yard, I play with the dogs, I do some yard work, things like that. So don't just literally sit and then sit some more. Pure Jealousy is a YouTube member now. Welcome to the crew. Thanks so much for joining. Automata, what up, all my fellow whack jobs? Yeah, we're all whack jobs in here. If we got opinions as women, I think we're probably whack jobs. John Duncan gifted some memberships. Thank you, sir. Appreciate that. Coffee Cake, this is the Commonwealth's opening statement. Well, that's what I would have given if I were the Commonwealth. I would not have given this, you'll hear from witnesses. I will not spew a bunch of names at you and tell you that they'll tell you about your observations. That's not what you do. No, you tell them the conclusion. You tell them where they're going to land after they see all of this evidence, and then you explain what it is in the evidence that's going to get them there. That's how you do an opening. So, yeah, that's how I would have done it, but I am definitely not Mr. Lally. John Beattybot, plow comment is admitted or alleged? Oh, it's alleged in the sense that Carrie Roberts said she said it, and she hasn't responded. She hasn't been on the stand. If she's on the stand, maybe they'll ask her about it. But at this point, it's a piece of evidence that's in from the testimony, and you decide how much weight you want to give that or not. Solo YOLO, please do verdict watch. Love your coverage. Oh yeah, we're gonna be here. We're gonna be here. It's hard to kind of get out of your own perspective sometimes and see things from the other side. That's part of why I wanted to do that steel manning of the Commonwealth's case this morning, to try to put myself back in that perspective of I'm looking at this from the perspective of somebody who is trying to convict Karen on this evidence. And so what am I focusing on? What am I looking at? And at the same time, just being aware, what do I have to disregard to get there? Because I do want to understand how the jury is perceiving all of this. And the jury is not me. They have their own perspectives. They might be coming at this from all kinds of different ways. So trying to understand the different ways they could be evaluating all of this, to get a sense of where are they likely to land, and then based on that, how fast are they likely to get there? How fast are they likely to get there? To me, the problems here are just so evident. They are legion. The problems are legion. Just so many issues, starting with the very basic timeline. that's just all over the place. It's all messed up. Now that she's back at John's house at 12:36, how does any of this happen? It just really doesn't add up. And so I have to think, yeah, the jury is going to be aware of these types of problems themselves. You know, I'm not some super genius over here. I'm just a person watching, paying attention to what I'm seeing, and I have questions. I shouldn't have. So I don't want to project too much of myself and my own thinking on the jury and assume, oh, it's going to be super fast. Like, it's not going to take them any time at all. I definitely think that's possible. Definitely think it's possible. This could be a very quick turnaround. But it's just hard to say because you don't know who's in there. And I've said before, when the lawyers talk to the jurors after a verdict, after the case is done, and get their perspective on it and what was important to them, what was like the turning point, what were the key pieces of evidence, it's shocking sometimes how it has nothing to do with what I would have thought it was. You know, what the lawyer thinks is important does not always line up with what the jury thinks is important. So the jury could be going, those text messages from Karen, those were the most significant thing to me. Those had the biggest weight in my mind. Those made the biggest impact. And boy, the way Lally presented those, if we get a chance on the lunch break, I'm going to pull up Sleuthy Goosey. I called her out yesterday because she's freaking fabulous, okay, with all of the documents and evidence. She is the receipts girl, and she keeps it organized and makes sense out of it. Just absolutely top notch. In terms of archiving so much of this information. She's got the full exhibit. It's got all of the texts in it, not just the ones that Mr. Lally decided to read out in court. So that's all going to go to the jury. There's no guarantee they're going to read it. But boy, very interesting when you look at that to see what Mr. Lally chose to present and what he chose to just kind of skip over, not mention, not highlight. So we get a chance at the lunch break. We'll take a look at that. Millie Martinez. Andrea, is AJ the lead on the defense team? He seems to be doing most of the witnesses, although Yanetti was her lawyer first, right? Great coverage. Yeah, Yanetti was her lawyer first, and he's now the sponsoring lawyer. Alan Jackson isn't licensed in Massachusetts. Elizabeth Little works for him. They work in the same firm. So they're in what's called pro hac vice admission. It's basically a temporary, limited kind of admission to the state bar without having to go through the whole bar exam and character and fitness evaluation and all that stuff. But you have to have somebody who is licensed in the state that's kind of like the official person still for record. They still have to sign all the documents. They're ostensibly responsible for you and making sure that you follow the rules of the court, the procedures, the ethical requirements, and so forth. Not that there's typically a whole lot of variation between states, but there can be differences, and those differences can be important. So that's my impression of where we're at right now. Yeah, Mr. Jackson is basically the lead attorney. He's making the decisions about the order and manner of presentation. He's allocating the workload and things like that. Mr. Yanetti is support. He's like the second chair in the case, clearly handling a lot of the evidence himself. Potentially things where he was involved in investigating that before Mr. Jackson came on board. I can't say 100%, but just I remember that was an impression I got early on in the case when I'm trying to figure out, why is Mr. Jackson handling some of these? Why is Mr. Yanetti handling some of these? So that is one possibility, because he was on the case before. He had involvement in talking to people, looking at things. For example, he seems to be the one that is coordinating with Lucky Loughran. He did that part of the investigation early on. So, but he is still, it's important for him to be there. He's the supervisor. He would be the sort of technical one in charge if you're looking at it from that authority standpoint. But from a practical standpoint of who is really running the trial, it does look to me like it's Mr. Jackson. John Duncan, loved your comments yesterday, Andrea, about the defense calling Karen first. So dangerous. But yes, I would love to see that happen. But they're so far ahead, she really doesn't need to testify. I know. And the common wisdom would be don't call her. That's the common wisdom. You don't need to. There's big potential for downside that it could go wrong. She could get mad on the stand. There could be things that she can't explain very well. She could come off as evasive or deceptive or something like that. I know there's a lot of risks. I just think there's more to the equation than just that. First off, I'm not really convinced that the risks are that high. How bad can she be? Can she come off worse than Jen McCabe? Is she going to come off worse than Jen? That seems unlikely to me. We already have that bar that's kind of set there. I really do think there is an important role for her to testify that is more than just the function of this trial and the persuading the jury and stuff like that. It is about the therapeutic process. Her being able to stand up for herself and say, metaphorically, all of you that have framed me and that have set me up and that have accused me and smeared me, give him a little finger. Give him a little finger. There's something very, very empowering and healing about a good FU at the right time. I can't overlook that. I really can't. To me, it is. I represent a client. And so the client matters to me. The person matters to me, and what is going to be best for that person. I'm going to be taking that into account. And we're going to be talking about that when we're evaluating this decision. Are you going to testify? Or are you not going to testify? The importance to them of being able to be heard. I can't overstate how meaningful that can be for a lot of people. And I just have rarely seen it backfire. Honestly, even with people that I thought, like, they're going to bomb. This is going to be terrible. I remember one guy, man, like, I can count on one hand the number of clients I sincerely did not like. Like, I'm pretty good at liking people. It's one of those skills I think that plays in well to being a public defender. I can like almost anybody. This guy, no, awful in so many ways. And I just did not have a lot of faith in how he was going to come across on the stand, but he wanted to testify, so we put him on. He even admitted, basically, to one of the crimes on the stand, but he still got acquitted of a bunch of other stuff. He did not come across nearly as badly as I thought he might. So I tend to think jurors are pretty forgiving about that type of stuff. They're not necessarily there to hold your flaws against you. They just want to see you as the whole person that you are and get a read on you because of that. So I just don't know that there's that many downsides here. I really don't. And the other point I'll come back to that I said yesterday, that one of the upsides about doing it first, it's a power move. Okay. Power move, primacy and recency right out of the gate. We're putting her on the stand. Yeah. We're not afraid at all. And they're going to remember the direct. The jury is already kind of conditioned to go to sleep when Mr. Lally stands up and goes to that podium. So that's not the cross is not going to be the first impression that they get of Karen. They will already have the entire direct examination to get an impression of Karen. But even if then Mr. Lally is able to do some damage to her, somehow she comes out of that exchange looking worse than him, well, they still have their whole defense case to make up for it. You know, you got a lot of opportunity to go ahead and bury that with proof that, look, even if she isn't likable, even if she does drink too much, even if she, shouldn't have done what she did with Higgins, whatever criticisms we want to throw at her, she still couldn't have hit him with the car. Because here's the biomechanical guys that are going to say, it didn't happen. So that's my thoughts on it. I really would love to see it. I just think it would be fantastic. What a move. Kyle Cowden, central IVs are like EJ and similar, no hands, arms. Yeah, so they went back and covered that, the intraosseal into the tibias and then into the femoral artery when he's in the hospital. What if any side quest are we sort of on? The IV could have blown. Hands are a hard place to get one in successfully, especially in a coding patient. I always go for the AC unless IO kit is near. So yeah, just more of the same. You wouldn't necessarily expect people to be trying to place the IV in the hand where that particular injury is. Alyssa Ramirez, would jury find Little's nerves endearing or does it hurt the defense? It's going to depend on the juror. It's really going to depend on the juror. I can just see different personalities reacting to her very differently. People who are agreeable and tend to like, people that they encounter are going to be forgiving. They might think, yeah, she's kind of sweet. She's kind of cute. She's got a high-pitched voice. The polar opposite of Mr. Yanetti in terms of projected aggression. She does not come across as aggressive even when she's asking hard questions. Nothing mean about her. Other people could hold that against her. She looks like a kid in the courtroom, or just something judgmental like that. You just never know. You never know. It's really going to depend. It's really going to depend on the individual jurors. John Duncan, why do you think defense counsel went with Ms. Little on this cross as opposed to Jackson or Yanetti? The best explanation I have is just that their allocation, their division of the workload here, they have given her the experts. That's been who she's handled. That's been what she's prepared for. That is a pretty good assignment for the person on the team who has the least amount of trial experience, because the experts can be dangerous, don't get me wrong, but the experts tend to be pretty predictable. You know what they relied on, you know what opinions they formed. You have your own experts that you've been able to consult with about, what are the weaknesses in this expert's conclusions, and are there ways that we can poke at that? Are there things that we can bring up? They're easy to plan for. And so you don't necessarily have to be so able to react on the fly like you might have to be with a more hostile kind of fact witness, or even these police officers who are super slippery and don't want to be pinned down. Experts love to have opinions. That's why they're there. That's what they're paid for. They love to have opinions. They're not typically going to slip and slide around getting pinned down on what they think. It's very, very different with the police officers who are just naturally suspicious of anything that the defense attorney is saying, no matter how reasonable it is. They don't want those words put in their mouth. All right, so we are back now. Let's get the sound
Today you
on.
told me you would like 10 minutes for your argument. I'll hear you now.
All right, here we are going to get it. Motion to dismiss.
Your Honor, I'll be brief. The court must consider, after viewing the evidence in light most favorable to the Commonwealth, whether a rational jury could find the elements of the charges beyond a reasonable doubt. And here, the case that the Commonwealth has submitted to the jury after resting is insufficient to meet such a finding. There's no question but that with this particular prosecution in this particular case, no reasonable or rational jury could come to a unanimous verdict in favor of the Commonwealth. I want to, if I can, focus my argument on count 1, 2, and 3 and a specific element of each count.
Okay.
In each one of those counts, there must be evidence that the vehicle killed John O'Keefe. There has been no competent evidence presented in the Commonwealth's case that Karen Reed's vehicle actually struck John O'Keefe. There's been conjecture, there's been speculation, but no actual competent evidence. The Commonwealth's entire case relies on a theory built on the shoulders of a trooper named Joe Paul, who testified a couple of days ago. And his theory, according to the Commonwealth, is that John O'Keefe's arm was struck, he was spun around in sort of a pirouette, he was projected 30 feet to the left, hit his head on a curb or the road in the intervening time before coming to a final rest spot about 30 feet away. Everything in the Commonwealth's case, everything relies on that theory. that theory of damage to the taillight at the scene. If a rational jury could not unanimously determine that Trooper Joe Paul's theory is true beyond a reasonable doubt, then we believe the motion has to be granted. There is no competent medical evidence to support that theory. There's no competent physical evidence that the taillight could break and shatter in the way that they've suggested, and that the arm would not have any breaks or shatters or any damage, any additional damage. There's no evidence how getting hit in the arm could actually launch a body 30 feet, as per the Commonwealth's theory. And there's no evidence how a body hit by a 7,000-pound SUV could sustain no injuries from the neck down, which we just heard this morning. The evidence before the court, the only evidence that is before the court, is that the Commonwealth's own medical examiner does not believe this is a homicide. And she went on this morning to say that in her expert opinion, the injuries are not classic pedestrian injuries. And they are, every single one of them, consistent with a physical altercation. Calling a witness to simply espouse an opinion like Trooper Paul did that belies science, common sense, or even logic, that's not enough to get the case to the jury. The light most favorable to the Commonwealth does not mean that the court must believe the Commonwealth's witnesses. What it means is that if there is a rational controversy in the evidence, the court must accept that evidence that favors the Commonwealth.
What's his walkout
But here, there is
song?
no rational controversy. As put or expressed in Commonwealth versus McCormick, it's a 2023 case
What should he
found at
walk
491
out
Mass 848.
I'm thinking No Sleep
Pinpoint
Till
site
Brooklyn.
860, quote, where the Commonwealth's evidence is entirely circumstantial, it cannot meet its burden if the evidence equally supports inconsistent propositions, as resolution of such a case necessarily
It
requires
did have a great beat.
conjecture or surmise.
I do
In
like
our
Bang
view,
Bang.
There is no question that there's no rational controversy related to the Commonwealth's theory. Trooper Paul's theory is by definition not rational. It's not reasonable. And it's basically based entirely on conjecture. And that's why, in our view, the court is required to find Ms. Reed not guilty of counts 1, 2, and 3. It's because each of the counts, as I said at the beginning, necessarily include an element that John O'Keefe was struck by Karen Reed's vehicle.
You guys got some good ones.
Thus, if a rational jury cannot reasonably believe Trooper Paul's theory, it's the only evidence presented by the Commonwealth describing how Mr. O'Keefe possibly could have been struck, then Ms. Reed is entitled to an acquittal. Nothing else matters. Nothing
like
else in the
this.
court's evaluation, nothing else in the jury's evaluation, nothing. Everything turns on whether or not the car hit John O'Keefe. And the Commonwealth's only theory of how that happened is from Trooper Paul's description. If the court were to deny this motion, then by doing so tacitly, the court is expressly endorsing Trooper Paul's theory of how John O'Keefe was struck, and we don't believe that that's rational. We don't believe that any rational jury would ever unanimously agree with Trooper Paul, and thus we ask the court to find Ms. Reed not guilty at this time.
Okay.
I'll submit.
Your Honor, if I may just, we have a written motion for the court to act on pursuant to that argument. May I hand it to you first? And I can copy it.
All right, I will hear you,
Oof.
Mr. Lally.
Yes, Your Honor. Surprisingly, I would disagree with counsel's
So let's leave the comments out.
Your Honor, as far as the comments, all I was going to say is that I would submit to the court that,
Is this surprisingly that I took issue?
and my apologies for that. What I would submit to the court, Your Honor, is that this case does not rest and fall with the testimony of Trooper Paul. Trooper Paul's testimony, while important when taken in conjunction with the remainder of all of the other witnesses and all of the other testimony that the court has heard, I don't want to minimize it, but at the same time, that is not the only evidence that the vehicle struck Mr. O'Keefe or interacted with Mr. O'Keefe. So what the court has, as far as the physical evidence, next to Mr. O'Keefe's body, one sneaker in the location of the curb, the glass, the drinking glass that Mr. O'Keefe is seen walking out of the Waterfall Bar at approximately 12:11 a.m. with, that is in the vicinity, the direct vicinity where the Canton police officers actually recover it early in the morning of January 29th. You have the microscopic pieces of the defendant's taillight, which was testified by Ms. Hanley to be consistent with pieces of the taillight from the defendant's vehicle that are within or embedded within Mr. O'Keefe's clothing. You have the remainder of the pieces of taillight, and this part is important in relation to Trooper Paul's testimony as far as the linear momentum, and it's all in the same sort of direction.
Good point.
And path of all of the roadway evidence that he observed that's discovered in and around the area where Mr. O'Keefe's body was. The testimony from Ms. Mixlear, with reference to all of those taillight pieces and how they were able to reconstruct from the pieces that were found on the ground and then put back together, matching not only to that, but the taillight housing from the defendant's vehicle. The taillight housing from the defendant's vehicle, which has the victim's, Mr. O'Keefe's DNA contained on it, as well as the mitochondrial DNA testing of the hair that was on the rear right quarter panel of the defendant's vehicle, which also was matched or consistent with that of Mr. O'Keefe, his mitochondrial DNA, as well as report heard from Ms. Chart from Bodie Technology.
Some dropkick Murphys would
You
be
have the
fantastic.
plethora of testimony from the various civilian witnesses from that particular night. You have the evidence of motive from the text communications, as well as the testimony of the children in this case as to the state of their relationship from the defendant's own mouth in those text communications and in those voicemails as to the state of their relationship. You have the testimony in regard to Mr. O'Keefe and his
So many
recounting
good
of the
songs
state of their
here.
relationship and his numerous attempts to break it off with Ms. Reed prior to that day. There are arguments that continued throughout the afternoon of the 28th and seemingly into the 29th. You have the defendant's own statements that I hit him, that come from multiple sources, including firefighter Nuttall, firefighter
There it is.
Monty,
I hit him, I
firefighter
hit him, I
Laughlin,
hit
Ms.
him.
McCabe. You have her statements to the paramedics in the back of the ambulance that the last time that she saw Mr. O'Keefe, they had gotten into an argument. You have the testimony in regard to Ms. Roberts and Ms. McCabe as far as the altercation or the verbal argument stemming from Ms. McCabe's reference of Bella's mother.
Another good one here.
Being
Some Lemmy.
A landmark, being someone
Yeah,
Mr.
I like those
O'Keefe, used
vibes.
to date just prior to that argument occurring in front of the house at 34 Fairview Road. With each and every piece of evidence that was presented throughout the course of the Commonwealth's case, including the forensic evidence.
We need like a
including
playlist
especially,
from the chat.
one thing I would stress for the court is taking not only Trooper Paul's testimony, but
This would
Trooper
be like
Paul's
the most
testimony
badass
in
playlist
juxtaposition
ever.
to Trooper Garino's testimony as far as the vehicle or the native GPS locations of
The
Mr. O'Keefe's
circus
phone
theme.
in reference to the timing and in particular the information or data from the Toyota text stream. Trooper Garino's GPS native location of Mr. O'Keefe's phone has that reversal, the same 3-point turn that Trooper Paul testified
We're
about.
not gonna
for
take
8
it.
minutes prior to the vehicle traveling 24.2 miles per hour for approximately 62 feet in
Yeah,
a straight
for
line in
AC/DC,
reverse.
good one.
And as far as the testimony and the evidence that the court has before it, the court also has those backup testing videos that Trooper Paul conducted with the defendant's vehicle, so the court can see exactly what that vehicle looks like at approximately 25 miles per hour in reverse in a straight line. And what I would submit, Your Honor, is that there's more than sufficient evidence from a medical perspective, from a forensic perspective, from a civilian witness perspective, and from the investigation of this case as to all 3 indictments that the Commonwealth has met its burden, particularly under the standard before the court at this time. And for those reasons, I would request that the defendant's motion be denied.
Okay.
Well, that was fun.
In the light most favorable to the Commonwealth under the prevailing Lattimore standard here in Massachusetts, I am satisfied the Commonwealth has met its burden. The defendant's motion is denied. So, Mr. Yanetti, are you calling your first witness?
Yes, Your Honor.
Okay, so let's bring the jurors in, please.
Yep, exactly what we knew it was going to be. I still feel like I gave a better summation of the case than Mr. Lally did, but that's You know, I'm just a little biased. Exactly what we knew what was going to happen. Ooh, another good one right here. Just a couple more. We should make a nice playlist from this chat. Send it to Mr. Jackson. Here's your walkout songs. Ooh, some Aussie. Not a bad one. Truckin', I'm thinking more a little steal your face right off your head.
All right,
He's gone. Nothing going to bring him back.
Thank you. This court is back in session. Please be seated.
All right, so jurors, if you remember in my preliminary instructions to you a long time ago now, I stressed to you that the burden of proof rests with the Commonwealth. The defendant has no burden of proof whatsoever, doesn't ever have to testify or present any evidence. So the Commonwealth has completed its case, the Commonwealth has rested, and I want you to keep in mind that the defendant has no burden of proof. Ms. Yanetti, do you have a witness for us?
Thank you very much, Your Honor. The defense calls Brian Laughlin.
Okay.
We're going to start right with Lucky Loughran.
He is. I just stepped on him.
Do you solemnly swear the evidence you give the court and jury in the case now and here and speak the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you.
May I proceed, Your Honor?
Yes.
Good morning, sir. In a good loud voice, would you state your name and spell your last name?
Sure, it's Brian Loughran. It's Loughran.
And where are you from,
Mr.
sir?
Loughran, I'm going to ask you to keep your voice up as loud as you can, sir.
Sorry.
That's okay.
Maybe put your mouth as close to the mic as you can. Where did you grow up, sir?
Canton, Mass.
Is that where you live?
Yes.
How long have you lived there?
Both 35, 36 years.
And did you go to Canton Public Schools?
Yes.
Now, in the course of living in Canton, were you familiar with the Albert family?
Yes.
Which members of the Albert family were you familiar with?
All of them.
And when you say all of them, can you name the ones that you were familiar with?
I was familiar with Brian,
Brian Albert?
Chris Albert, Brendan Albert, Kevin Albert, and I believe Kathy Albert is the sister, but I'm not 100% sure on her first name.
Okay, and those are the siblings that you had contact with and were familiar with?
Yes.
Did you know some better than others?
Yes.
Whom did you know the best?
Chris Albert.
What is the age difference between you and Chris Albert?
I believe we're the same age.
Did you graduate high school with him?
He went to a different high school, but yes,
Graduated at the same time?
correct.
And with regard to your familiarity with Chris Albert, can you explain to the jury how you became familiar with him and what your relationship with him has been?
I went to school with him, elementary school. We went to middle school, then he transferred to a Catholic school. Then later in years, I began to work for Chris for D&E Pizza, delivering pizzas.
Okay. And approximately what ages were you when you were delivering pizzas for D&E Pizza and
Knew
Chris
him
Albert?
pretty well.
I was 25, 26 years old.
And how many years did you deliver pizzas for him?
Up until I got married, 35,
So several years.
8 years.
8 years, okay. And with regard to your interactions or knowledge of Kevin Albert, can you describe that?
Kevin Albert would be through D&E Pizza if he came in. Through the police department, would see him on details.
All right. And were you friendly with him?
Yes.
With regard to Brian Albert, could you describe your interactions or your relationship with him?
Again, through D&E Pizzas, delivering pizzas to his house. Cordial, polite, would say hello.
All right. So you're friendly with the Albert family?
Correct.
Now, back in January of 2022, where were you working?
I was working for the town of Canton.
In what department?
I was working in the sewer department.
Is that also called the water department?
Yes, water and sewer are combined.
And under what heading is that? The
The
water.
DPW.
It's under the DPW, the Department of Public Works.
Correct.
Now, back in January of 2022, were you one of the regular snow plowers for the town of Canton?
Yes.
And directing your attention to January 28th of 2022, do you remember that day?
Yes.
What do you remember about that day, the 28th?
It was a potential blizzard. We had been given a start time.
All right, and when you say you had been given a start time, what does that mean?
It means that we're expected to be in our trucks at a certain time on our route.
Okay. And who gives those instructions back in January of 2022?
The supervisor for Canton DPW,
And who was that at the time?
William Walsh.
Also known as Billy Walsh?
Yes.
Now, when were you called in to do plowing that evening or early morning?
We were told to be in by 2:30
And is that 2:30 a.m. or p.m.?
a.m.
Would that now be on January 29th?
Correct.
What time did you arrive at the DPW that early morning?
About 2:15.
When you got there, what did you need to do in order to go out plowing?
I needed to get into my truck and get that prepared to go out.
All right, and your truck, is there one that's specifically assigned to you when you plow?
Yes.
And does that truck have any particular nickname?
Yes, it's called the Franken truck.
The
And why is it
Franken
called
truck.
the Franken truck?
It is a truck that has a lot of different parts than what it's required. It's not parts that were made for that specific truck.
It's been modded.
An older one?
Yes, it was a
Modded
truck
into a
that was very
monstrosity.
uncomfortable at the beginning to use, so they try to make it as comfortable as possible.
All right. And that particular truck, is it used for anything else other than snow plowing?
Yes, it's used for everyday use.
Okay. Now, so you get to the DPW at 2:15, you say that you get your truck ready. What does that entail to get your truck ready, and how long does it take?
It takes about 5 minutes, but just basically you need to make sure that it's got enough gas in it so we're not going to the route and running out of diesel fuel, which is not good. It's just basically going over the truck, making sure, you know, you have everything you need for that night
And do you plow alone or with someone?
by myself.
Now, with regard to the visibility in your snowplow Franken truck, can you describe that for the jury, what you can see, what you can't see?
So the Franken truck has an air ride suspensions, an air ride seat. So the seat is raised so I can see over the hood.
Okay.
And I can see about 5 feet on either side of the passenger side, driver's side.
And when you say 5 feet, are you talking straight out from the?
From the windshield straight out.
All right. And what, if any, lighting do you have on Franken truck?
We have marking lights. We have 2 plow lights that are situated at the corners of the trucks, and it's up high. It illuminates very well. It's very well seen.
Okay. And with the extra set of lighting that you just described, how far can you see off to the sides, in front of you, and directly in front of you?
Probably 5 feet on the sides.
Well, you already testified to that, 5 feet straight out.
Yeah.
But what about the sides going forward?
It's you know, it's hard to decide to put into words, but I can see a real long distance. That visibility is fine. You know, it is extremely. If you gave me probably 5, 10 feet, 15 feet out, maybe even further.
Okay. And with regard to the lighting, how much light does that give off?
Enormous amounts. It's almost driving with the spotlight.
And with regard to the air ride seats, what action did you take with those that particular night?
I raised it so that the bottom of my knees would hit the steering wheel.
And what, if any, obstructions, I should say, were in front of you that would prevent you from seeing what's in front of you or to the side?
Nothing.
All right. Now, do you have a specific route assigned to you?
Yes, I do.
Could you describe that route? And by the way, that specific route, was that the one that you were assigned on January 29th?
Correct.
Could you describe that for the jury?
Yes, it's a route that consists of Cedar Crest from Kings Road to Chapman Street and everything in between. There are a lot of streets I could name if you would like, but Fairview is one, Spring Lane is one, Cedar Crest, Kings Road. Those are pretty important roads that I would consider major roads on my route.
All right. Now, that particular night, if you got there at 2:15, what time do you think you were on the road by in Franken truck?
I was on Cedar Crest about 2:30, 2:35.
Now, with regard to Cedar Crest, I would like to show you a
Very
map if I
likable.
can. May I approach, Your Honor?
Yes.
You don't get any deception from this guy at all.
I've handed you a document. If you could just review that to yourself and then look up at me when you're done. Do you recognize what's depicted on that?
Yes,
What is it?
it is my plow route and consisting of streets that I plow.
All right. And to be fair, that's a portion of your plow route, right?
Correct.
There are other areas of the city that you plow?
This actually depicts my actual physical route.
Oh, okay, great. And that's a fair and accurate representation of the streets as they existed back in January of 2022?
Yes.
I would offer that, Your Honor.
Any objections to that?
No, Your Honor.
Okay.
Thank you. And could I have permission to publish before the jury?
Sure.
Okay. Now, you just testified that you got to Cedar Crest, I believe you said 2:30 to 2:35 or so?
Correct.
All right, as we look at this exhibit on the screen, are you going from right to left or left to right on Cedar Crest when you first approach Fairview?
Right to left.
Okay, so you're going sort of from the upper right-hand corner of the diagram down Cedar Crest toward Fairview. Is that accurate?
Yes.
Could you take the laser pointer and just confirm that route for the jury? That's, okay. You see that's Fairview Road? Are you able to read that writing?
I'm not, to be honest with you. I'm sorry.
Do you still have that map in front of you? Maybe that'll help you, Mr. Moore.
And actually, can I orient it so it's oriented just like that for him? Okay, that's how it's up on the screen.
Okay.
And by the way, I should have asked this, but is it in terms of is it, you can't read the writing or you can't really see the outline of the streets?
Both.
Okay. Well, that's not going to help much. Okay. If we can have the lights back on. With the court's permission, can I leave that
The jury
up on the
likes
screen
him.
while I ask a few more questions?
Everybody laughed.
Sure, except he said he can't see it.
Right, no, I know, but the jury can, so I think it would be helpful for them. All right, so you're coming down Cedar Crest, and would Fairview be on your left or your right when you first approach it?
When I first approach, it's on my left.
All right, now, do you take that left at that time?
No, I do not.
Why not?
At the time, I'm pushing snow, and we don't want to block any part of the road with snow, and taking a left would have left a row of snow. So I proceed to the end of Cedar Crest, do a cul-de-sac, and then head back up Cedar Crest.
All right, so there's a cul-de-sac at the end of Cedar Crest.
Correct.
Dead end.
Yes.
And you plow that?
Yes.
All right, so then when you come back up, is Fairview on your right or your left?
It is on my right.
What do you do?
I take that right and continue to plow.
Now, are you familiar with the Albert residence on Fairview Road?
Yes.
How did you become familiar with that?
Growing up in Canton, I knew where they lived.
Can I have Exhibit 66 displayed with the court's permission?
Yes.
From where you're seated now, Mr. Walker, are you able to see what's on the screen?
Yes.
And do you recognize that?
Yes.
What do you recognize that to be?
That is the Albert house, Brian Albert's.
And when you were passing the Albert home on Fairview, the very first time you passed it, would it have been on your right or your left?
It would have been on my right.
What section of the road were you plowing at that point?
The middle of the road.
Why is that?
I start in the middle and I angle right with the plow.
Now, I want to direct your attention to when you were, your truck was essentially perpendicular to the driveway. You see the driveway in Exhibit 66?
Yes, I do.
When you were perpendicular to the driveway, where were your headlights pointed?
In front of me, in front of the truck,
I'm sorry?
in front of the truck.
And what were you able to see of the front lawn of the Albert residence that very first time you passed?
I was able to see the entire front lawn.
And about what time was it that you first passed 34 Fairview Road?
About 2:45.
Now, as you continued along past the driveway, did you continue to have all of those headlights on in front of you?
Yes.
And as you continued along, what were you able to see of that front lawn? How much of it?
A very large portion, almost to the front steps.
And now, when you're plowing, where is your attention focused, sir?
My attention's focused in front of me and then to the sides.
Why would your attention be focused to the sides?
I am trying to be aware of any side traffic, any pedestrians, and God forbid, any animals.
And when you were passing the Albert residence, as you pass every home, what attention do you pay to the sides of the road and the lawns that are adjacent to the road?
I'm, again, making sure that there are no animals, no pedestrians, and making sure no one's coming out of their driveways, not expecting to see me.
And with regard to Exhibit 66, do you see the flagpole there?
Yes,
Is that something you had seen previously?
yes.
And when you made that first pass by that residence at 2:45 in the morning, sir, with your headlights on, what, if anything, did you see on the front lawn in the area of the flagpole?
I saw nothing.
If there had been a 6'2", 200-pound man lying in the snow there, would you have seen it?
Objection.
Sustained.
Do you think you would have seen it?
Now, once you pass the residence, where do you go?
I go to the end of Fairview.
And what street does that intersect with?
That intersects with Chapman Street.
We have the previous exhibit put back up with the court's permission. Sure. Okay. Do you still have the exhibit oriented the same way, sir?
Yes, I do.
Where's Chapman Street on the exhibit? Down the bottom, the top, or which side?
Down the bottom.
Okay. And when you come to the end of Fairview with Cedar Crest in your rear now, right?
Correct.
Do you take a left or a right on Chapman?
I take a left
All right.
onto
And
Chapman.
once you take that left, what do you do?
I back up and then take a left to go back down Fairview.
Okay, so you're essentially doing almost a three-point turn in the road?
Correct.
All right. So now, do you go back down Fairview at that time?
Yes, I do.
And how far do you go down Fairview?
To the end, to Cedar Crest.
Now, at this point in time, you would also pass the Albert residence, correct?
Correct.
Would it be on your right or your left?
On my left.
Were you looking to the right and the left as you were coming down?
Yes.
How much light did your headlights illuminate of the Albert's front lawn as you were coming down from Chapman Street?
Coming down Chapman, just about the entire front lawn.
And again, with regard to that area around the flagpole, did you see anything on the lawn?
Nothing.
See a body?
No.
All right.
Nothing.
Now,
No.
after you've done these two passes, sir, where do you go?
I then take a right on the Cedar Crest. I proceed up Spring Lane, come down Spring Lane, and then do the remaining of my route.
All right. How long did it take you before you wound up back at Cedar Crest and Fairview?
About 45 minutes.
So I think you had previously testified you made the first pass around 2:45?
Correct.
So would that put us at about 3:30 when you're about to make the second pass?
Objection.
Sustained, ask it different.
Sure, I'm sorry. What time was it, to your best estimate, in terms of when you would have approached Fairview and Cedar Crest again?
3:15 to 3:30.
All right. Now, when you approach that intersection again, are you approaching it such that Fairview would be on your left or your right this time?
On my left.
Same as last time.
Correct.
What do you do when you approach Cedar Crest? I'm sorry, when you approach Fairview and it's on your left?
At that point, I have an option. I can go to the end of Cedar Crest, or I can turn around at a street, depending on how much snow I have on Fairview.
And with regard to the decision you made regarding that choice, what decision did you make on January 29th at 3?
Went all the way to the end.
Went all the way to the end of Cedar Crest.
Correct.
Same thing you did the first time.
Correct.
And then you come back up?
Correct.
Is Fairview on your right or your left at that time?
It would be on my right.
And did you take that right?
Yes, I did.
What, if anything, unusual did you see at that time?
At that point, I saw a Ford Edge on the side of the road
Where was it parked on the side of the road?
in front of the Albert's house,
Where in front of the Alberts house?
by the flagpole.
And why was that unusual?
The Alberts never had cars that were parked out front, and it just stuck out as weird.
Now, what were the snow conditions like at that point? This is now, I think you said about 3:15 to 3:30.
It's starting to accumulate a lot quicker than what it was previous.
And what policies does the DPW have regarding cars parked in the street during a blizzard where there's plowing to be done?
We are to notify the supervisor. At that point, he will make a phone call to the police, and depending on if they can have the resident move it, it gets moved. If not, it gets towed.
And with regard to that policy, did you comply with that policy in those early morning hours?
No, I did not,
Why?
because I was being courteous to the Albert family.
Now, once you saw the Ford Edge parked on the side of the road near that flagpole, what did you do?
I had to go around the vehicle and as to not hit the vehicle.
All right, and probably obvious, but as you're approaching the vehicle, was it faced in the same direction that you were traveling?
Yes,
And so you're going around to the left or the right of the vehicle?
left.
And once, as you were approaching that vehicle, were you able to see on the right side of that vehicle, but the lawn side?
Yes,
Did you see anything on the front lawn at that time?
Objection.
I'll allow it. Did you see anything?
no,
Lights were still on.
correct.
All right, now, once you pass the vehicle, did anything attract your attention at all?
No.
All right, where do you go?
I go up to the end of Fairview and do the same process, take a left on Chapman and back down Chapman and take a left into Fairview again.
Once you come back down Fairview, do you pass the Albert residence again?
Correct.
Was there, that car that you saw?
Correct.
It moved from when you passed it the first time?
No,
Were you able to see the front lawn of the Alberts in front of you? As you were coming down Fairview toward Cedar Crest?
not as much as the first time because the car blocked the view.
All right. Now, after that, how long did it take you before you came back to that area to plow again?
About 3 hours.
Do you recall about what time it was that you wound up back on Fairview?
I don't honestly recall what specific time.
Sure. Approximately, if it was 3:15 to 3:30, that second time, what would be your best estimate of the time when you came back?
I would say if I had to say, it would have been 5:30 up Fairview.
Okay.
And came back down, and then at that point, I wasn't able to go further than Carriage Lane.
Okay, and when you say that you went up Fairview and came back down, you initially went from which side of Fairview?
Right side.
What would that be, the right side? I'm sorry. Would it be the Cedar Crest side or the,
It would have been Cedar Crest side.
coming from Cedar Crest and then you went up Fairview, came back down?
Came back down. As I'm going up, I am actually seeing first responders. And at that point, as I'm coming back down, the road's blocked at that point.
Okay. And when the road was blocked, what, if any, plowing were you able to do after that on Fairview?
I was able to go as far as Carriage Lane and then turn around.
Okay. And then I imagine it was several hours before you could plow again?
Before I could plow Fairview to the end of Cedar Crest, yes.
All right. Now, I'd like to direct your attention to February 15th of 2022. were you approached by an investigator who wanted to ask you questions about what you had seen and done on January 29th of 2022? Do
Yes.
you remember his name?
Yes.
What is it?
Paul?
And what was your understanding about whom Paul worked for?
Objection.
Ask it differently.
On February 15th of 2022, were you ever approached by anybody in law enforcement, sir?
No.
So what was your understanding of Paul's job?
Objection.
I'll see Councilor Taiba.
What's wrong with this? We already heard about this from Mr. Trotta. Mr. Trotta talked about that was too Long Island. Trotta. I gotta remember where I am here. Mr. Trotta testified about how the proctor came and asked, and he showed him the plow schedule and everything. So we've already heard about the police being out there, and he talked about talking to the defense investigator. So what's the problem here? I'm having a real hard time imagining the issue here. I got Mr. Trotta's notes. I got them.
You are unmuted.
Right here in notebook number 4.
Just a couple questions, Mr. Loughran.
Sure.
At any point in 2022, were you ever approached by any police investigators, sir?
No.
When was the first time that you were approached by the state police in this case? Do you recall?
I don't recall the actual date, but I do know.
Year?
Yes.
What year was that?
2023.
And do you recall the name of the investigator that approached you?
Mike Proctor and Sergeant, and I can't pronounce his name. I don't want to.
If I said Buchanan, would that ring a bell?
Yes, it is.
He didn't want to say it because he didn't want to mispronounce it. What an extremely courteous person.
I have nothing further. Thank you, sir.
Okay. Mr. Lally?
Thank you, Your Honor. Good morning, sir.
Good morning.
Now, may I approach?
Yes.
So now we get to see how Lally is on cross with an eminently likable witness.
Sir, I'm showing you a document that's already been marked with Exhibit 109. Just ask you to look at that and look up whenever you're finished, okay?
Is it a former statement that he made or something? No, because it's already in evidence. So it's probably the plow schedule that Mr. Trotta brought in.
Yes.
Do you recognize that, sir?
Yes, I do.
And what do you recognize that, sir?
These are the plow routes for the town of Canton.
And there's different numbers that are associated with different routes and different drivers assigned to those routes, is that right?
Yes.
And if you look down at number 11, is that your route that you were talking about as far as for a portion of Cedar Crest neighborhood that you plow?
Yes.
And that's the route that you were assigned to on January 28th and January 29th of 2022, correct?
Yes.
Now, if I could ask, just as far as there's a certain way that you plow a route.
Yeah.
Excuse me. There's a certain way that you plow a road, correct?
Correct.
And when you're first plowing the road, you're sort of plowing the middle of the road, correct?
Correct.
And you do it in sort of a fashion that's referred to as ring road right, is that correct?
Yes.
Can you explain to the jury what that is and sort of why you're plowing a road in that particular fashion when you're first starting to get out there with the plow?
So ring road to the right refers to the snow coming off the plow. It actually leaves a row of snow. We ring road to the right to prevent cars from having to go through the ring road to the left. If you go to the left, you've now put the ring road in the middle of the left-hand lane. So everything's to the right.
So everything's to the right because if there was a vehicle coming the other way, you'd be plowing into that vehicle, is that correct?
Correct.
And your goal sort of when you're first getting out there to plow the roads is to sort of clear the middle of the roadway first, correct?
Correct.
So that's where your truck is when you first go out and plow the road, is you're sort of in the middle of the road near the double yellow line if there is one on that road?
Correct.
Okay. Now, this truck that you were driving, on that day, how long have you been assigned to that truck for plowing purposes?
I was assigned to that truck for probably 2 years, maybe longer.
Maybe longer. Were you driving that same truck in 2015?
No.
No? Okay, so you were driving a different truck at that point?
Correct.
Do you remember what kind of truck that was?
It was an F-550 utility truck, pickup truck.
Similar in size or shape to the truck that you were driving that day?
No.
Now,
Good try, Lily. Why? What happened in 2015?
you were asking questions about February 15th, 2022, and you spoke to some investigator on that day, correct?
February 15th?
Yes, 2022. That Paul person you were talking
Yes.
about? Okay. And you met him at a skating rink, is that right?
Correct.
And you said in a statement to him at that time that you would have seen a body on the front lawn or the sidewalk, is that right?
Correct.
Now, are you aware that there is no sidewalk on the same side of the street as 34 Fairview Road?
Correct.
Now, you mentioned some familiarity with the Alberts and with the Albert resident. Are there other people on that route that you're familiar with as far as where they live and who they are and all that?
Yes.
And how are you equally familiar with them, more familiar with them, or less familiar with them?
Equally.
Equally?
Yeah, Lily, that's what he said.
Now, familiarity with 34 Fairview Road, does that extend to sort of the lighting around that area?
No.
So do you know that there is actually no street lighting whatsoever in the area of the fire hydrant or the flagpole or anywhere there for several hundred feet?
Correct.
So you do know that?
I believe so, yes.
And so when you're driving by, you're looking for cars coming out of their driveway, cars coming in the opposite direction, people walking, is that correct?
Correct.
And you're trying to look for those objects so that you make sure that you don't strike them or hit them or anything like that, correct?
Correct.
So far,
And
we
on
have to
February
repeat all of
15th,
his
2022, when
testimony.
you had this meeting with
Style of
Paul, you told him
cross-examination.
about 3:30 or 4 a.m. Is when you saw this Ford Edge on Cedar Cliffs, correct?
Correct.
Now, in fact, when you first spoke to this individual named Paul, you didn't tell him it was a Ford Edge, correct?
No, told him it was a Ford Edge.
You didn't tell him first that it was a small SUV?
No, told him it was a Ford Edge.
Do you remember at any time Paul taking you on the parking lot and showing you different vehicles and asking you if those vehicles matched what vehicle you saw?
No. He wanted to make sure that what I was telling him was accurate. So he showed me what was a Ford Edge, but I had already told him it was a Ford Edge.
So he brought you out to the parking lot at the skating rink that you were meeting at, specifically showed you a Ford Edge and asked you if that was the vehicle.
Correct.
Now, do you know
But he
sort of the
already said it
difference
was.
between if you were to see a Ford Edge at nighttime in a snowstorm, the difference between a Ford Edge and a Jeep Cherokee?
Yes,
What's the difference?
the taillights in the back.
What about
Ford Edge is a more round. The whole back facade is a little bit more round. The Jeep Cherokee are more square.
Nice.
it? Now, what color was this SUV that you saw?
He knows his cars.
I can't tell you that. I am colorblind.
Can you tell, I'm just curious, sir, as far as your color blindness, can you tell whether or not an object is dark or light just by looking at it, or you can't tell at all?
I can see things that are light. I can see things that are dark. I can see true colors. I can't see shades of true colors.
And so from what you saw, was this light or dark?
Light.
Now, you told this Paul individual on February 15th that the SUV that you saw was exactly where Mr. O'Keefe's body was found, correct?
Correct.
How do you know where his body was found?
I told him specifically if he was looking at the door, the front door, it was about 3 feet to the left of the door. And with
To the left of the door?
looking at the front of the door to the left of the door, pushing it up Fairview.
So if he wrote in his report that you told him that the vehicle was exactly where the body was found, that would not be true?
Objection.
No, I'll allow that.
Could you repeat that question, please?
If he wrote in his report that you told him that the SUV was exactly where the body was found, that would not be true, would it not?
That would be true. The car was to the left of the door, putting it in front of the flagpole.
My question for you, sir, is how do you know where Mr. O'Keefe's body was found? At any point in time, did you see Mr. O'Keefe's body on the front lawn?
No.
So how do you know where Mr. O'Keefe's body was found?
Through police reports, police interviews, stuff that was posted on the media.
So you've seen police reports in the media?
Well, not the police reports, I'm sorry, but what was said during on the news.
So what you've heard on the news, not necessarily what you saw or what you know yourself, correct?
Could you repeat that question, please?
You're recounting sort of what you've heard or saw on the news, so this doesn't come from your personal knowledge or anything about where Mr. O'Keefe was, correct?
Correct.
Okay. Now, you also spoke with some other individuals in May of 2023, correct?
Correct.
Now, did you tell those individuals that you actually came in, and when you say came in, you come into sort of the main sort of hub or the shed on Boulevard Street, correct?
Correct. We punch in.
That's where you punch in and you pick up your truck and you sort of do your checkpoint around the truck and then you go out and plow.
Correct.
Now, you were plowing on this street. Was there any other sort of subcontractor or anything else that was working, plowing the roads as well?
Yes.
And who was that?
It was by the yard landscaping.
And so they assist as far as the plow route is concerned, and they go around and they plow things on the same route that you were describing, correct?
Correct.
Now, these other people that you talked to in May of 2023, did you tell them at that time that you actually came in around 11:30 p.m. to 12 a.m.?
I don't remember that.
You don't remember that, or you didn't tell them?
I don't remember that.
So that would be a significant difference, 11:30 p.m. to 12 a.m. from 2:15 a.m. and 2:30 a.m., correct?
Correct.
Now, you also
Because we
indicated
trust
to them
Proctor
at that
and
time
Buchnick.
that you went past Fairview at approximately 12 a.m. and 2 a.m., correct?
I never did 12, but it was definitely 2:30,
So if they
2:40,
wrote that in a report, that
2:35.
would be inaccurate as well, correct?
Sustained, and only one person can talk at a time.
I apologize. I'm sorry, sir. Please continue and finish your answer.
I didn't hear the question.
Okay. Well, let me ask it again. So as far as if that was contained within a report regarding that conversation in May of 2023, that you went past Fairview Road or went down Fairview Road at 12 a.m. and 2 a.m., that would not be accurate, correct?
Objection.
Sustained, ask it differently.
Did you go down Fairview Road at 12 a.m. and 2 a.m.?
No.
If that were contained in a report of your conversation you had in May of 2023, would that be accurate?
Objection.
Sustained, ask it differently, Mr. Rowley.
Now,
Is
as
this
far as that
commenting on the
conversation that you
credibility of
had in
another
May of
witness?
2023, did you tell those individuals that you saw the vehicle around 1:30 or 2 in the morning?
Again, I don't remember ever saying that.
Is that accurate as far as whether or not you told them that?
Again, I don't remember saying that.
Did you see a vehicle around 1:30, 2 o'clock in the morning?
I wasn't on the road at 1:30 or 2 o'clock in the morning.
Correct. Now, do you also recall telling those individuals that Fairview Road was blocked off by cruisers at about 3 or 3:30 in the morning?
Again, that would have been incorrect.
Do you recall saying that in May of 2023?
I do not.
May I approach, Your Honor?
Yes.
So is this interview recorded? Or they just happened to shift the times around when they wrote their reports?
Show counsel.
Sir, I'm going to ask you to read, showing you a document, I'm going to ask you to read this paragraph, and this paragraph to yourself, okay? And then whenever you're done, just report that, okay?
So who do we think is lying? This guy? Or Proctor and Buchanan? The ones who showed us the fake reversed video from the Sally Port? The ones that made up a story about, you know, they were already intending to take her car when they drove up to Dighton, but pretended like they're still just in their fact-finding part of the investigation. If we're going by records, I'm not coming down on the trooper
Are you finished,
side
sir?
on this one.
Yes.
May I approach this retrieval?
Yes.
Thanks. Mr. Loughran, after having reviewed that, as your memory refreshed, as to that conversation you had in May of 2023,
No, it does not.
so you still, after reading that, don't recall telling anybody in May of 2023 that you came in around 11:30 p.m., 12 a.m. on the 28th, 29th?
I never came in at 11:30, 12:30 at night. It was 2:30 calling.
You don't recall indicating to anyone in May of 2023 that you went past Fairview at 12 a.m. and 2 a.m.?
Correct, never did.
And you don't recall telling anyone that you saw the car around 1:30 or 2 a.m.? Is that correct?
Correct.
And you don't recall telling anybody that the part of Fairview containing 34 Fairview was blocked off at 3 or 3:30 a.m., correct?
Correct.
Now, if the part of Fairview that you were talking about, you didn't say that in May of 2023, because at 3 or 3:30, the roadway wasn't blocked off, correct?
Correct.
It was blocked off sometime around 6 a.m., correct?
Correct.
And so if you had said that the roadway was blocked off at 3 or 3:30 in the morning, and it was actually 6, then when you saw the vehicle would have been off a little bit as well, correct?
Objection.
Sustained.
Seeing the car at 1:32 in the morning, with the road being blocked off at 3 or 3:30 in the morning, if the road's blocked off at 6 a.m., then that actually would have been, you saw a car sometime around 5 a.m., correct?
Objection.
Sustained.
Sure you didn't see a black
Nobody
Lexus
can
SUV in
understand
front of the house at 34 Fairview Road around 5 a.m.?
No.
Now, you also were asked some questions and you spoke to some troopers in August of 2023, correct?
Correct.
And County Canton, they have a parking ban in Canton, is that correct?
Correct.
That goes from November until April?
Correct.
Now, part of your plow route is a road called Tippy Cart, correct?
Correct.
Where is Tippy Cart in relation to Fairview?
It is on top of it's on the right side of Cedar Crest. It would put it 2 streets before Fairview.
And at some point, when you were plowing on Tippy Cart that night, you actually hit a basketball. Is that right?
Yes.
And did you call that in?
Yes.
And as a result of that, what happened with the basketball hoop after that?
Nothing. The point was to make sure I was covered, basically. That's why I notified my supervisor that I hit the basketball hoop.
And about what time was that you hit the basketball hoop?
I don't recall.
Is it closer to when you started, closer to when you ended?
I don't recall. I don't recall what time.
You don't recall anything specific about that time frame, correct?
No, just that I know I hit the basketball net.
And obviously, and I'm not trying to put words in your mouth or anything, sir, but you didn't intentionally hit the basketball hoop, correct?
Correct.
So you hit it because you didn't see it, correct?
No, I was attempting to avoid the net by going around it, and the machine had a different size body than what it originally had, and I underestimated when I was going around that I need to be wider.
So you misjudged the distance, is that fair to say?
Yes.
Not the point you think it is there, Lally. It's not that kind of misjudging the distance. This guy's got great answers. And his demeanor has been the same consistently throughout. You notice? He answers all of them quickly. He doesn't change his aspect from one attorney to the other attorney. He's the same with both of them. That is a very persuasive characteristic for a witness to have. The whole time frames, is he trying to say this was not when he spoke to the troopers? It was a different investigation. I seem like he was trying to make that point, but it was not clear. Of course, nobody can say feds in the course of this trial. Is he trying to say that was in the feds report? I don't know, because all we heard about from Mr. Loughran here was speaking to the defense investigator and then speaking to Trooper Proctor and Buchanan. And I certainly don't expect Proctor and Buchanan to record it or write it down correctly. The FBI, I would think, would record it. So is there a recording? I don't think this point has been very clearly made by Lally. Oh, the whole, be careful what you ask. You might not get the right answer. What's the difference between the Ford Edge and the Jeep Cherokee? This guy knows cars. He knows cars, and you're going to ask him that question. How do you tell the difference? Well, the shape of the taillight. It's rounder on the Ford Edge, and it's squarer on the Jeep Cherokee. He knows. See, Lally, this is why you interview the witness. You ask them that ahead of time, and then you don't try to get smart on the stand. You don't try to get him with a little gotcha, because it turns out he actually does know. You thought he wouldn't, but he does. That was very entertaining. Oh, that answer about why he didn't call in the Ford Edge. It was a courtesy to the Alberts. A courtesy. Excellent. Excellent answer. He has no reason to come in here and try to give him a hard time. It just is what it is, and he knows what he knows.
Now, sir, at some point prior to coming in here and testifying today, have you met with Mr. Yanetti?
Yes,
How many times?
twice.
And when were those times?
Tuesday and Saturday.
Tuesday and Saturday, when, sir?
Tuesday of last week, Saturday of last week.
And this Paul person that you spoke of before, was that person present there as well?
Yes,
And did you make note of Paul writing anything down, or Mr. Yanetti writing anything down while you were talking to them?
no,
And as far as you're aware, there's no reports that were generated from any of those conversations or any of those meetings, is that correct?
correct.
So, sir, I'm correct if I say that you're sure about every time that you went down Fairview Road and everything that you saw going down Fairview Road, but you're completely unaware of the time that you ran into and struck a basketball hoop that night, is that correct?
Objection.
Sustained, you can ask it differently.
You're sure about all the times that you went down Fairview Road?
Yes,
And you have no idea what time that you went on Tippy Cart and you struck the basketball hoop, is that right?
if you ask me to guess, I can guess for you.
I'm not asking you to guess, sir, I'm asking you to know.
I don't recall exactly what time I hit that net.
Nothing further.
All right, anything, Mr. Yanetti?
Briefly, there's just one question I want to make sure that we understand what's going on.
So no statements, right? Just ask a question.
I always do that. I apologize, Your
Okay.
Honor. You were asked a question by Mr. Lally. Are you sure you didn't see a black Lexus at around 5 a.m. in front of Fairview? And your answer was no. And my question to you is, does that mean that you're not sure if you saw one or that you didn't see?
Objection.
I'll allow that.
I did not see a Lexus at 5 a.m.
At any point that night while you were plowing,
No,
you see a black Lexus in front of 34 Fairview?
no.
Thank you, sir.
Very briefly, based on your timeline, were you on Fairview Road at 5 a.m.?
Yes,
How so, sir?
it was about 3 hours after the last time I went on it. So it put me, I was last on it at about 3:45, about 5:30.
You were on the road about 2:45, and you said it took you about 45 minutes to sort of do the loop and come back, correct?
Correct.
And from the time that you were on there, including the time that it took you to plow and the time that it took you to do all of those things along the route, you're coming back to Fairview Road at 45 minutes
Stop
later,
digging,
or it took
Lally.
you 45 minutes to do the route?
It was about 45 minutes.
And so from there, 45 minutes, from what time are we talking that you were first there? Said about 2:45 or so?
About 3:30 with the,
3:30, okay.
Yeah.
So about 3 hours after that would then be about 6:30, correct?
it was about, I mean, I know I went up there and saw the first responders coming down.
I
And when
understand. What I'm asking is, you had testified that you may, or you were on Fairview Road around 5 a.m. If you're not returning for 3 hours later, and that's about 6:30 from 3:30, correct?
Correct.
So then you were not on Fairview Road at 5 a.m., correct?
I was. The time that it took me to do what I needed to do put me there about 5. So when I'm coming down Cedar Crest from doing my route, I am constantly looking at Fairview to make sure that it's considered a main road. So we need to take that as a priority. So if it's a lot of snow on that road, I am going to go turn around and do the road so that the road is available. So first responders have access to that road.
So what I'm saying is, you testified, your timeline, that you came down there around 6:30 in the morning, correct?
My timeline was 5:30.
At 3 hours
5:30?
after 3:30.
It was. He did say
It was
5:30.
45 minutes.
No, 45 minutes was from 2:45 to get you to 3:30, then 3 hours later it's 6,
It was
correct?
It was about 45 minutes because I didn't get a lot of time. At that time, the snow was coming down at a significant rate, and I needed to make sure Fairview was kept clear. So I come down and I check. So I have the streets are all around Fairview. They're 5-10 minutes around Fairview. So the furthest street from Fairview is Kings Road.
So my question is, are you talking about coming down Fairview, or are you talking about being on another road and looking at Fairview?
Coming down Cedar Crest, looking at Fairview.
Despite that timeline that you gave earlier?
I am always looking at that street.
Nothing.
Good
All right,
enough.
Mr. Lockran, you are all set, sir.
Thank you.
Good
I'm
enough.
going to ask Dr. Marie Russell to join us.
Okay.
Dr. Russell. Going with some combination punching here. First, no body there. Now the dog bites. Not an impressive cross so far. I mean, he did bring in stuff from beyond the scope of the direct, which is good. You got outside stuff. You tried to brought that in. It's just it wasn't very effective. So basically what you did is you got him to repeat his story a few times and emphasize the points that are helpful to the defense. We wouldn't call it a bang bang because they're clearly using both hands here. They're not just limited to winging it from one side. They're gonna hit you from all angles. All angles today. No body and dog bites.
In case now and here, ensure the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. You take the stand.
All right, whenever you're ready, Mr. Jackson.
Thank you, Your Honor. Dr. Russell, could you please, in a loud, clear voice, state your name and spell your last name for us?
Hi, Dr. Marie Russell, R-U-S-S-E-L-L.
Doctor, what do you do for a living?
I'm an emergency room forensic pathologist, just recently retired.
And prior to retirement, what was your position?
The immediate position before retirement was chief medical executive at for the state of California at the Corcoran State Prison.
And
So, Dr. Russell, I'm going to ask you to keep your voice up, okay?
Yes, I'll try.
Thank you.
Thank you.
there's a couple of air conditioners in here. Just keep your voice as loud as possible. What is, in fact, an emergency physician?
An emergency physician is a medical specialist who has completed a residency, internship residency in the field of emergency medicine, which is a field which involves taking care of patients that are sick or injured and go to the emergency room.
Can you tell us what your education, starting with your education, training, and background is that qualifies you as an emergency physician, starting with your education all the way back to college?
Okay. Well, I have completed at least 16 years of formal education beyond high school, which includes college, and then 4 years of medical school, then 4 years of emergency medicine residency and internship, and then 4 years of pathology residency, which includes 2 years of anatomic and 2 years of forensic pathology. And then I treated, I've taken a bunch of other courses and attended seminars.
Let's start with your college. Where'd you go to college? Where'd you start?
Okay. MIT. I did my first year at MIT where I took my pre-med courses.
And then what happened after that? By the way, about what year was that?
Oh, that was in 1972 to 73.
Where did you go after MIT?
So what happened? I was interested in becoming a doctor, and so I took the pre-med courses, and then subsequent to that first year, I learned that my mother had metastatic breast cancer, and so I decided to go home to New York to be with her. After that, she subsequently passed away, and I returned to Massachusetts and decided to take advantage of the time off from school to investigate my interest in law enforcement. And I subsequently became a police officer here in Massachusetts.
So following MIT, did you go to a police academy?
I did.
Which police academy did you go to?
I went to the Boston Police Academy.
And did you end up becoming a sworn officer?
Yes,
For how long?
I did it for 7 years full-time.
And what department did you work for?
I worked for the City of Malden Police Department.
What years was that, if you could give me a range?
From 1977 to 1984.
During the time that you were a Malden police officer, did you also go to school and continue your formal education?
I did.
Describe that for us, please.
Well, I took specialized courses through the Massachusetts Criminal Justice Training Council.
Objection, move to strike.
All right, so I'm going to strike that. Jurors, disregard that.
Let me ask you this way. I don't want to
It
get
only
into the
matters when the cops
specifics.
do it.
Okay.
While you were a police officer, did you also take formal education to further your medical training or your college?
Yes, I did.
That's what I'm interested in.
Okay.
Tell us about that.
Oh, yeah. So I attended Northeastern University part-time and received a Bachelor of Science degree in psychology.
After you got your degree in psychology from Northeastern, did you go on to continue your education in medicine?
I did. I attended medical school at the University of Massachusetts Medical School from 1983 to 1987.
Also known as UMass?
Yes,
Did you ultimately end up with a medical degree?
did. Doctor,
After you became a doctor, did you engage in a residency?
yes.
What years were the residency, that first residency?
So the first residency was from 1987 to 1991, and that was in Los Angeles at the Los Angeles County University of Southern California Medical Center.
Is that also known as LAUSC?
It was at the time, yes.
And that's associated with the University of Southern California Medical Center, is that right?
Yes.
After your first residency, by the way, what was your first residency in? What was the subspecialty?
So it was in emergency medicine, and USC is a very large trauma center.
How would you describe the size and volume of the USC Trauma Center?
Well, it's one of the busiest in the United States.
After your first residency in emergency medicine, did you do a second residency?
Yes.
What was the subspecialty in that second residency?
So I did a 2 years in anatomic pathology and 2 years as a fellow in forensic pathology at the Los Angeles County Coroner's Office.
So you did 2 full residencies after you became a doctor, is that right?
That is correct.
What's the difference? I don't want to go into great detail, but what's the difference between an emergency physician and, for instance, the residency that you did in pathology, both anatomic pathology and forensic pathology? What are the differences?
Well, generally, the emergency physician treats live patients, and the spectrum of injuries can be wide, or illnesses can be wide, and the forensic pathologist treats or deals with deceased patients generally.
Did you become a fellow at the LA Coroner's Office following your second residency?
No, that was part of the second residency.
Understood. Describe that fellowship.
So that was 2 years of full-time work at the LA Coroner's Office under the supervision of very experienced medical examiners. And what I did was I did autopsies, every day. 1 or 2 autopsies every day, attended conferences, and read journal articles, etc. It was a very formalized education.
Did you also become at some point a professor or an assistant professor at LAUSC, the medical center side, the university side?
Yes. So while I was doing the forensic pathology and anatomic pathology residencies during the daytime, I worked as a full-time ER doc supervisor in the capacity of an assistant professor in the evenings.
Did you also become an adjunct professor at Cal State Los Angeles, California State Los Angeles?
Yes.
Is that a separate university?
Yes.
And you had separate responsibilities as a professor in that role?
Yes.
Were you also teaching legal medicine and forensic medicine in that capacity?
That is correct. It was a master's level program.
How long were you an ER physician in total and an attending physician for Los Angeles County USC Medical Center?
29 years in total. 4 of those were in training and the rest were as a supervisor. And
Of your 29 years, 25 of your 29 years, you were supervising others,
correct.
meaning other doctors,
Other doctors, yes.
teaching other doctors.
Yes.
And teaching medical students.
Yes, and seeing their cases. Once they examined the patient, they would present their case or tell me about the case, and then I would go in and see those patients in addition to my patients.
That was my next question, doctor. In addition to teaching, were you also specifically assessing, diagnosing, and treating patients of your own?
Yes, not all the time. Some shifts I didn't have to do that, but much of the time, yes.
For the bulk of the 29 years that you were an ER doc, an emergency physician, in other words, were you also attending to patients as well?
Yes.
Once you left that fellowship with the LA Coroner's Office, did you remain active in any way or connected to the Los Angeles Coroner's Office?
Yes, so I would attend their weekly conferences when I could, when I was available and to do so, and I also consulted on some cases with them. So if they had something that was interesting and beyond their clinical expertise, they would sometimes consult me.
During your tenure at LAUSC, did you become the director of any of their sub-programs?
Yes.
Can you describe that for the jurors, please?
Yes, I was director of the USC Center for Life Support Training, and that involved teaching other doctors life support courses such as advanced cardiac life support, or we teach the surgeons advanced trauma life support.
I'm sorry?
Oh, go ahead.
Were you also a director for their quality improvement in the early 2000s?
Yes, for the emergency medicine department.
What was the reason for the quality improvement program, if you will, for LAUSC?
Well, for any program, it's ideal to have a quality improvement component, because what you want to do is look at cases that were treated and see if there were any errors, and if so, correct the errors, teach the doctors that involved, what went wrong, and try to make systemic improvements or teaching improvements to prevent those errors from occurring in the future.
Were you teaching basically best practices for emergency room physicians as well as trauma physicians and surgeons?
Yes, we tried.
And you were the director of that program, correct?
Yes.
Did you also become the director of LAUSC Jail Medical Services?
Yes.
What is the connection or the tether between the jail system in Los Angeles and LAUSC Medical Center?
Well, LAC Jail Ward was established about 70 years ago, and it was a place that the officers from various agencies such as LA Sheriff's, LAPD, California Highway Patrol, or any of the municipalities around could bring people that they arrested who were in need of medical care.
So the jail system, very large jail system, I'm guessing, in Los Angeles, correct?
Correct, yes.
There have to be medical attendants
Correct.
to that jail system, correct? Yes. And you became the director of the jail medical services for the entirety of that system?
For the hospital component of it,
Understood. In California,
She's perceptive.
there is
She
you're
can
obviously
read his,
licensed in California.
yes,
There is a state medical board in
what he
California,
wants.
correct?
yes.
And did you ever do any work with that state medical board?
Yes, I worked with them for about 7 years part-time as a regular employee embedded in their enforcement unit. And what that involved was examining cases that were referred to the medical board because of substandard care or illegal activities of the providers. It was for physicians and physician assistants that we regulated.
What was your title with the state medical board for those purposes?
The title was medical consultant. That was the official title.
Okay. And then before your retirement, by the way, what years were you the medical consultant for, or a medical consultant for the state board in California?
Gee, I think from 2009 to 2016. I think those were the years. I'm not positive. I did that. That was a job I was doing. One, I was doing the LA County USC Medical Center job too. It was an extra job.
So you didn't stop working as a physician, an ER, an emergency physician at LAUSC to take that position?
No,
You just consulted with them?
I did it once a week, 1 day a week.
Got it. And then with regard to one of your last positions that you held, did you become the chief medical executive for the California State Prison, Corcoran?
Yes.
Tell me about that position and the years that you held that position.
Clearly unqualified.
So that was from 2018 to 2023. And as the chief medical executive, I was the supervisor of all the doctors and nurse practitioners that provided care to the inmates.
And obviously, the California prison system is a very large prison system.
Very.
Doctor, are you board certified in emergency medicine?
Yes.
Are you a member of the National Association of Medical Examiners?
Yes, I'm actually fellow status, which is higher than member.
Are you a member of the American Academy of Forensic Science?
Yes, again, I'm a fellow there.
Which also is an advancement above just being a member?
Correct.
Have you ever published in the area, and now I'm going to get very specific, have you ever published peer-reviewed articles and done research in the area of animal bites and scratches?
Yes.
Did you author or co-author a peer-reviewed article named Managing Law Enforcement Dog Bites in the ER?
Yes.
About what year was that?
It was in the 1990s.
Late 1990s, 1996, does that
Yes.
sound right? Did you also author or co-author an article called Law Enforcement Canine Dog Bites, Injuries, Complications, and Trends?
Yes.
So given those articles, did you study specifically dog bites, dog wounds on the human body?
Yes, I have a very strong interest in wounds in general, and I have a strong interest in dog bites in particular.
During the course of your career, your professional experience, how many patients would you say you've seen or treated with animal injuries, including bites and scratches?
It's very hard to estimate, but between my own practice and the residents that I supervised, it was, I'm sure, well over 500, and could possibly be double that.
Could be up as many as 1,000.
It could be, yes.
Have you qualified as an expert in emergency medicine in the past?
Yes.
You qualified as an expert in the area of forensic pathology and wounds in the past?
Yes.
Is that both in federal and state courts?
Yes.
Doctor, were you asked to review certain materials related to this case in furtherance of coming to some opinions and conclusions about injuries suffered by John O'Keefe specific to his right arm?
Yes.
What did you review in coming to your opinions and conclusions?
Well, I reviewed hospital records and pictures taken of him in the hospital, when he was in the hospital. I reviewed autopsy records, the autopsy report, and photographs taken during and before the autopsy. I reviewed, let's see, I reviewed reviewed the grand jury testimony of the autopsy pathologist. I reviewed affidavit of Dr. Sheridan. I reviewed the town of Canton dog bite reports about regarding incidents.
Objection, may we approach?
Yes.
Lolly doesn't like that because she didn't remember that during her voir dire. It looks like she is reading from her notes up there, which you're not supposed to do. But let them instruct her not to. It's not like the cops haven't been up there doing that. So just go ahead and tell her. And Mr. Lally, you can cross-examine on that. You didn't remember that before. You didn't recall, and she can explain. I remembered now. Yep, good point by Sleuthy. Yeah. After that voir dire, she probably did go double check the Dropbox and went and reviewed them. We're going to the fan. No, don't take us to the fan. Surely we're just going to have a conversation away from the jury. Don't make us stare at the fan. I'm going to take the fan off. I'll take that away from you guys. And you don't have to stare at that. Yeah, clearly a discrepancy from her voir dire where she said she didn't remember seeing any of those. So the explanation is either she has looked at them since then or she did and just didn't remember at the time. If it's looked at them since then they might have an argument to keep it out because the whole issue was the voir dire was to put Lally on notice of what she did, what she was going to opine to, and so forth. So anything that she did subsequently, they shouldn't necessarily be able to get that in. It's the same argument for not allowing Trooper Paul to testify to his off-the-cuff determination that, late in the day during the prep session, probably during trial.
Hey there, Karen Reed, trial watcher.
Sorry, Jesse. Yeah, I guess they are going all the way full on to break. You can't make up a new opinion after everything has already been disclosed and then not disclose that. So if it affected her opinion or if she has a new opinion as a result of that, they probably won't let her go there. But if it's just adding to what she looked at to form her opinion that hasn't changed, it's still the same opinion as it always was, then maybe it will be allowed. I don't know. I would like to know, just for my own interest, what sort of effect those records would have on her analysis. I've expressed skepticism with the whole bite mark comparison. No, we're not going to ID a dog from bite marks on different people. I'm just not going to buy that. I think that is going to be pseudoscientific. It's just way too close to the kind of junk science that has put innocent people in prison by practitioners who can't reliably tell the difference between a human bite or an animal bite. But if it adds to her interpretation of these injuries, because, for example, she can look at things like, well, how deep did the dog puncture? If the dog, just different characteristics of the attack that could carry over between both times. Where was that person? Oh, they're all injured on the arm. I could see there being a point to identifying similarities like that. But I don't know that I would be okay with going down the road to saying these bite marks on John O'Keefe's arm are not just a dog, they're from Chloe. That's going to be too far for me. Just keeping it real, guys. That's going to be a bridge too far for me. Don't believe you can ID the dog from a dog print mark, dog bite mark. But they don't need to do that. It's just, it's overkill. I don't know that it's necessary. It's just enough to testify. Yeah, these are dog bites. These are dog bites. I've seen hundreds, if not thousands of them. They're dog bites. I study this. I have a specific area of expertise and interest here that I have published on. This is my wheelhouse. And yes, I can look at these and say these are dog bites, and I can explain why they're dog bites. I think that's perfectly good enough. Well, if we got some time, let's get back to some of your guys' questions and comments and stuff. Thomas, hard for a younger attorney to get trial experience these days, especially on the Guys, I fixed it. We lost our internet for a second here. I was terrified we were going to lose the whole stream, but we didn't. So thank you for holding tight with me. Woo, that worked out. And we're still on break. Oh my gosh, I was afraid I was going to I was afraid things were going to get quite chaotic there. So, hey, it happens. Thank you for sitting tight. Anyway, we were addressing the super chat, which is still here. All of your guys' chats are still here. I'm so glad. I was so worried we were going to lose everything. Yes, what I was trying to say here, it's always hard to get trial experience on the civil side just because so few civil cases actually go forward to trial. But if you are a young attorney and you want trial experience, please consider becoming a public defender in a rural community. We have such a shortage of public defenders, and for whatever reason, kids like the city right now. I mean, I guess I get it. It's exciting and all that. It's where people are, but we have major shortages out here. And in my own community right here, Franklin County, we have, which is not actually where I live, but it's in my area. There are so few public defenders that they're having to cut people out of jail and stuff because they don't have enough attorneys to be able to assign people an attorney for their arraignments. And so they just can't handle the volume of cases that are going through. We have a desperate need. There's so many opportunities to go to trial as a public defender. We have a good system here in Washington because we have caseload limits and things like that. So it's improving all the time. Way better in terms of just quality of life and being able to manage your stress and your workload and do the things that need to be done to do a good job on a case. So I'm going to pitch that. Highly recommend it if that's the kind of experience you're looking for. Claudine with just the super chat. Thank you so much. I really appreciate it. Kyle Cowden, ortho's my only itch. My first IO creeped me out. That would creep me out. Okay. Doing that whole drill into the bone. I don't consider myself a very squeamish person. I had knee surgery when I was in 8th grade. This was in Belgium. There were different medical practices then because they did it under local anesthesia, and I watched the whole thing. Didn't really bother me. It was fine. The only part that was really gross is at some point, they called this process a laminectomy. So they went in with a laser and actually cut.
So the Commonwealth's objection is overruled. You can continue.
They actually cut a ligament with a laser, and I could smell my own flesh burning. That was a little troubling.
Reviewed and coming to your opinions and conclusions. Did you also review a toxicological report?
Yes.
And a neurology report, neuropathology report?
Yes.
As well from the Commonwealth?
Yes.
Based on your review of
but drilling into the bone
all of
creeps
those
me
materials,
out.
I don't want to know what your opinion or conclusion is yet, but were you able to come to an opinion or conclusion concerning the injuries specifically to John O'Keefe's arm?
Yes.
Or his right arm? Were there any documents in furtherance of your review from UC Davis?
Yes.
Did you review those as well?
Objection.
Sustained.
With the court's permission, may we display Exhibit 19?
Okay.
Doctor, I want to show you a photograph and ask you very quickly, have you seen this before?
Yes.
Is this one of a number of photographs that you reviewed in furtherance of your evaluation of this case?
Yes, it is.
I'd like to just focus your attention on this for just a quick second and ask you, does this accurately reflect the wounds or injuries that you saw on John O'Keefe's right arm in coming to your opinions and conclusions?
Yes, it reflects the injuries that I saw in photographs.
All right. Now, based on your review of all of the data that you've talked about, all of the information that you were given and reviewed, what is your opinion or conclusion about how these injuries were sustained?
I believe that these injuries were sustained by an animal, possibly a large dog, because of the pattern of the injuries.
Could you describe for the jurors, please, on what you base that opinion?
Yes. Well, may I use the?
Sure.
Okay, thank you. there's a number of patterns here. There, on the upper part of the arm, there's parallel lines, and those were inflicted by either teeth or claw marks. So there's a number of patterns that could be teeth or claw mark. And so this is one set right here. This is the one further down, closer to the elbow, parallel marks. Again, probably most likely from teeth marks. And the reason I say that is in addition to the parallel marks up here, down here, there's also little punctate, incomplete puncture marks here, little round marks right there that were inflicted by the actual point of the tooth.
Okay, that was my question. What relevance does that have to your determination that this was likely caused by an animal?
Yes, and I can explain in a moment the various kinds of wounds that animals can inflict. But going on with the picture first. So then down right at the elbow, there's another different series of marks that again have linear abrasions up where the pointer is, and then down below some punctate, superficial, round, small abrasions, again representing upper and lower teeth, in my opinion. And then there are some irregular wounds down just below the elbow. And these are all, by the way, on the exterior surface, or what we call what doctors would call the posterior surface of the arm, which is the part of the arm that would sustain defensive type wounds. So if someone were to protect themselves.
Yes.
Objection.
So it's sustained. Next question.
Sure. Doctor, if I can ask another question. Just to clear up what you said a little earlier about some of the wounds close to the elbow, is it your opinion that both the top teeth and bottom teeth could have created some or all of the injuries on that elbow area?
Yes.
Okay, so in other words, instead of the mouth going all the way around the arm, it could have, the top and bottom jaw could have situated itself on this portion that we're seeing, the posterior part of the arm?
Yes, and in this case, the animal did not get a good enough contact.
Objection. Move to strike.
So I'm going to strike that, ask a different question.
Have you seen contact wounds where the animal, a dog for instance, gets a very solid purchase on the leg, arm, part of the body?
Yes.
Okay, is that this or is this something else?
Something else.
Describe that.
Very good, Jackson.
An animal inflicts injuries. The type of injury depends in part on the actual type of contact and how much force is applied by that animal, in addition to any relative movement between the animal and the victim in this case. So, for instance, in the law enforcement dog bites, many of...
Objection.
Right. So the nature, is it notice? Is it, what's one word?
May we approach?
Okay.
No, he can't do it in one word. He's got to use some word salad. Even when she tried to feed him the one word notice. If he didn't get notice of this opinion, it's because he didn't ask. He didn't ask. He had the opportunity to ask all of the questions that he wanted about her opinion, these injuries. He knows that she said these were top and bottom teeth. She said that specifically in the voir dire, talking about these injuries. She said that. So if you didn't get into that, that's on you. Oh my Lord, how is he going to cross her? How is he going to cross her? If he's smart, he won't. He will take the Ms. Little approach and not ask questions. He's going to get in here and try to be argumentative with her. He's going to try to push road rash on her, or he's just going to try to, maybe he'll just do something like, well, you can't definitively say, you can't rule out every other possible way these injuries could be caused or something like that. I mean, I don't know how he's going to do damage here. I mean, you're not going to pick her apart on technical conclusions. All you really have is what you got for your own medical examiner, who says it could be a lot of different things, and she won't say definitively what she thinks it is.
May I, Your Honor?
Yes.
Thank you. Without getting into any specifics about police canines,
Okay.
does the pattern of injuries that you see appear consistent with an animal or a large dog?
Yes.
Does the number of injuries that you see here relegated to just the right arm, is that also consistent with an animal or large dog?
Yes, it can be.
Is the direction of the injuries, or the consistency of the direction of the injuries, or the parallel injuries, is that also consistent with an animal or large dog attack?
Yes.
Based on everything that we've discussed today, Doctor, is it your opinion, based on a reasonable degree of medical certainty, that these injuries were from an animal attack, possibly a large dog?
Yes.
That's it.
Have a moment, Your Honor.
Yes.
That's all I have at this time, Your Honor.
Okay.
May we approach?
Okay.
What he wants to go into more. He's got more arguments. The dog bite medical specialist says these are a dog bite. How do you overcome that?
You are unmuted.
Hey, John.
Sure.
Good afternoon, ma'am.
Good afternoon, sir.
Now, testified that you're certified in emergency medicine, is that correct?
That is correct.
And you're
Attacker
not, nor were you ever
qualifications.
certified in forensic medicine, is that correct?
That is correct.
Pathology.
Correct.
And when was the last time that you worked at a coroner's office?
1995 in terms of doing autopsies. Yes.
Now, when was it that you first spoke to anyone from defense counsel in regard to your coming in here and testifying today?
May 17th.
Doctor, I am going to ask you to keep your voice up.
Oh, sorry.
Thank you.
May 17th, 2024.
May 17th of this year, is that right?
2024.
So about 6 weeks after this trial began?
I don't know when the trial began.
Now, as far as who reached out to who?
I reached out to a district attorney that I worked with with the LA coroner's office.
And then somehow that person put you in touch with Mr. Jackson, is that right?
Yes.
And was that also on May 17th?
17th and 18th, yes.
So I'm sorry, 17th or the 18th? Which one was it that you spoke with Mr. Jackson?
I didn't speak to him.
You did not speak to him?
Not speaking, not verbal. There was some email communication or text communication.
You communicated with him, was that
Yes.
on the 17th or the 18th?
Yes, both, I think.
Oh, okay. And when did you render this opinion as far as what you've testified to here today?
Shortly after he sent me the files.
Now, in regard to those files, you testified in this court a couple days ago, correct?
I did.
And you were under oath at that point, is that correct?
Excuse me?
You were under oath at that point, is that correct?
Yes,
Correct. And when you were asked specifically what materials that you had reviewed,
Yep, you can
you
cross on
included
it.
a number of items, but you did not include anything about a Dr. Sheridan affidavit, anything about a UC Davis report, or anything about any sort of bite history for a canine that lived or resided at 34 Fairview Road, correct?
that's correct, because I hadn't reviewed them then.
And so since then, 2 days ago, now you've reviewed them, correct?
Yes, I became aware that those files existed, yes.
You became aware of those files? Were they not sent to you previously?
No, I think there were technical difficulties regarding me and the computer and downloading from Dropbox. And so, yeah, so they were, I think they were sent to me, but I think I didn't open them.
Now, with reference to these technical difficulties, did you ever express any of those technical difficulties? Or, hey, I can't see the whole file, or there's other things in here that are listed that I can't look at?
No, I wasn't aware.
And so with regard to, as far as your reaching out or contact in regard to this case, how did that come about?
Okay. I saw an article, I believe it was in the Boston Globe, regarding this case. And I didn't, initially I didn't think anything of it. Then I saw an article that indicated that there was some...
I'm not asking you anything about anything any article indicated. You saw an article in the Boston Globe about
Yes.
this case, is that right?
Yes,
And how did you come upon it? You have a subscription to the Boston Globe?
I did at the time, yes.
You did at the time. What time was this?
In May,
May of 2024?
yes.
And how long had you had a subscription to the Boston Globe at the time that you saw this?
It was either a 6-month subscription or a year, I don't remember.
And that was the first time that you had seen anything about that?
First time I paid attention to anything like that, yes.
Now, again, you had testified here just a couple of days ago when I asked you questions about this, is that right?
Yes,
It wasn't in your testimony just a couple of days ago that the subscription was actually for a year or 18 months. You
No.
Remember, not 6 months a year.
So only one person can talk at a time. So was that your testimony, Doctor?
no, I don't believe so. I believe that I said it was a 6-month subscription or a 12-month subscription.
In any event, you saw something, that's the first time that you recall seeing anything in the media about this case was in May of 2024?
It was the first time that I recall reading anything about it. Correct.
Now, did you write a report in regard to your opinions that you've testified here today?
No.
And I asked you that a couple days ago as well?
Yes.
Okay, so in the
Sir.
last couple of days, you've had time to review a UC Davis report, Dr. Sheridan's affidavit, and any sort of dog bite history, but you haven't had a chance to write a report?
Objection.
Sustained to that form.
Yeah, she
haven't
doesn't have
written
to
a
write a
report, correct?
report.
That's correct.
Why not?
I haven't been asked to write a report, sir.
Now, did you ever look at anything related to Mr. O'Keefe's head injury?
I looked at,
Objection.
Sustained.
Let him open those doors. Let him open those doors. Did you evaluate medical probability that this was a motor vehicle collision?
Yes.
You seen a lot of those? You have any opinions about that? Open that door wide, Mr. Lally. He's trying to pull the Jackson. I didn't ask you about what it indicated, but that's part of her answer. I mean, they could have easily objected to that. Said she's answering how she came to learn about the case. Let her finish her answer. But instead, she's handling herself well, and Lally is just coming across like he's being a jerk to this very nice, very qualified lady for no reason than because he doesn't like what she has to say. Are we going to pull the whole getting your 15 minutes of fame here? Are we going to pull that? And she'll say, we could say the same thing about you, Mr. Lally. just to have a little throwback moment. I don't know why he's coming so hard at her. It's because he doesn't have anything substantive, to challenge her. So he's got to try to come at her. See if he can get the jury to not like her. Think there's something wrong with her having this opinion, her having offered this opinion. I mean, Jackson is going to be able to redirect on this. Why did this particular article catch your attention? Well, because that's when I became aware there was a dog bite issue. And since this is my area of expertise, I thought I might be able to be helpful about it. I didn't realize there was this conflict. And as it turns out, gosh, I'm like one of the experts on dog bite injuries. Maybe Lally's going to ask if it could be a wild pig. You said an animal. That doesn't exclude a pig, does it? Is he going to go in and challenge her with the DNA? See, that would be stupid because the absence of evidence is not evidence of absence. She could say it means nothing that there's no dog DNA on the clothing for all kinds of reasons.
May I have a moment, John?
Yes.
Now, Doctor, you testified that you had some familiarity with areas of forensic science. You're on some boards, things of that nature. Is that correct?
You're on some boards? I'm a fellow.
And as a result of that or any other work experience, are you familiar with a NAS report from 2008?
Oh my God, he's going with the NAS report?
Not with that limited information, no.
You're not aware of a report issued by the National Association of Forensic Science in 2008, which specifically has a section dealing with...
So I'm going to see you both at sidebar again.
Yeah, it's dealing with the bite mark comparison. That's what I've been talking about. The bite mark comparison evidence for identity purposes, for proving this person caused this bite mark or this dog caused this bite mark is junk science. Yeah, that's in the National Academy of the Sciences report from back in 2008, which is, I mean, this is how long forensic science has been very publicly called into a lot of significant question by people in the field. And then it was the PCAST report, the President's Council Advisors on Science and Technical, I forget what it stands for, but they did theirs a couple years later. These challenges to the basis for a lot of these forensic techniques.
So, ma'am, you're not familiar with that report, specifically as it applies to forensic odontology?
So could you say that again, Mr. Lally? What's the report?
The National Academy of Sciences 2008 report in relation to the section referring to forensic odontology.
I'm not familiar with that specific report, no.
So then you equally unfamiliar with the
PCAST?
representation that is not from the NAS report, that is not a reliable science as far as bite marks are concerned.
There are certain aspects of bite marks that have been deemed not reliable. And that I believe has to do with saying that this particular person or animal inflicted this particular bite. But that's very specific, and that's what I'm aware of, that recommendation.
you're not aware of any findings in the NIH
Correct.
report that has led to questioning of the value and scientific objectivity of such evidence?
For specifically identifying a bite mark to an individual that might have inflicted the bite mark, I think that's what that applies to.
Okay, I'm not asking, again, this is a report, are you familiar with it or are you not?
She's answering your question.
I'm familiar with a summary or a abstract of a report that indicates that forensic odontology is not is deemed not reliable when it comes to that particular narrow aspect of forensic odontology.
And so you're not familiar with it. Also, talking about sample data and collection, analyses of these, interpretation and reporting of results. You're not familiar with those areas of the NIS report as well?
But what specifically, do you have a specific
Would you like to show
question
me?
about that, or?
First question was whether or not you're familiar with the report. You indicated that you weren't.
I did not read the report.
From the report.
Mr. Lally, let the witness answer, one question at a time, one speaker at a time. Doctor, can you answer that question?
Sure. I did not read that report.
Now, you had written some articles that you were asked about in reference to dog bites or canine dog bites in the emergency department. Is that correct?
Yes, co-authored.
Something that you published or authored or co-authored sometime in the late 1990s. Is that right?
Correct.
And in that instance, you talk about law enforcement dogs and a bite and a hold technique, correct?
Yes.
Now, part of the reason in writing that article had to do with sort of the applied forces and the unique spectrum of injuries from those kind of dog bites. Is that correct?
Yes.
And that spectrum of injuries would include deep puncture wounds. Is that right?
They can, yes.
Severe crush injuries. Is that right?
Correct.
Large tissue avulsions and lacerations. Is that right?
Yes.
Wounds necessitating surgical debridement. Is that right?
Yes.
Bony injuries ranging from cortical violations to displaced fractures. Is that right?
Yes.
Neurovascular damage. Is that right?
Yes.
And other wounds at high risk for infection, correct?
Correct. But we also put a disclaimer in that article.
I'm not asking you about any disclaimer.
Okay.
I'm asking you about what the type of injuries that you were looking at. Is that correct?
Yes, but we saw a skewed population.
Did you skewed population in a study? Is that correct?
What we saw the worst of the worst.
Or no? Did
Yes.
you skewed population in the study?
I'm sorry, I don't understand the question.
To the population.
Did we skew? No, we reported on all the ones that presented to the emergency room for care. However, a lot of dog bites don't present to the emergency room.
And so from the different cases that you report on within that article, are there any of those cases in which there is injuries to just one aspect of one part of the human body for the victims of dog attacks or dog bites in those cases?
There may have been. That's a summary of the 700 cases, more than 700 cases.
Is it normal in any kind of animal attack for injuries to occur on just one side of one arm of the person that's being attacked, clawed, or bitten?
There are many people who are bitten or scratched.
I'm asking
Only-
if it's normal, ma'am. That's all.
Okay, so,
her answer.
hold on, Mr. Jackson. Mr. Lally, ask a question, wait for the answer, and then start a next question. Do not interrupt the witness.
I apologize. I don't mean to interrupt, but I'm asking for an answer responsive. to the question.
Apologize to the witness, not the
So
judge.
ask a question and ask it in a manner that you get a responsive answer.
Dr. Russell, is it your testimony that it's normal in an animal attack for injuries to occur on just one side of one arm and nothing else, anywhere else on that person's body?
It can be, yes.
I'm not asking if it can be. I'm asking, is that normal?
I can't say.
It's sustained. You have to ask the question differently.
Yeah, what a stupid
So
question.
from your observations, you looked at various photographs of Mr. O'Keefe, is that right?
I did.
Did you observe any injuries on any other part of his body that you would attribute to an animal attack, whether they be claw marks or bite marks or anything else?
No,
So nothing on his left arm, correct?
nothing that identified as a dog bite or
Nothing on
scratch.
his legs, is that correct?
That's correct.
Nothing on his torso, is that correct?
That's correct.
Now, you say an animal attack, possibly a large dog, correct?
Yes.
Can you say what type of animal left these marks that you attribute to an animal attack?
Not with 100% certainty, no.
Can you say where physically Mr. O'Keefe was located when the animal attack supposedly occurred?
Objection.
Can you say that?
No.
Okay.
Can you say when
Question.
Mr. O'Keefe purportedly sustained these injuries from an animal attack?
Well, to a certain degree, yes. Before, yeah, it was before death, but not long enough to have a big inflammatory reaction. So yes.
Okay.
So minutes to hours before death.
Minutes to hours before death, but at some point before death, correct?
Yes.
Can you say anything about the breed of dog?
No.
Can you say anything about whether it occurred inside the house, outside of the house, anything like that?
No.
As far as you mentioned some of the different things that you reviewed over the course of your testimony, over the preparation of your testimony, both prior to Tuesday and between Tuesday and today, any of those things contain any forensic reports or phone examinations or anything else related to this case?
Could you repeat that? What kind of examination?
Any
Phone?
of the materials that you reviewed, whether it be prior, sometime between May 17th and Tuesday,
What are the
or
phone
anything that you
records
reviewed
gonna tell
between
you about
Tuesday and today, did any of
These
those
injuries being
materials that you
consistent with the
reviewed
dog?
contain any sort of forensic reports or anything beyond the UC Davis?
Yes, I saw a photograph.
So you saw photographs. And to that point, you never actually saw Mr. O'Keefe's body, correct? You just saw photographs?
That's true.
And with respect to the UC Davis report, as far as canine DNA, are you aware that the results of that were that there was no canine DNA on Mr. O'Keefe, on swabbings that were sent to the UC Davis lab?
I'm going to allow it.
Yes, but there was clothing in between.
Okay, but the swabbings came from the clothing with tears in the
Okay.
clothing in the same area as the injuries, correct?
Okay.
Do you know that or no?
I couldn't tell if they came from the wound or the clothing. I thought that they came from the clothing, but
You couldn't tell by reviewing the report whether or not the swabbings came from clothing or from Mr. O'Keefe's body?
I know the clothing was sent to the laboratory,
You know the clothing was sent to what laboratory?
to the DNA laboratory.
To UC Davis?
Oh, I don't know that. No, I'm sorry.
You are aware that that came back as far as negative for any canine DNA, correct?
That's correct.
Now, as far as the injuries that you observed, your testimony is that both the top teeth of whatever animal this is and the bottom teeth of whatever animal this is both made contact with only the top of Mr. O'Keefe's arm or the posterior of his arm?
Both sets of teeth made contact with certain of those wounds, yes, but not all of them.
But neither the top nor the bottom teeth made any contact that you observed, assuming your
'Cause it didn't
issue
get
as
a
far
good
as an
grip.
animal attack. There's no evidence of any animal attack on the bottom of Mr. O'Keefe's right arm, correct?
I'm not sure what you mean by bottom.
Anterior,
Interior? That's correct.
and nothing on the posterior or the anterior of his left arm,
That is correct.
and nothing on his legs,
That's correct.
nothing on his torso,
Correct.
nothing on his head, is that correct?
Correct.
Now, as far as the marks that you did observe that you do attribute to an animal attack, can you even say with certainty whether or not those marks you feel are bite marks versus scratch marks? Do you have any idea which are which?
There may be a combination.
So is that a no?
Well, no, I think that the ones that had the linear abrasions above the small round punctate abrasions, I believe that those are bite marks from upper and lower teeth.
Mm-hmm.
Now,
Always
you
worse at cross than I
indicated
even
that part of what
expected.
you had reviewed was a dog bite history for a dog from 34 Fairview Road named Chloe, is that right?
Yes.
And there were a couple different instances of that dog essentially getting in a fight with other dogs, correct?
Yes.
And at any point in time, did you see anything in there as far as a dog going after a human in which there was no other dog present?
No.
And there were actually photographs contained within that material of dog bites from that dog, from Chloe, correct?
Yes.
So now
Did
you're
any
going to
of
ask
those
her to
dog
do
bites
what
that
you
you
just
saw in
said
those
was
photographs look
unscientific?
anything like what you observed in the photos that you saw of Mr. O'Keefe's arm?
No, but. Okay.
That's all, ma'am.
Objection, Your Honor.
No, so the answer is no. You can get back up, Mr. Jackson, but the answer to that question is no. Next question.
And she knew he was going to cut her off. So she just smiled.
So is it your testimony that from reviewing what you reviewed, that what you observe on Mr. O'Keefe's arm is consistent with an animal attack to the exclusion of any other possibilities?
To a degree of reasonable medical certainty, yes.
Yes.
So as far as any other sort of blunt impact injuries or other manifestations of how those scratches got there, you're saying, nope, had to be an animal attack.
I've seen thousands of wounded.
No, ma'am. What I'm asking is.
All right, so Mr. Lally, I'm going to let the witness answer.
Go ahead, ma'am.
I've seen thousands of people with injuries to their skin. And from blunt, from sharp, from all different mechanisms. Those injuries did not look like blunt force injuries.
So it's your testimony that the injuries to his arm don't look anything like blunt force injuries that you've seen before. You wouldn't characterize them as that?
That's correct.
And that's based on some photographs and some other materials that you began reviewing sometime May 17th, 2024.
Yes, I'm an ER doctor. I need to make a diagnosis quickly when I see
Yes.
something, and I'm trained to do that. That's my specialty.
Are you being asked as an ER doctor to come to a quick conclusion in this case?
No,
But you did anyway.
it's how I'm trained.
Nothing further.
Very briefly, Your Honor. Please report.
Go ahead.
Concerning the forensic odontology report, the NAS report that Mr. Lally asked you about, what is your understanding about the report as it pertains to identifying individuals who left a bite mark? Explain that to the jury, please.
I believe the report says that is not reliable as it once was thought to be.
Like a fingerprint identifying a human being, DNA identifying a person, or a bite mark identifying a person. NAS said, not the bite mark, doesn't work that way.
That's correct.
Has nothing to do with the pattern of injuries that you've seen 1,000 times from animals, correct?
Correct.
You were asked several questions about the injuries that you saw and studied attendant to highly trained canines, police dogs, correct?
Yes.
Very different than just a domestic dog that somebody might have as a pet, correct?
Correct.
And the bite injuries are very, very different as well, aren't they?
That is correct.
Tell us more about that. Jackson,
You were
ask
asked
her
whether or
to
not you were
expound on that.
aware, based on UC Davis's report, that there was no canine DNA found on the swabs that were sent to them, correct?
Yes,
Are you also aware that there was pig DNA?
I'm aware of that.
Did that have any impact did you analyze that at all, one way or the other?
Not to any degree of scientific certainty, no.
But you do know that dogs chew on pig ears sometimes, correct?
Objection.
Sustained.
Do you know that?
You've reviewed at least a report, if not a series of reports, that indicate that a particular dog has an attack history, correct?
Yes,
You were asked specifically by Mr. Lally whether or not the wounds in a dog attack on another dog attack where a human stuck a hand in the middle look anything like these, correct? Remember that question?
I remember a question like
And
that.
you said no, but, and then you were cut off. Remember that?
Yes,
Can you finish that answer for us?
yes. So animals and dogs in particular can inflict a wide variety of injuries on the skin, from just individual puncture wounds to abrasions where there's a scratching of the skin, to where there's actually a pulling away pulling away of the skin from the underlying tissues, your ripping effect. And so there's a variety of wounds that or patterns that one can see from an animal attack. It depends a lot on the thickness of the skin, the movement of between the victim and the animal, and also the power of the animal and the training of the animal. Yes.
So in other words, not all wounds inflicted by a particular animal are going to look exactly the same.
Correct.
Very dynamic situation, isn't it?
Objection.
Sustained.
Doctor, having seen up to 1,000 bite and claw marks on the human body, and based on your review of the entirety of the case file that you reviewed, including the nature and the pattern and consistency of the injuries that you saw on Mr. O'Keefe's right arm, what is your opinion to a reasonable degree of scientific certainty about the nature of those injuries?
Objection.
Sustained.
What is your ultimate conclusion and opinion about the injuries that you saw and that you reviewed and that we saw today?
Objection.
Sustained.
Asked and answered. She'll let Lally repeat the same thing
Can you tell
100
the
billion
jurors
times.
at the end of the day, what is your opinion and conclusion about those injuries?
Objection.
Sustained.
Can we approach?
Ask her if anything that she was asked on cross-examination by Mr. Lally has changed her opinion in any way. Has your opinion been revised as the result of any of the questions you got from Mr. Lally? That's all you have to ask. It's sustained because it's asked and answered. She's already stated her opinion. Only Lally gets to say the same thing 500 billion times over the course of a single trial. So he just has to rephrase the question in a way that isn't asking her for the same thing. It's asking her for something slightly different. Now that you were asked all these questions on cross-examination, have you revised your opinion in any way? That's all you got to do. I would have liked to have him also have her flesh out more about the grip. She was starting to get into the grip, the bite and hold, but that's the same thing, you know. And now Lally opened that door too with it's different with the police dog. Why is it different? Well, they're trained to grip a lot harder, you know, bite in a specific way. They exert a lot more force.
Thank you, Doctor. No more questions.
You are unmuted.
Mr. Lally, you had no more questions?
No, yeah.
Okay. All right, doctor, you are all set.
Okay,
All
thank you.
set. I think we're probably taking our lunch break now. But the clothing would be in the way.
We'll take our luncheon break.
Board, all rise to the jury.
Which I think is where she was trying to go. That the clothing can interfere with the dog's ability to get a good grip on the underlying skin, and so it's gonna like slip and stuff, and they're only gonna get like a partial, you know. Considering if this is not a trained police dog doing a trained bite and hold maneuver. Would have liked that fleshed out a little bit more, but it doesn't matter. It doesn't matter. These are a dog bite. They're consistent with a dog bite to a reasonable degree of medical certainty. Not that, there's any magic language there, but that's how Bev wants it. So they got that in, reasonable degree of medical certainty. Yeah, boy. Lally is, he's about as bad on cross, maybe a little bit worse than I thought he was going to be. I knew he'd be antagonistic and argumentative, but interrupting the witness and talking over them. And I mean, if I've criticized Mr. Jackson for trying to play like tricky language games to get a gotcha, oh my gosh, was that worse? How much worse was that? And then I didn't ask you that. I mean, wow, it just comes across as being a real jerk for no particularly good reason. You got to be in alignment with the jury. If they don't think she's a jerk, then you just really, really misfired. If they like her, then they just watched you attack her, and they don't like you for that. They don't like you for that at all. How did you like... Okay, we're going to bring up the NAS report. This kills me, okay? This has been the defense attorney's tool with forensic scientists of all stripes for, over a decade now. That we've been bringing this up. I've cited the NAS report so many times. I remember one particular big motion dealing with ballistics, whole big chapter on ballistics. They have a special section that's on feature comparison techniques, which is basically the whole discipline of this looks like this. And that can include fingerprints, that can include ballistics, that can include hair and fiber, that can include odontology, just all these things where they're like, we're going to compare these features and try to get an opinion about identity as a result of that comparison. Oh yeah, and I've given you my rant on ballistics. That comes out of the NAS report. Pretty rich coming from the prosecutor who's guaranteed putting all this stuff on all of the cases, every opportunity that he's going to get. I mean, messy stuff. And then you're literally gonna be like, the NAS report says that forensic odontology is junk science. How come you didn't do some forensic odontology here with these records we have of Chloe? Why don't you just go ahead and do that for us right here on the stand? The thing I just said minutes ago is junk science. Why don't you compare these bites to try to give us an opinion about the identity of the dog? I mean, you couldn't make this up. You couldn't make this up. Well, we didn't get the lead off with Karen, which I would have loved. Definitely would have loved it. Would have been a power move. But I am not unhappy with this 1-2 punch of this very likable plow driver who is consistent with both of these attorneys. He doesn't change his demeanor from one to the other, suddenly get all defensive and wriggly, suddenly forget everything on cross-examination when he had a perfect memory on direct. None of that. Same guy with both lawyers, very definitively what he saw. Nobody would have seen it. Did see the forward edge there around 3:30 or 4. And now, it's a dog bite. The arm, it's okay. Everybody on the jury, everybody in the courtroom, everybody watching at home, you can believe your own eyes when you looked at that and thought, that looks like a dog-bitten arm. Yeah, you've now been given permission from probably the preeminent medical dog bite expert in the country that they're dog bites to a reasonable degree of medical certainty. And she answered my question that I have been waiting for from the very beginning. Were these post-mortem or pre-mortem? No, they were pre-mortem, but not so long in advance of death that there was time for a significant inflammatory response. That's why they're not so swollen. It was too close to the time of death. That's what I needed to know. They were pre-mortem injuries, because that's addressing that whole scavenger theory. You know, scavengers don't tend to come and chew on people that are still alive. Not that it's impossible. Not that it's impossible. But, you know, animals tend to be wary of humans. Don't tend to approach us very much. Even when you're sitting there like nice and quiet in, you know, your deer blind or something, they don't tend to come up to you if they know that you're there. But if you're dead, you're just dead. You're like anything else that's dead. So you're just potential food at that point. Well, guys, yeah, I don't know how long we're going to get for lunch today. I'm going to go ahead and go through some of our chats before I take my quick break here. We had a little bit of a long run yesterday because I got so backed up. And today, if we do that again, which is totally cool, like I'll take questions all day, is totally fine. But I will potentially have to take another break because it's getting really hot, and it's getting the time of the year where I got to check the trees more than one time. I've mentioned before, they dry out like that. When you put a tree in a pot, in a small pot, not a lot of soil in there, a lot of root contact with the edge of the pot, and just a lot of evaporation, evapotranspiration is happening. The trees are moving a lot of water when it gets hot. So, and this is also the particular soil you use with bonsai. It's called akadama. It's a clay. It's a special kind of Japanese. It's not specifically Japanese. It's just where that tends to be where most of it is from, because they manufacture it and, you know, we don't. Anyway, it dries out very quickly. So I might have to take another break if we're going to go long, which is totally cool, but I'm going to have to check the trees again. But I'll see if I can not get super backed up and get through some of your comments and super chats here right now. Yeah, so we were addressing this as we went to the break. I was giving you my story about my surgery I had in 8th grade where it was just local. And it was both my knees, by the way, both of them at the same time. And the only part that I remember kind of creeping me out was, so they do the laminectomy. They're basically releasing a ligament that holds the kneecap onto the rest of the knee. Whole long story about this and why they did it and was it even necessary? Probably not. But anyway, so when that happened, I could feel my kneecap moving around. Like I could feel the motion. There was no pain though, but that was the part that maybe kind of creeped me out a little bit. Because I was like, I know if I could feel this would be excruciating. But I couldn't feel it. Anyway, yeah, I don't like the idea of drilling into somebody's bone. That really creeps me out. Claudine Buzzo, I'm a firefighter paramedic. It's called a bone gun. That's how you can get an IV if you can't get a good vein. You guys are hardcore, okay? You guys are badasses with the stuff that you're able to do and deal with. Not super squeamish, but drilling into a bone, that bothers me. T, what if how much did Proctor pay this ME? I don't think she was all that beneficial. I really don't. She was so accommodating to the defense, willing to entertain all of their possibilities. Didn't push back, not like Dr. Russell here pushed back when he tried to suggest, you know, well, it could be something else. She's like, nah, to a reasonable degree of medical certainty, nah, this is a dog bite. I understand that Emmy, she said, you know, she's not from Canton. She's not normally in that office over on the Cape. She's actually over on the whole other side of Massachusetts. So I don't know that she's really part of the club, part of the culture over here. Maybe doesn't have as much either to gain by buying into their theory or to lose if she doesn't. Bird with a super sticker. Thank you so much. Appreciate that. Aunt Betty defeated Lally. He's going to have a rough couple days here. He's going to have a rough couple days. And we're already flying through these defense witnesses. How long are they even going to need? I got to wonder. Steve Barrett, could the defense attorney reintroduce the photo of Colin Albert's scraped knuckles and ask her if the injuries to both John and Colin be consistent with the physical altercation? I'm sure Bev would have stopped that just on the basis of, one, it's beyond the scope, you know, of her autopsy to look at Colin's knuckles. And two, just it's too right on the nose with the third party culprit. And she's been very, you know, very consistent about not letting too strong of a finger pointing type of evidence be brought in, you know, something that points the finger at somebody specifically. So I seriously doubt she would have allowed that. But it did cross my mind too when she was up there talking about injuries from a fight. That would have been funny to put those up. Would these be consistent with the types of injuries that you would expect to see in a fight? She could wiggle around that. This is a living person, you know, like Dr. Russell pointed out. Forensic pathologists deal with dead people. They don't deal so much with the living injuries. That's what makes Dr. Russell so unique, is the fact that, yeah, she looks at both dead people and alive people. A massive volume of them in these acute injury types of situations. What an amazing expert. John Duncan, wait for us. Bring it now, David. It's your turn. I've been waiting. I have been waiting. I took his words to heart. Honestly, I haven't even really needed to wait because we got so much of the defense case from the Commonwealth. They're not going to need to call, you know, a ton of their witnesses on their list because the Commonwealth already did it for them. So much of the defense case is already in front of us. I really haven't had to wait that much. But yeah, now the bonus on top, not just the problems with the Commonwealth's case, the stuff on top. That's what I'm waiting for. I want to know what they have. Do we have other proof of a cover-up? Do we have other proof of consciousness of guilt? Do we have things above and beyond what we just got from the Commonwealth with the butt dials and, you know, so on and so forth? Can't wait to find out. Theory neutral, re-Bev bias. Recall the early anti-allegations, whether true or not. Now imagine the subsequent prolonged harassment, KR movement. Ergo. I mean, yeah, I can see how she'd be antagonistic to Karen Reed once the perception was out there that you're aligned with the Commonwealth and with the prosecution. Yeah, people are probably not going to like that. This is the downside of the kind of high pressure public strategy that's been going on in this case. Is that people are going to react to that. I mean, you're going to have Jen McCabe's out there screaming about how she's a victim. You're going to have Lizzie Proctor's out there trying to get people on Facebook to lose their jobs. I mean, you're gonna raise the temperature quite a bit surrounding all of this. And yeah, that if you're gonna put the judge in the middle of that, that's a hot seat. So yeah, I can understand how she would be resentful of the defense if she has taken public heat for that. I don't consider myself to be, you know, applying heat to her on the basis of just connections. I'm looking at what she's doing here in this court and having a problem with it. So in that respect, I would have no criticism of her if she had just ruled fairly and evenly across the board, consistently, and applied the same standards to both parties. I wouldn't have a big complaint about that, because I understand lots of people will say they have a connection with you. They'll try to leverage you for their own benefit. Yeah, this is that triangulation thing that people like to do. I'm going to insert the judge in between me and this person that's attacking me. I'm going to put this lawyer in, you know. I know this lawyer. You're going to hear from this lawyer. No, you're not going to hear from me. We've never talked about your case. But people will do that kind of thing all the time. It doesn't mean that it's legitimate. You know, so I would not have held the anti-Bev stuff against her at all. What I'm holding against her is what I can see with my own eyes, with her own pattern of ruling, her pattern of treatment of these people. And, you know, just yesterday, sucking up to the Commonwealth for bringing an obviously facially inappropriate motion to bring in, she was hiring a lawyer as consciousness of guilt. Like, on what planet would anybody with a legal degree, a legal background, think that that's okay? No, you don't suck up to the Commonwealth for doing that. You express dismay at their judgment for bringing it in the first place, if you're going to say anything at all, and not just give your ruling. Brian Elliman, Lally seriously rested, and the last thing the jury heard was there are multiple valid explanations for the injuries. Great job. I mean, it's just the conclusion of a series of strategic decisions made about this case that are just inexplicable. Just inexplicable. I don't know why you would end with this. This was not strong. If the strongest thing in the Commonwealth's case has been, I hit him, seems like we would end with that. We would have held firefighter Anthony Flamati until now, and we would end with that, right? That's one of the strongest things. The broken taillight, her taillight was busted after she hit John, and so then the 8:30 a.m. dash cam seems to show something kind of off with her taillight. Hold that for now. Leave the jury with something strong. Something that really tends to corroborate your case. Because this is just stumbling, catching your own feet, and barely getting over the finish line here. Yeah, could have been anything. Could have been consistent with all of these things the defense has suggested. Getting punched in the face and getting knocked out and falling back and hitting your head. Yeah, it could be that. Your Honor, the Commonwealth rests. I can't explain it. I really can't. It's like the guy has never done a trial before. I mean, I know that he has. I do. I know that he has. But you wouldn't know it from how he's performed in this case. Experienced 1-0 is now a YouTube member. Welcome to the crew. Hope you enjoy your time here. Jaragon, the defense could rest right now and the Commonwealth has already belabored the point that Karen is innocent. LOL. Yeah. I mean, there was never any chance the motion was going to be granted. You do it anyway. And that's essentially going to be what the arguments to the jury are going to be, right? That's essentially what they're going to be presenting. They're going to fill in a lot more of the details. And now, of course, we're going to have a whole defense case that the defense is going to be able to pile on top of the problems with the Commonwealth's case. But it's going to be up to the jury to decide. But yes, if they just rested, do I think they would probably get an acquittal? Yes. Yes, I do. This is just driving the stake through the heart of this case. Be rational and nice when in this global sandbox. Court helps FBI, PD, DA, judge et al. Investigate. They have a lot of, in this particular jurisdiction, oversight over the discovery, particularly third-party discovery, and what the people are allowed to go after and not. That varies a lot state by state. So in my jurisdiction, in Superior Court for felony charges, I don't have to go get the court's permission to send out a subpoena. I can subpoena whoever I want, whatever I want. It's my ethical responsibility that keeps me constrained to, looking at things that are potentially relevant. I have to have a good faith basis that I think this is legal. The request is legal. I'm not seeking out something that I'm prohibited from asking for. And that there's a reasonable, good faith basis to think it will lead to the discovery of admissible evidence. That's it. It doesn't have to itself be admissible evidence. It just has to further my thought process, my investigation, my thinking to help me understand what admissible evidence there is likely to be out there. So I have to give notice to the state, and they can object. The person I send the subpoena to, they can object too. But we don't have this role of the court kind of getting involved and overseeing and saying whether or not I get to do my investigation. So I understand it's different in different jurisdictions, but it does seem a little bit odd to me. I understand the premise behind it is that we're protecting the third-party people from the undue intrusion of the court process. I get it. But you can let them raise that, you know. You don't have to have the judge in there as an intermediary kind of acting on their own behalf. So just different systems, but yeah, she does have a big role in deciding what they even get to look at. Charles Argo, James Brown, I Feel Good. Yeah, that would be a good song. That would be good. That would be a good song. Salt Cod, farce trial to ensure guilty never see court. That is a possible explanation for what we've seen and why this case has looked like a defense of the McAlbert clan, doesn't it? Doesn't it? Very little effort, even from the outset, into proving that Karen Reed was guilty. And then only when she has made it clear she is going to defend herself and even started to outline some of the parameters of what her defense is, then they'll go and investigate witnesses. Then they'll go and interview people. The eyewitnesses, the people who were there at the scene, the Ryan Nagel, all those guys. Tristan Morris interviewed the first time during trial. They spent so much money and energy and attention on that 2:27 a.m. Google search and trying to evaluate when exactly did this happen? What does this mean? Compared to, I don't know, what caused these injuries on John O'Keefe's arm? Getting a reconstruction, like a legit reconstruction by a qualified person. How did this motor vehicle incident that we're alleging happened? How did it produce these injuries and this damage to this vehicle? Didn't spend a penny on that. No. Spent it defending Jen McCabe's Google search history. So, raises some questions about what's going on here. Genitals is a YouTube member. Welcome. Welcome, sir, ma'am. And John Duncan gifted some memberships. Thank you so much. Thank you on behalf of everybody who got one of those. Quite frankly, Samantha Teresa, Andrea, was it really time for Ms. Little to practice lawyering because the defense needed a clear hammering home their biomechanical expert opinion? Was putting Little on for this witness a mistake? I would have liked to have seen more. Like I said, I would have liked to have seen that foundation really strongly established, that the types of questions that they're asking about how injuries are caused is beyond the scope of her expertise as a medical doctor. She volunteered it, not a biomechanical expert. That's the kind of person that you need. I don't know if I want to say Ms. Little made a mistake there or anything like that, or she did it wrong. I mean, the problem is that as many lawyers as there are in the world, there are so many approaches to the case. And I am not Karen Reed's lawyer. I am not behind the scenes. I don't have access to all their stuff. I haven't been involved in the trial strategy. So they know so much more than I do. I don't want to be too critical of her performance like that. It does seem to me that it looks like, she is green. And so because of that, she needs to be more disciplined and stick to her script. Don't veer too far off the pathway that you've already planned out, because you can get in danger. And if you don't have experience with that, you may not know how to deal with it. Even the experienced lawyers can get caught. We saw David Yanetti take a hard one on the chin with Matt McCabe volunteering the they. He asked question too many. Who is the they in the group chat about the tell them the guy never came in the house. And Matt McCabe came out with Channel 4 News. That caught him, because he's been leaning on it being the police that they were supposed to call, that they were supposed to tell that story to. So even the experienced people can get hot. They can get caught. They can make mistakes. And the less experienced you are, it's just so much more important to stick with your script. They didn't know she was going to say that. If they knew the doctor was going to say that, would they have maybe put one of the more experienced people on to be able to develop that? Maybe, but they just didn't know. And hindsight is helpful for understanding how things unfolded the way they did, but they don't give you any insight into what you should have done without that knowledge. So I'm not prepared to say they shouldn't have used her, but I am willing to say that, yes, I wish they had gone further. Once she opened that door, she gave them that opportunity. It was there on the table. I feel like that was a missed opportunity. None ya business. Thank you for your coverage of the Karen Reed trial. I appreciate your educational insight. Your trial reaction is easily the prime of law too. Well, thank you so much. Enjoy having you all here. I've had a lot of people here the last several days. Really enjoyed. God, our playlist that we got today, fire. Good stuff. Good stuff in the playlist. And then all of these people with their expertise, you people here in the chat that know how to drill bones to put in IVs and have actually done that yourself. I love that we have all of that type of input. Love having all you guys here. Lori J, would you poll us now where we are all landing from Commonwealth, proof versus no proof? I will, when I'm about to step out to take my little break here, I will look and see if I can figure out how to do a poll. I've never done one. So if I can figure it out, I will put that up. Fighting Usyk, stick a fork in it. KR on the beach next weekend. We can hope. 4th of July. 4th of July would be a great time to celebrate the justice system of this great nation working the way that it's supposed to. That would be good. Vicky McNamara, honestly, two of the most impactful moments to me so far were MM saying, tell them the guy never came in the house, Matt McCabe, yep. And when Allie said Colin wasn't there when John was, emotionally, those two stuck with me. Everybody is going to have, the different things that stuck with me. And it's funny, it's funny to me with the group text, because I know this one just resonated with so many people. They called him the guy. This is supposed to be their good friend, and they're concerned so much about justice for him. For me, the one of the group texts that was just jaw-dropping, horrified me was, if they didn't ask Carrie Roberts, they didn't do a deep interview or whatever, didn't do a hard interview, ask all the right questions, that's on them. To me, that said everything. That just said so much. They aren't interested in justice. If they were interested in justice, they would be making sure the investigators asked everything they needed to ask, that they got all of the information that they needed, and not it's on them if they fail to get something. No, if you care about the investigation getting the right result, if you found out they failed to get something, you would get it to them. You would get it to them, not that's on them. So it's going to be like that in the jury room too. Everybody is going to have the different things that resonated with them. Everybody coming up with 12-10. That was another one for me. It's kind of related to that. Allie saying Colin wasn't there when John was. Well, how would she know, right? Because she wasn't supposed to be there at all. She doesn't know when John was there. She was just there to give him the ride home. So yeah, I can see that one sticking out. But everybody coming up with Colin left at 12:10. I mean, just way too specific. Way too specific. Cargo pilot guy, will you be in the courtroom for the Kohberger trial? I am planning on it. Yes, I am. I am planning on it. That one will almost certainly be live streamed at this point too. So there's going to be a big online audience. But it's right here. I want to see it go down in person. Not that there's necessarily, any big advantage to doing that, but there are sometimes, you just see the jury for one thing. I definitely would like to see what's going on with that. And then just sometimes, things happen in the hallways or, whatever. So, yep, I am planning to be there for that for sure. Track worker, if they had gone into house, blood would have been on the floor. We'll never know. We'll never know since they never did. Fighting Usyk, her FU will be the movie book deals. That'll just be the extra. That'll be like that'll be the second hand. That'll be the second hand. But I don't disagree with you. I think that I would read her book. Of course I would read her book. Of course I would. I would buy it and read it. And I can see that argument. Let her tell her story when she's got really only something to gain from it and not really, not this potential downside of it being the wrong call at trial. Because you would regret that for a long time if you made the wrong call. Palmyra Productions is gifted a membership. Thank you so much. Desert Cat, with what we know so far, do you believe Karen Wrights has a civil rights violation against Canton PD, state troopers, individuals, Morrissey, or all? So I'm definitely not a civil rights expert. Not something that I've ever gone down as far as, filed a case or anything like that. Everything I know about it is just collateral that comes up because there's issues in my clients' cases and they want to know what type of recourse they have. And I, am 99% of the time going to refer them to somebody else to try to answer those questions, somebody who does this type of work. What I can say is this: the civil rights violations, very, very hard to bring, very hard to prove. The qualified immunity is the big hurdle that has to be overcome for the law enforcement officers. With Morrissey, the prosecutor, nearly impossible to get him. He has more than qualified immunity. He has absolute immunity. So does the judge. Those people are pretty much untouchable. Non-law enforcement witnesses, you would just bring a regular tort action. You wouldn't have to bring a 1983 claim. So if you can prove fraud, some type of intentional infliction of emotional distress by, fabricating a case against you kind of thing, you can just bring that in straight tort. You don't have to overcome the qualified immunity. So the challenge then would be coming after the police officers. I brought up a couple days ago a case that I had found that deals with a 1983 civil rights action against law enforcement. And in that case, they did allow it against the prosecutor as well, because of the circumstances of that case involved fabricating evidence. And so, yeah, fabricating evidence is pretty good proof of, wrongful, malicious type of prosecution and, depriving somebody of due process and stuff like that. So I certainly think she's going to pursue it. I think with what they have, I'd be kind of surprised if she didn't pursue it. Now, the reason why she might not is just because now when you're a plaintiff in a civil case, you're paying for that out of your own pocket. People lots of times think, well, a lot of this stuff can be done on contingency. There's a very limited universe of cases that are regularly taken on contingency, and it's because they can be handled as a volume practice. They're the same types of issues over and over and over again, very specifically medical malpractice, where you'll have, the same types of problems that come up, the same types of decisions. You'll have your same pool of experts and stuff like that. Common to specialize with that. And then also, car accidents. Car accidents, very common. One of the other reasons why these are very common for contingency structure with the lawsuit is because insurance is involved. There are cases where you can early on look at, is liability going to be hard to establish, or are we just looking at damages? Attorneys like cases where we don't have to fight over liability. It's really clear the other person is responsible. The only question is, how much are they responsible for? Those make good contingency cases. Civil rights cases aren't like that. There's no insurance at the end of the road. There's no guarantee that you're ever going to be able to collect from anybody if you get a judgment. Liability is not clear. There are so many hurdles that you have to go through in order to even get to a jury in the first place. These are high risk types of cases. So that's an impediment. You need a war chest if you're gonna file a suit like this. And she has had to spend a lot of money on this trial. I don't know how much of her war chest would be available to pursue civil action. So that would be the reason why I would think maybe not. Maybe not. And Palmyra gifted another membership. Thank you so much. All right, guys, I am going to go ahead and pop out, take my quick break. I will be back shortly and try to catch up before they get back into court here. Okay, guys, I am back. Everything is good down here on this front. We're still waiting for court to come back into session. And I am seeing reports that the next witness for the defense is going to be the computer forensic expert, Richard Green. That's a very interesting choice of witnesses to leave us for the weekend. I don't know the full scope of what Mr. Green did for the defense. We know, of course, he was involved in the dispute over Hoslong to Diane Cold, and what we know about that, what we can be expected to figure out as far as the time frame of when that search occurred. He's been pre-butted ostensibly by the prosecution witnesses, but here we have him not backing down. Nuh-uh. No, you know, if they had answered everything there was to answer about that issue, the expectation would be you don't call him. You just don't call him. Go ahead and let that die. Concede that issue. Well, they're clearly not conceding that issue. Now, it's possible he did a whole bunch beyond the Hoslong to Diane Cold that he needs to testify about. So it could be that they're just sort of stuck with him. But I don't know. It's been on the table for a while. You got plenty of time to go in and bring in a new forensics person if you need to. If this one's kind of burned himself. So that's going to be very interesting. I await with interest Mr. Green's explanation of the Hoslong to Diane Cold artifacts and why are the people that we heard from the Commonwealth, why are they incorrect? Jessica Hyde and Ian Whiffen and Trooper Guarino, why are they not correct? I'm interested. Kay says, re K are testifying. They need to set the tone and get the jury firmly with them. Prime them to believe her absolutely not first. They need some groundwork. I can see this argument too. I would argue the jury has already been primed for that through the case in chief. They already know who the people are from Mr. Lally. So they don't necessarily need a lot more priming on her.
Richard Green.
And here he is, Richard Green. Forget if he's got an E at the last of his name or not. I think it does. Oops.
You raise your right hand. You solemnly swear the evidence you give the court and jury in the case now and hearing should be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. We'll take this case.
Good afternoon.
May I proceed, Your Honor?
Yes.
Sir, if you pull that microphone as close to your face as you can so your voice will be kept up, and I'd ask you to state your name and spell your last name.
Sure. Richard Green, that's Green.
And where do you
No
live,
E
sir?
at the end.
I now reside in Coldwater, Michigan.
What do you do?
I own and operate a company called United States Forensics.
And what is United States Forensics?
Sure, we're a digital investigation firm. We're licensed in Florida and Michigan, but we do cases across the country.
All right, and again, I'd ask you to keep your voice up only because we have an air conditioner there and we have jurors behind me that.
Okay,
I'll
do my best, sir.
Yeah, as best you can. Now, you are president of that company, sir?
I am.
In addition to managing the company, what do you do on a day-to-day basis?
Well, I perform the majority of the investigations. I specialize in computer, cell phone, cloud, auto video, metadata media, surveillance systems, things of that nature.
Do you work in conjunction with others?
Certainly.
Describe that, please.
Certainly. Well, we do take cases from individuals. Prefer to take cases from attorneys. So we've also worked with numerous public defenders. We've worked with a federal public defender. We've worked with law enforcement. So quite a variety of clientele.
Civil cases?
Yeah, civil and criminal. I would put it at about 60% criminals, 40% civil.
Okay. And on the criminal side, you've done both law enforcement and defense, correct?
Yeah, most of the law enforcement ones, though, have been more geared towards civil. It's when they had perhaps they were party to a suit, and it was just improper for them to use their own experts.
I see.
So that's where we've provided assistance.
All right. Now, how long have you been involved in the field of data forensics?
Sure. Well, my first case and testimony was 28 years ago. I'm not even sure we called it data forensics back then, but that was 28 years ago. And then about 16 years ago, started the company United States Forensics and been full-time in the industry since that point.
All right. Now, you'd mentioned that you'd actually testified for the first time 28 years ago. That would have been 1996, if my math is correct?
That's correct.
You were qualified as an expert witness at that time?
Yes, sir.
In order to have been qualified as an expert witness, you must have had experience before that?
Yeah, it was specifically in computers. We didn't do much with cell phones back then. By about a decade or so in computer IT, networking. We actually built a line of computers, a lot of repairs. So I was pretty deep into the computer IT world at that point.
Okay. And you say you formed your company in 2006?
Correct.
And you work full-time, part-time? What's your schedule?
It's been full-time ever since.
Would you describe for the jury, please, your educational background, your training, certifications, etc.?
Why don't we break it down into smaller segments?
Sure.
Okay.
First, with regard to the training.
Don't wait for
that
Lally
you've
to
received.
object.
Sure.
Bev,
So the
criticize his
that would
compound.
have to do with Associates of Digital Forensics.
Well, that would more be your education, right? You received an associate's degree in digital forensics?
Correct.
Okay, so why don't we start with education, since you did?
Okay. Well, that was part of the work and more or less the formal training to get that degree. The certifications, which again, this all kind of goes hand in hand, but the certification training would be the CCE, which is Certified Computer Examiner from the International Association of Criminal Investigation Specialists. I also have a certification as a computer crime related investigator, cybersecurity, as well as computer first responder. The training aspects over the last 18 years on really a daily basis, when I've worked, I've participated in listservs, done research into the newest developments in the computer forensics, and really on usually a weekly basis, we'll target some training seminar. I found in this business, even if you took like 6 months off, you would start to get behind in this business. It changes that rapidly, and you really need to do continual training.
Okay, and again, your voice trailed off a little bit at the end, so.
I'm sorry.
I'm sorry to keep reminding you, but I just want to make sure everybody hears. With regard to the amount, your caseload at USA Forensics, can you give the jury some idea of how many cases you handle on a yearly basis or have handled historically?
Yeah, we average, I'd say between 100 and 120 cases a year. We probably get inquiries to about 3 times that amount.
Okay. And have you testified as an expert witness in the area of computer forensics since that 1996 first appearance?
Yeah, we testified about 24 times in various state and federal courts.
Okay. And when you say various states and courts, is that state court, federal court, both?
Both.
Now, directing your attention to September of 2022, were you contacted by somebody to become involved in this matter?
Yes, sir.
Remember who that was?
I believe it was Ms. Little.
What were you asked to do?
Well, there was 3 cell phones related to this case, and to provide relevance with the data on those phones as related to the incident on January 29th, 2022.
Okay, and were you aware of the owners of those 3 phones?
Certainly. It was Karen Reed, John O'Keefe, and Jennifer McCabe.
Now, I'd like to ask you first, if I can, about John O'Keefe's phone. How did you receive the data from that phone, if you remember?
Yeah, we received what's called an image file, and that's a forensic term that we use. Essentially, it's a copy of the data that's encapsulated into a single file. In this case, it was a zip file.
Did you examine that data?
I did.
What were your goals during your examination of John O'Keefe's phone? What were you looking for?
Well, initially what was reported was the location data. We wanted to get an idea of when he had arrived and anything else that we could tell from that as far as location.
And when you say when he arrived, do you remember the location that you were asked to learn when he arrived?
Yeah, 34 Fairview.
In Canton?
Yes, sir.
All right. Were you able to determine, as a result of your examination, approximately when his phone arrived at 34 Fairview Road according to the location data?
Yes, sir.
And how did you do it?
Sure. Well, I say we, so that's proverbial we. I extracted the location cache data, which is stored in the on your phone, and it's in the certain location. We exported that out, and then we use a tool called CellHawk, and we import it in there, so it can take literally, thousands of data points and automate that process to specific GPS locations, and just as importantly, the range of accuracy that location is reporting.
Okay. So according to the process that you underwent, what time did the location data indicate that John O'Keefe's phone arrived at 34 Fairview on January 29th, 2022?
So the first one right to the driveway was at 12:24 and 28 seconds.
12:24 and 28 seconds.
Correct.
Now, if I asked you to filter John O'Keefe's location data within an accuracy of 3 feet using CellHawk, could you try to do that?
Yes, sir.
In fact, did you try to do it?
I did.
When?
Last night.
Who asked you to do that?
You did, sir.
I may approach, Your Honor?
Yes.
No objection from Lally on that? He's happy. Look at him smiling.
So I placed that document before you. Could you familiarize yourself with that and look up at me when you're done?
All right.
Recognize that?
I do.
What is it?
So this is a screenshot from the CellHawk program. It has a kind of a central box here that says database settings, and this is where we apply a certain filter.
And what filter did you apply?
This was for the accuracy of less than or equal to 3 feet.
With regard to what?
Oh, John O'Keefe's location data.
Is that an exact? Is the data on that document exactly what you received when you used the CellHawk program to filter the data?
Yes, sir.
I would offer that, Your Honor.
No objection.
No objection. Lolly knows what's coming.
No objections.
I just
I'm
want to
sorry, I
smile
thought you said
with him. He's so
objection.
smiley. I want to smile right with him. Look at his
So
glee.
you need to give it to Madam Court Reporter?
I'm all
He's just
flustered.
gleeful.
Sorry.
He's having a great day. I suspect I'm going to have a great day
And if the
too.
witness could have that again.
Thank you.
With permission, I'd like to publish that, Your Honor.
Okay.
Well.
So-
Let's see.
Mr. Green, what are we looking at?
Okay, so that is the screenshot from the CellHawk.
And what can you tell us
Welcome, Kat.
of what you learned from that exhibit?
Well, yeah, I'll just use the pointer here, might help. You can see up in this part here, where this is where we apply the filter for 3 feet or less. That'd be the accuracy. And then it actually returns 0 results, meaning all of the data within there had an accuracy rating higher than that 3 foot. It could be 5 meters or 10 meters, but none of it was granular enough at a 3 foot or less accuracy level.
Oh, and if you had inputted accuracy of within, say, 500 feet, what would you find?
Yeah, you would see then a large number of circles, each circle representing the meters that the accuracy would be related
So this is
to.
impeachment of
What's really
Guarino.
important to understand, though, is
Trying to
you
say
don't
the
want to
3 foot
look at
accuracy
just the middle of the circle.
John's location.
That accuracy indicates it could be anywhere in the circle. So if you saw one and it encompassed 2 or 3 houses, you could only draw that inference of somewhere in that circle. So it's kind of like how the hurricane, they say don't just look at the cone, right? Because it could be different than that. Also, the accuracy, this is Apple's best guess of what the accuracy is. So it could actually be different than that. It's Apple is using a number of services, and they're giving back the best estimation that they can for the accuracy.
Okay, so we've talked about the location cache data and where it put John O'Keefe's phone in terms of arriving at 34 Fairview, but was there also Apple Health data on John O'Keefe's phone during that time?
Certainly, yes.
Is Apple Health data generally accepted within the forensic science community as being reliable?
Well, the Apple Health data comes from something called Health Kit, but it's integral to the iOS system. So anyone that has an iPhone probably seen Apple Health data, and it's known to have extremely valuable data that the forensic tools work with and present to us. The degree of accuracy, it depends on the type of data that's being pulled out on the artifacts. For example, steps are known to have an accuracy of around 98% on the actual steps occurring.
So if the Apple Health data returns, for instance, steps, 20 steps within a certain time period, 98% of the time Apple's going to be right?
That's what studies have shown.
All right. May I approach the witness, Your Honor?
Yes.
Do you want this back? Okay.
So he's saying it's been validated by testing.
Mr. Green, I've placed another document before you. Do you recognize what that is?
Yes, I do. This is this lists out Apple Health data for that was from John O'Keefe's phone on January 29th, 2022.
All right. That came from the data that you received, the image file of John O'Keefe's phone, correct?
That is correct.
I would offer that, Your Honor.
Mr. Lally?
No objection.
Give that to me. And with the court's permission, may I publish that, Your Honor?
Okay.
Specifically, I'd like to start with page 2, record 2. Hey, Mr. Green, are you wearing the right glasses to be able to see the scene?
Yeah, I probably need bifocals here. I keep switching glasses, but
Are you able to read what is on the screen? And if it's easier, you can look on your document in front of you. It's page 2, record 2.
yeah, I think I'm going to have to do that. I can probably still see good enough to do the laser one. I'm sorry, which record is this you're looking at?
Page 2, record number 2.
Okay, yes, I have that in front of me.
Okay. What does record number 2 show on page 2 of John's Apple Health data?
Sure. So this is the number of meters. It's listed as 87.74, and the time is listed between 12:21 and 10 seconds. And there's a milliseconds after that, but I'll just round it off to the second if you don't mind. So 12:21 and 10 seconds to 12:24 and 22 seconds.
Okay. And you said that it showed 87 meters traveled during that time period?
Correct.
And with regard to that same time period, 12:21 and 10 seconds and 12:24 and 22 seconds, please turn to page 5. And Mr. Bates, if you would zoom in on record number 2.
I have that.
Okay. What does record number 2 reflect?
Again, it's the same time period, and the steps taken is recorded as 80 steps.
Okay, and you said the same time period, so again, 12:21:10 to 12:24:22, correct?
Correct.
All right, now I'd like to direct your attention to page 4, record number 1. And if Mr. Bates, you could post that.
In comes Lally on cross with the 2% error. So let's ask him if you can wave your phone around to get steps.
Sure. So this indicates 3 sets of floors. That represents elevation change. So it doesn't indicate to us up or down, but 3 steps. And the time period for that is 12:22:14 to 12:24:37.
Okay, did you say 12:21:14 to 12:22, I'm sorry, 12:24:37?
Yeah, 12:22:14 to 12:47:37.
I see.
Okay.
And with regard to all of this data, the 80 steps,
So
and
another
the
15
3 flights of
seconds
stairs
after
that you
the
mentioned,
meters.
Is it possible to pinpoint where within the time frame that's given those steps or flights of stairs were ascended or descended?
No, the most granular we can get is the time period, and it doesn't signify as any more likely at the beginning of the time period than at the end of the time period than at some time in the middle. And if you think logically, like distance traveled, that doesn't happen at a split moment. It happens over a period of time. So it's time is a factor in that equation, and this is how the Apple records that data. You got to look at the time overall.
Okay, so you don't know if it's the steps are bunched up toward the beginning or toward the end or more evenly spread out?
No, I would not be able to tell you that.
Now, we've discussed the Apple Health data. I want to go back for a second to talk about the location data on the iPhone. Does that data that you've already talked about in terms of the arrival time that it gave for John O'Keefe's phone at 34 Fairview, does that arrival time fall within or outside the range of 12:21 and 10 seconds, or 12:21 and 10 seconds and 12:24 and 37 seconds?
Well, that certainly indicates an overlap, but the health data is ending after the arrival, and we can.
Now, I'd like to discuss with you the concept of clocks used by apps on an iPhone.
Sure.
Are you aware of the 3 different clocks that are used by iPhone apps?
I am.
What are they?
We have 3 separate internal clocks. You have a monotonic clock, a baseband clock, and a wall clock.
Okay, and is the wall clock also called a display clock?
Yeah, that would be also a common name for that.
And what is the significance of the existence of 3 clocks regarding different times that may show up within these records?
Sure. Well, app developers can access Apple program library, and they can call upon any of the clocks to use within their apps.
Okay. Now, in your investigation and examination of this case, did you find examples on this phone of different clocks being used?
So in this particular case, I had reprocessed the data with the newest version of the Axiom forensic program. It's similar to Cellbrite. There are competitors to Cellbrite, and we use both programs. And this newest version had a feature in there where you can filter for the Waze application. And again, just following up and seeing how this functioned, we filtered for the Waze application. And for the first time, we saw this monotonic timestamp being related to the Waze application.
Okay. I want to show you Exhibit 640, if I may approach, Your Honor. Sure.
So we know which clock it used, and then we'll be able to show that clock is off by however many
I've
minutes.
placed Exhibit 640 before you, sir. Do you recognize what that is?
Yes, sir.
What is it?
So this is a screenshot from the Magnet Action Program I was referring to. It's the 8.1, actually it looks like 4287, but
Keep your voice up, sir.
I'm sorry. Yeah. So it's the newest version of the program, and we have it filtered for the Waze app, and it's giving us the timestamps associated with it.
With the court's permission, may I publish that?
Okay.
There you go.
And first of all, are you, no, that writing is probably too small. I can't read it.
Okay, thank you. I'll go off of this one.
There we go. With regard to what we are looking at there on that part of the screen, what are we looking at, Mr. Green?
Okay, so this is listing details of this particular artifact, and you can see that this is bundled. The com.waze.iphone, that's a standard bundle type name where it always starts with com dot and then the application reference.
And what does that mean? When it says, it's highlighted on the screen, com.waze.iphone. What does that mean that we're in right now?
Yeah, well, this is an artifact specifically related to the Waze program.
Waze app.
Yes, sir.
All right, go on.
Okay, and we can see here our entry for the monotonic time, the baseband time, and the display time.
And what did you notice about the relationship of the three of those?
Certainly. Well, most noticeable about this, the monotonic is running a little over 3 minutes ahead of the display. So that, I think it's 3 minutes and 1 second, give or take a little. So, in a lot of cases, 3 minutes may not seem like much, but in this case, this struck me as important to. Objection. Move to strike.
Sustained. I'm willing to strike that. Next question.
Okay. I apologize.
That's okay.
You can hand that back to Madam Court Reporter.
Certainly.
He can't say it's important in his opinion as the forensics guy.
Mr. Biggs, if you can put that back up. And this was to be page 2, record number 3. And you don't still have that in front of you, do you?
Actually, I do.
You do.
I do.
Page 2, record number 3, sir.
Yes, sir.
What does that show?
All right. Okay, so this is another entry from John O'Keefe's cell phone data, and this records 25.46 meters occurring between 12:31:56 and 12:32:16.
Okay. And directing your attention to page 5, record number 3, you could tell the jury what that shows, and if we can have that displayed as well, Mr. Vince.
Certainly. So this is directly related to the
After Jen texted him,
distance, and this is recording 36 steps, and it's the same time period, 12:31:56 to 12:32:16.
Okay. So we have 36
Pull
steps
behind
being
me.
taken according to Apple Health data on John O'Keefe's phone for a time period that ends at 12:32:16.
Objection.
Sustained. Ask it differently, Mr. Newman.
With regard to those 36 steps, do we know where within that time frame they were taken?
Sure. Let me reread that here. We January 29th, 2022, 12:31:56 a.m. It's actually 12:31:56.109 a.m. and 12:32:16.507 a.m.
Okay. All right. So now I'd like to switch, if we can, to Jennifer McCabe's phone and your analysis of that. During the course of your examination, when you reviewed data from her phone, did you find a particular artifact of interest?
Yes, I did.
What did you find?
We found a Google search that happened. First of all, the search was how long to die in cold. and it happened at or before 2:27 a.m.
All right. Where was that search found?
Sure. So the artifact on that was called a Safari Suspended Tabs artifact, and there's a database associated with that called the Browser DB database, and in a company file, which is by the same name but ends in WAL, which stands for Write Ahead Log. And the write ahead log is where the data first gets written to, and then at certain points, that data then gets committed and written to the main database.
All right. So that, if I'm correct, that browserstate.db/wall file, that's a temporary file, right?
It's temporary by nature, but it's not, it's integral. It's part of the way the SQLite functions. So it's not like a throwaway file. It's part of the way the whole system works.
And is it helpful to you when evaluating artifacts?
Certainly, yeah. Just by nature of it, we'll find a lot of the newest artifacts in that wall file.
Now, how do you determine the timing in terms of the timestamp on the browserstate.db wall file?
Sure. So the wall file has different rows and columns. You can kind of think of it as an Excel spreadsheet. And in this one particular column had it was a time column. That'd be the nature of the data going into it. And this the heading on this particular one was last viewed time.
Okay. Regarding that Google search for HOS long, and I say HOS, HOS long to dry and cold, found in the browser state DB wall file, what was the date and time for that artifact?
Sure. So that's recorded in what's called Apicocoa time, and it's actually the number of seconds since January 1st, 2001. So you end up with this large number, but that gets converted to present to us something that's human readable, and then you have to apply the offset for the local. So once you do all those calculations, that's where we get the January 29th, 2022 at 2:27 in the morning.
The specific, do you remember the number of seconds after?
I believe it's 40 seconds.
2:27, 40 seconds.
Yeah.
Okay. And in what state did you find that artifact?
Yeah, so the specific artifact, or it comes from a record, and the record number on this is 4028, I believe, and it was in a deleted state.
Okay. Now, what would you normally expect to find along with the artifact, sir?
So you'd have the date and time, the URL, which the way the URL presents itself, we know that it's a Google search, but you also see a history of other places that tab has been.
And with this particular artifact, did you learn the full internet history of websites related to that record?
No, that wasn't possible. We were only able to get the one website. I would say,
And I'm sorry.
I'm sorry, go ahead.
I interrupted you. Sorry.
Well, no, so we definitely got the one artifact, the Google search, and we have the time related to it, but we do not know everywhere else that tab had been.
What significance was there to you about the fact that the full internet history related to that record could not be recovered?
Well, I wanted to do a little deeper dive into that, and so I used some various other database specific tools. One was called Belkasoft X, which has an excellent database viewer in it. Sanderson Forensics, which is known to specialize in this type of work, and
That's what Jessica Hyde used.
ArtX?
I'm sorry?
ArtX?
You saved me. Yes, ArtX, which is a program known in the community for research.
And how did you sort of cross-reference the three of those together? How'd you use them?
Yeah, so all three of those tools, along with Axiom and Cellbrite, which they do have a low-level SQL viewer as well. So I looked at the data with all 5 of those tools, and I found it to be consistent amongst all the tools.
And in addition to using those tools, what else did you do?
So I wanted to get a little more context. One thing with this artifact, it is deleted. And one thing about deleted data, sometimes you get it all back, sometimes you don't, sometimes you get a fragment. Deleted data makes it very difficult to give you the whole picture of what's happening. So in this particular case, I want to see what other artifacts were around this time as it related to web history, and particularly this browser database file.
And so what do you compare the 2:27 a.m. search to in order to gain more information?
Exactly.
I'm sorry.
What the information was. So what we found is that when we looked at a particular URL, a particular website that was visited, and then searched using that URL, the browser state database entry is the last entry in all of that. So we could see searches, videos playing. There's an artifact called knowledge C that records the user's activity, but the browser state is the very last entry on the items that we observed.
And did you find other examples of that you can speak to before this jury?
Yes, I believe we have one printed out there.
Okay. May I approach, Your Honor?
Yes.
So this is, I think, contradicting Jessica Hyde saying that the DB like backdates or
Place the
something.
document before you, sir, if you could familiarize yourself with that.
He's saying no, it's created
I
after
have
at
it.
the conclusion of the search.
Okay, so this is another screenshot from the Axiom program. And it is showing a search that we conducted for raining men. And then it takes that search, and we have a couple different items on there. We set the date to begin in 1970 and ending in 2100. In other words, we only wanted to see artifacts that had dates associated with them. And then we listed them from the newest date to the oldest date. And this particular one, again, it ends up with the Safari suspended tabs artifact being the very last in the series of dates and times.
All right, I'd like to go through that, but first I'd offer it into evidence, Your Honor.
Okay. Any objection?
No, Your Honor. There you go.
Is this defeated, Lally? No, Your Honor.
It's 6:54.
And with the court's permission, may it be published, Your
You
Honor?
want this?
Yes.
Okay.
Well, I do feel like this is much easier to understand
Okay.
than the Commonwealth's experts.
So we have a number of columns here. Could you explain to the jury what's going on with that exhibit?
Certainly. So I'm gonna switch glasses back here. Forgive me.
Do you need the light on, sir, or are you okay?
No, I'm fine, Your Honor.
Okay.
Thank you much. I can certainly do this. So we are looking at here web-related history, and also I have the filter turned on for application usage because there are some log files, sort files that the iPhone keeps track of to record user interactions, and that can give us a idea of the history as well. And then, as I mentioned, we have it filtered so that it's only showing dates, that dates existed, and we took the earliest possible date to a date way in the future. And then it's listed, and next to the date and time, you'll see a little arrow, and it's skinny at the top and big at the bottom. That tells you it's going from smallest, earliest time to latest time. And this particular view is showing us the last of that series, because what's relevant and really important here is that the Safari suspended state tabs ends up being the last of the entries related to that, not one of the beginning of the entries related to that.
And what is the significance of the Safari state tab being the last entry? What does that tell you?
Yeah, well, so it tells us the internet history happened before that, and the purpose of this tab on at least this particular iPhone with this very specific iOS version is to record the state of that tab when the user left that. And the the whole purpose of that is if you're on Safari, you're on a website and say you have to take a phone call or answer a text message and you navigate away from the Safari app, when you come back, it remembers where you were and allows you to pick off from there. It also allows you to hit the tab button and see what other tabs you might have open and navigate to one of those tabs.
All right, so as I see the last tab, am I correct that the time is 1:29 of 22, same day, at 2:27 and 38 seconds? Is that what it says on your?
I'm sorry. I'm definitely getting a pair of bifocals. I apologize.
That's hard to
here. I
read
feel a
for
little
us too
silly.
with that zoom. The aspect ratio is strange now.
Yes, on this particular one. So that is just moments before the Google search artifact.
The one that you previously talked about, the Hoslam to Die House.
Belong to die in the code, yes.
But all the other history of this particular artifact was before that time, correct?
Correct.
So with regard to what that tells you about when the It's Raining Men was either searched or accessed, was that at, after, or before 2:27 and 38 seconds?
I'm sorry, can you?
Sustained.
Okay, well, if you say it one more time.
All right, let me try and put it a different way. Given the timestamp of 2:27 and 38 seconds on January 29th for that Safari suspended state tab with the It's Raining Men, what did that tell you about the timing of when It's Raining Men was accessed by the user?
Yeah, well, so the indications would be that that tab was brought up and then went away from to do another tab. So it can happen less than a second. It doesn't take long to open up a tab and start a new tab. Can be done very quickly.
I'm not really phrasing this the right way to get what I want. What I want is the timing of the interaction with It's Raining Men by the actual iPhone user. When did that happen?
Well, certainly, all the activity that we have is all prior to the recording of that timestamp in the browser state.
All right, now, with regard to this particular example where the browser state DB is the last entry, so the activity happened before, was that unique on this phone, or were there many examples of this?
No, I found many examples of this exact behavior.
All right. Now, given your findings in researching these issues and how this user used this iPhone with this iOS, do you have an opinion to a reasonable degree of scientific certainty as to the timing of that search for Hoslam to Die in Cold?
Objection.
Sustained.
Do you have an opinion to a reasonable degree of scientific certainty as to when Hoslam to Die in Cold was searched?
Objection.
Sustained. I can see you at Sidebar.
Thank you.
What we don't have is qualifications. He's already said. Is it because it's asked and answered? He did say the Google search Hoslam to Die in Cold happened at or before 2:27 a.m. So the reason why this presentation makes a lot more sense to me is because he's saying he recreated it. And based on his ability to recreate this type of file, he understands how this type of file comes about. And so he didn't present it to me as a complex sort of theory of how things work and interact and might do and internal processes of the phone that are unknown and so on and so forth, which were extremely hard to follow. I don't know who is right between all of these people. And the jury is unlikely to know either, like independently who's right. They're just going to go with who makes sense. The guy who was able to recreate it makes sense to me.
Do you have an opinion as to the timing of that first search for Hoslam to Die in Cold?
Yes, I do.
What is that opinion?
That would have happened at or before January 29, 2022 at 2:27:40 a.m. in the morning.
And what is the basis for your opinion?
Again, by how this particular phone operates with that exact operating system and comparing it to other data on that phone and the way it presented it out, it's all consistent with that search happening at or before that time.
And what opinions or conclusions did you reach regarding how, if any, how the 2:27 a.m. search was deleted?
Well, we know that that's in a deleted state. And importantly on that phone is when I say, I keep using the proverbial we, I found a lot of other that would have been used or deleted artifacts between midnight and the early mornings on January 29, 2022.
Okay. Are you aware of any internal mechanisms that could have caused that deletion?
No, not in this particular case. I know of no mechanism that would have done that.
All right. And you mentioned other deletions on the phone. I want to show you what has been marked, if I may approach. Sure. MMM for identification. Do you recognize what I've placed before you, sir?
Yes, sir.
What is it?
Okay, this is from Cellbrite. It's a program, again, like the Axiom that processes data. And this is this lists out a 623. This lists out a deleted call record.
Okay. Are you able to see from that record to whom the call was placed?
Yeah, well, we have the number, and I won't necessarily read it out loud here, but through searching, and this is from the phone of Jennifer McCabe, but through searching for that the number, I was able to see that it went to, you want to say the name?
Sure.
Yeah, Uncle Brian A.
Oh.
Uncle Brian A.
I would offer that into evidence, Your Honor.
Same objection as before, Your Honor. As when this was, may we approach?
Okay.
Uncle Brian A. I mean, we know you can delete call history. That's easy to do. Did he reconstruct that also? Do you even need to? I mean, we certainly know why she would want to delete it. What time was that call? Between the midnight and the early morning of 2022, they're not supposed to be on the phone. So he's going to tell us. Yeah, I mean, best case scenario here for the Commonwealth is that the jury's like, well, we don't know. And this ends up being neutral.
So, folks, we're trying to streamline the exhibit numbers. It looks like this may already be in evidence. It's one of 4 different numbers, so I sort of wanted to keep it with that.
Good Lord.
We are so far removed
Just
from
let
where
it
it
in,
was that this will
Judge.
just come in as the next exhibit.
Yes.
So you will technically
You are
have it in
unmuted.
evidence twice.
She had told Lally to go find it in the other one if you don't want it in.
Thank you. May I approach again, Your Honor?
Yes.
It's one page. It's not a big deal.
Final document before you, if you can identify that for the jury, please.
Yes, this is another report generated out of Cellbrite. It's based on Ms. McCabe's cell phone data, and this lists out the call log with a number of deleted items and a number of live items.
I would offer that, Your Honor.
If I get to see.
Sure.
It's fine, Your Honor. I think it's already in evidence as well, but
So,
Actually, it's, I confirmed it's not. It's not yet in evidence. We looked at the exhibits that were specified, so,
there-
It's 6:56.
thank you. If you could hand that to the witnesses, if I could have.
They just go ahead and do it anyway. They don't even wait for the judge. Mr. Yanetti is driving this truck now. This Franken truck.
Okay, with regard to that exhibit, Mr. Green, what did you find that was unusual, if anything?
objection.
sustained. Ask it differently, Mr. Yanetti.
Yes. What did you find of note?
Certainly. What was the time frame of the deleted records? Now, I'll just talk about this particular report here. It starts at 5:33:47 in the morning, and on the second page, we see it ends at 8:50 and 15 seconds, again, a.m. And then the normal recalls, what we call live data, then begins at 8:59 and 34 seconds and goes on throughout the day with no additional deletions.
And am I right that those are all, that's the call log, those are all phone calls?
Correct, yeah, this is the call log.
And what was the difference between the calls that were at 8:59 and after on January 29th, 2022, and the calls that were before 8:50 a.m. on January 29th, 2022?
Yeah, well, it's the state they were found in, deleted versus live data.
I'm sorry?
Deleted data at the earlier time and live data after the 8:59:34.
What percentage of phone calls were found deleted on Jennifer McCabe's phone prior to 8:50 a.m. on January 29th?
So all right, I have to see you. Take this down for a minute, please. I have to see counsel.
Why? Oh, so annoying. What percentage of calls before 8:50 a.m. on 11/20/29 were deleted? I'm guessing it's going to be 100%. All of them. All of them were deleted until after 8:50 a.m. And then they're just fine. And they're live. Is it because it's unredacted? Do they need to be up there with a Sharpie pen? Best case for the Commonwealth is that this is a wash now. It's a wash, and the jury is like, well, I don't really know if Jen McCabe searched it at 2:27. But this call deletion record is still pretty bad.
You are unmuted.
So, Mr. Green, I'm not sure if that question was clear or if you understood it. If it's not, please let me know. But I had asked you from the first recorded call there that was listed as deleted until 8:50 a.m. or so. what percentage of calls were deleted on Jen McCabe's phone within that time period?
Yeah, so we found no live data, so 100% of them would have been deleted.
Now, are you aware of the term spontaneous deletion?
No, sir. I know what the individual words mean, but in relation to digital forensics, I'm not familiar with that term.
And do you have an opinion as to how those calls would have been deleted from that phone?
Those would have been user deleted.
I may have a moment?
Sure.
No further questions. Thank you, sir.
Okay, pretty good.
Good afternoon, sir.
Good afternoon, sir.
Do you know who Miss Jessica Hyde is?
I do.
Are you aware that she wrote a report in relation to this case,
Yes.
specifically in regard to the Google searches for Ms. McCabe's phone that you were just talking about?
Yes, sir. It was very specific about that search.
And have you had a chance to review that report?
I have.
You also know who Ian Whiffen is?
Certainly, yes.
And are you aware that he wrote several reports or submitted several items in relation to, again, the exact topic that you're testifying about in relation to the Google searches on Ms. McCabe's phone?
Yes, sir. I understand that.
And have you had a chance to review those materials as well?
Yes, sir.
You understand that they both disagree with what your opinion is in relation to those searches?
I absolutely understand that, sir.
Now, just as far as your qualifications and certifications go, I'm just having a difficult time.
Yeah, she
from
did.
The certifications that you have, at what point were you, or what if any certifications do you
6:05-ish
have
or so
with
in the
reference
morning.
to, Cellbrite as a tool as far as your use and interpretation of data from Cellbrite?
Certainly. So my certifications are much more broad. They have to do with a lot of the fundamentals and how we conduct the investigations and what tools we should know and when we need to know we need to do more work and such like that. Cellbrite, I do not have any specific Cellbrite certifications. They offer many of them. However, I have participated in, God, I can't even count, hundreds of their training events that they offer, both Cellbrite, Axiom, Belkasoff. They all provide the community with fantastic support as far as that. And although certainly a class can be very good, but you really need to stay up to speed, you've got to participate in the most recent understanding being put out there. Even in the changes of their tools will change from one version to another.
And so, to the point, as far as you have no certifications in regard to Cellbrite as a tool and how to use it, those kind of things?
That's correct, sir.
And in this specific instance, at any point, did you reach out to Cellbrite to go over sort of your findings or your opinions in relation to this search?
I did.
And who, if anyone, did you speak with from Cellbrite?
Yeah, as close as I can remember, I know it was Leo, and I believe it was Santos.
And do you know what part of Cellbrite they work in or what they do?
Well, he was in the technical support and contacted him. He had informed me that they had elevated this up to some higher level technical support when they came back. His comments to me, if you want to hear them, was that this. Okay.
Capture his comments, but at
Okay,
some point,
I understand.
you talked to technical support, is that correct?
Absolutely.
And they indicated that they would refer you to actually Mr. Whiffen's team?
No, sir, they did not.
So you weren't told that you were referred to Mr. Whiffen's team and you weren't contacted by anyone from Mr. Whiffen's team?
No, and I forget the exact date. A couple weeks ago, maybe a month ago, out of the blue, I got an email from Ms. Whiffen saying, and I can't I don't want to misquote them, but certainly I got an email
I'm not
from
asking
them.
you about any specific conversation
Okay.
you had. What I'm asking, and I'm asking about a time period more back in 2022.
I'm sorry, I couldn't quite hear you.
Back in 2022, did you reach out to Cellbrite in relation to this search and your opinions related to it?
Yes, sir.
And at that point, was that the point that you spoke to someone from technical support?
Yes, sir.
And at that point, did someone from technical support actually refer you or tell you that they were referring you to Mr. Whiffin's team?
No, sir, I had absolutely no idea about that.
So no one from no one from Mr. Whiffin's team reached out to you and then you just never called them back? That didn't happen?
Not that I'm aware.
Now, you were asked to look at a couple different phones, and I'm assuming by counsel for the defendant, correct?
Can you say that once again? I'm sorry.
You were asked to look at 3 different phones is what the testimony was. And I'm assuming
Correct.
that was by some counsel for the defendant, correct? No one else asked you to look at these phones,
Oh,
correct?
correct. Yes, it was from the defense asking to, yes.
And so the phones that you were asked to look at were Mr. O'Keefe's phone, the defendant's phone, and Ms. McKay's phone, correct?
Correct.
Now, as far as Kerry Roberts' phone, were you ever asked to look at that?
No.
And with respect to the defendant's phone, was there any GPS location information or data that you observed in her phone?
So we had an indication that location had been using, there was something called Apple Map tiles. And those probably, when you use the Apple Map app, that it, in order for it to work, it will create these little tiles or little pieces of pictures, and they get stitched together to give you the view that you see on your phone. Now, for that had to be working, we know location data had to be working. This particular location data, the location data cache, is known to only be present on the phone for a couple weeks. Now, what I don't know, and Mr. Lally, if I'm going too far, just please stop me. What I don't know are what measures were taken to preserve that data, whether it was put in airplane mode, whether the location services were turned off, whether it was put in a Faraday bag. And quite frankly, Mr. Lowry, I don't know if they did all that, if the location data would have remained or not. I've never tested that, but all indications, it would have had location data on the day that it was seized, because we received the Apple Map tile. But when I got the full extraction, there was no location data there. Now, I did observe.
So there was no GPS location data on the defendant's phone, correct? From what you observed.
And again, if I'm, there was, I did find deleted location data from April of 2022.
Interesting.
Now, with respect to the defendant's phone, did you also find deleted web history data from the afternoon of January 29th, 2022?
No, I'm sorry, I didn't observe that.
Didn't observe it, or didn't look for
it? You know, I really don't have a recollection if I specifically looked for deleted data. I don't believe I did. I don't know if I would have had to have a cause to.
Now, with reference to, you were asked some question about location accuracy within 3 feet. You did some sort of thing last night on CellHawk using that tool, is that correct?
Certainly.
And you were asked to do that after Trooper Guarino testified yesterday, is that correct?
I understand he testified yesterday.
And so with relation to you creating sort of that document, and that's now been marked as an exhibit, was that something that Mr. Yanetti asked you to do in relation to Trooper Guarino's testimony yesterday?
Well, in all fairness, you need to ask Mr. Yanetti. I could make an assumption.
You were just asked
here.
to do it, and you
I
did.
mean, if
I'm not
I don't know quite.
doing anything.
I'm not trying not to answer you, you know, but I was asked by Mr. Yanetti to perform that search.
So, Mr. Lally, please be cautious of that.
Yes, sir. So, Ms. Green, with respect to that 3 feet of accuracy, are you aware that what Trooper Guarino was testifying to in regard to that had absolutely nothing to do with phone applications or anything to do with data from a phone or a CellHawk or a tool or anything like that?
Objection.
Now, I don't know the full extent of what
It's
Mr.
for the
Guarino would have
jury.
been
It's facts,
testifying
not in
to.
evidence.
And so you're not aware that his testimony was actually in regard to reviewing cruiser camera video from the Canton Police Department and photographs of where Mr. O'Keefe's body was, and then mapping that using GPS latitude and longitude.
Objection.
Based on that within a 3 feet accuracy.
The objection sustained. Ask it differently.
Are you aware of any of what Trooper Guarino testified to yesterday?
What you're mentioning, I may vaguely be remembering, and again, I'm not trying to not answer your question exactly. My conversation with Mr. Yanetti is 3 foot. When it comes to GPS data, can you tell 3 feet from GPS data? And no, it's not known to be that reliable, and particularly Apple location services. How that applies to the trooper's testimony, I can't say with specificity. I'm happy to opine on location data, though.
There's no question.
Okay.
Sir, but that's, thank you. May I have a moment, Charlie?
Sure.
Now, sir, with reference to Safari and deleted tabs, isn't it true that there is no way for a user to delete a tab, only to close it? Do you agree with that?
Yeah, well, when you close a tab, all right, you're taking it out of the active state, and it's going to an inactive state that some people could call deleted. Now, the Safari history allows you to go in and delete history by certain date ranges, but you can also go into specific websites that you visited and delete those. Now if you want me to continue, the WAL file itself, you can't open up a WAL file and say, oh, I want to delete that record. But functioning the phone through the user interfaces will have an effect of deleting data within that WAL file.
Isn't it also true that Cellebrite uses that red X to annotate that the record is no longer active and has been recovered? It should then make it incumbent upon the examiner, being you in this instance, to determine if it was actually deleted, correct?
Yes, sir. Thank you for asking. It's yes.
That's all I'm asking, sir.
Okay. All right.
Now, you stated in your affidavit, in your testimony, that you used the Sanderson SQLite or SQLite Forensic Explorer to examine the Safari tabs DB associated with the WAL file log. Is that correct?
Yes, sir.
Now, in your analysis using that Sanderson Forensic Explorer, was there an indication that House Long to Die in Cold was found in the WAL file?
Yes, sir.
Now, with regard to that, did you independently verify the cause of that timestamp that you observed there?
Yes, sir.
Now, is it your interpretation that the timestamp means the search appeared at that time solely based on the naming of the field in the database?
No, sir.
Now, can a WAL file contain items that are so new that they're not yet committed to the database?
Yes, sir. That's the purpose of it.
So the WAL file holds the newest information until it's merged to the database, including additions, deletions, changes, all of those items, correct?
That is correct.
Now, according to your affidavit, the device was in active use between 2:23 a.m. and 2:31 a.m. And just to be clear, I'm talking about Ms. McCabe's device, correct?
Correct.
And what other searches did you see at that time, and where were they?
I'm sorry, can you repeat that? I couldn't quite hear you.
Searches did you observe in that time frame, and where were they performed?
Well, there were a number of websites, including the Rainy Men exhibit that we did. There was Ozone Basketball, I believe. There, Hockermont, Smith. And I can tell you that those, similarly, the last entry with those there is the browser state DB file. It's not at the beginning, it's not at the end, and I have a couple thoughts on why that may be in regards to Ms. Hyde and Ms. Whippen. I'm happy to share those with you.
I'm not asking you anything about that, sir. What
Very
I'm
good.
asking
No, you're
is,
not,
is it
Mr.
possible
Jackson
for a
will.
change request in the wall to a SQLite database pertaining to one particular field, leaving the other fields as what they were previously?
I want to answer your question as well as I can. So can you repeat that one more time?
Is it possible for a change request in the wall to a SQLite database pertaining to one particular field, leaving the other fields as what they were previously?
So I'm having a little trouble answering this. So
Tell us it's a bad question.
if I'm understanding correctly, when the wall file gets written to the database, and could that have made the change ending with this deleted record? Is that the question? I'm sorry. I want to answer you. I'm just
That's okay.
a little lost on how you're asking
And
it.
the question?
Sorry?
Do you not understand the question?
Why don't you move on, Mr. Mayor?
So is it possible that the URL field, which has the website name, was updated to the newest search while the timestamp retained the original search? Is that possible?
No, not the way on this particular phone in this particular iOS, and also with the user interacted with it, that it would have been at the 227 or before. The way this very specific iOS was happening, that is consistent with all the other ones that I observed out there on the phone related to specific web searches and activity.
Is it possible that the search for How Long to Die in the Cold at 6:24 a.m. was the most recent search completed in the tab?
Oh, well, not in that tab, but I certainly agree with you that there was a second search done at around that time.
Now, is it also possible that the search that you assert took place at 2:27 and 40 seconds in the morning is the same as the search that took place at 6:24:51 a.m. for that same search?
Yeah, that's inconsistent with the actual data I'm seeing on this actual phone with this precise iOS version.
Now, as far as the search in Safari with the string as far as the smotot.apple.com included, is it, you recall that search as far as being a suggestion from Apple, from the iOS, as far as the search with how long to digest food?
Okay, I didn't hear your whole question, but I heard the last part about how long to digest food, so I can opine on that. So my feeling on that is when the How Long to Die in Cold was put in, that was most likely a Apple suggestion. And I've done some testing now. The time period I'm doing my testing, is after the fact that this would have actually occurred. But as I tested that on a live phone and using a Google search, I could see that how long to digest food would come up. I also notice the specific phrase, how long does it take to die from hypothermia? So as you do this Google search, you try to repeat what's being done. Those are two suggestions that actually came up.
And so that was something that was a suggestion and not something that was actually searched, correct?
Yeah, no, and I know that's different from my affidavit from about a year and a half ago, in all fairness, but.
That's entirely different.
One person,
David, correct?
Mr. Lally,
I'm sorry.
one person at a time.
Yes.
Okay. So, yeah, in fairness, I want to give you my best knowledge, as I understand it saying here today, including after my review of Mr. Whiffen and Ms. Hyde's report. So I want to do everything I can to shine as much light and clarity on this as possible. So as I repeated, since that time and did the search, I would notice that is one of the things that would come up, and it would have a little picture of like a dinner plate or something like that. And there was actually a similar, if not the same picture found in the artifacts of that phone.
And so just to conclude, that's not what you said in your affidavit that was actually filed under pains and penalties of perjury with this court, correct?
Yes, and on that day, that is what my true and proper belief was. Okay, it's since further testing, I have found that I now believe that was probably an automatic one, and if I've caused you any distress, I apologize.
Doesn't cause me any distress.
Okay.
What I'm asking, sir, is that that's what you filed because that's what you thought at the time, correct?
Yes, sir.
And subsequently, you've done further testing, and that's shown that you were wrong, correct?
That is correct.
Now, according to your affidavit, there was a search for how long to digest food at 6:23:49 a.m. that precedes the search for how long to die, and the misspelling here would be the key CLKD at 6:23:51 a.m. Is that correct?
Yes, sir.
Now, is it possible that the how long to digest food was a predictive suggestion from Apple rather than a search entered by the user? Is that also correct?
Yeah, I don't know. I don't know the answer to that. I believe that it was, if it had picked up a earlier search from 227 of how long to die in the cold, and then you went to retype it in, it may have then tried to give you something similar at the 6:23 and 6:24 timelines. So hopefully that answers your question.
So steps, going to Mr. O'Keefe's health data, steps doesn't necessarily mean that someone is physically taking steps, correct?
Again, the research that's done for this is steps tend to be a very accurate artifact.
So steps could not also be coincided with, say, movement in a car or other sort of movement of the phone as far as the health data is concerned?
Sure. Well, I did, geez, quite some time ago, do some testing with an actual iPhone 11, the same make and model, and took a drive and tried to see if it would register steps. It did not. I sat in a chair and tried to duplicate how I thought I would walk to see if it recorded steps. It did not. I took the phone from the floor to the ceiling to see if it would record a flight of stairs. It did not. The only, with that iPhone 11, same make and model that I got, it was very consistent with me actually doing walking steps, and that was whether I had it in my shirt pocket, my pants pocket, or clipped onto my belt.
That's your testimony?
That is my testimony, yes, sir.
Now, are you familiar with GPS native locations?
Yes, sir.
And GPS native locations takes its data as far as defining a latitude and longitude from a number of different sources, correct?
Well, true GPS, okay, it's going to take it from the GPS network. What you may be thinking of is assisted GPS, which the iPhone uses, and that assisted GPS will try to, it kind of does a crowdsourcing. So it'll look at cell towers, what's in range as far as like Wi-Fi's and a number of other devices to try to get you an enhanced GPS location and give you the best data possible.
So it takes GPS native locations within an Apple iOS device, takes from 4 different sources. Isn't that correct?
It tries to get from a variety of sources, like I just mentioned. Not all would be available.
Now, with regard, did you look at any GPS native location data with regard to Mr. O'Keefe's phone?
Yes, sir.
And would you agree then that the GPS native locations didn't record any movement of that phone after 12:25 a.m.?
12:25. You know, I would have to look at the exhibit to see what the time of that last entry was. I don't want to misstate something to you, sir.
Now, you were asked about sort of the elevation change in 3 floors, ascending, descending, and saying that you couldn't pinpoint a time period or within that 12:21 to 12:24 time period from the health data. Is that correct?
Correct. It happened somewhere within that time.
Could you pinpoint more specifically if you looked at the GPS native location data?
No, well, we're talking to Apple Health and GPS location. So
But you said you couldn't do it.
I'm sorry, which one are you asking about? Please.
What I'm asking is, you said you couldn't pinpoint it within the GPS health data. What I'm asking is, if you had looked at the GPS native location data, could you give a more specific pinpoint as to where Mr. O'Keefe's phone was?
I'm going to allow that.
Maybe we can see briefly.
Okay.
GPS health data. Did he just misspeak, or is he trying to get funky with what he's talking about? I didn't understand that. Oh, so the super effective thing that this guy is doing is he just wants to be a font of information, even on cross-examination.
You are unmuted.
Guys, we were just having a super glitchy tech day today. Sorry about that. Now my camera is shutting off and on without notice. Anyway,
Now, to be
he's
clear,
making
sir,
Lally say, no,
You
I
had
don't want to
indicated
know.
earlier in your testimony
It
that
makes it look like he's
the
hiding stuff.
elevation change from 1221 to 1224, you could not pinpoint where in that time period, or specifically where in that time period the elevation change occurred, correct?
That's correct. It's a time range. Yes, sir.
So what I'm asking is, had you looked at that in the GPS native location data, would you have been able to more accurately or specifically pinpoint when that occurred?
Okay. So the location, are you looking for a yes or no? I'm sorry.
Yes or no?
I'm apparating today, guys.
I'm trying to. There was, yes, there was location data within that time period. Okay.
And are you aware that Mr. O'Keefe's phone from the GPS native location data was actually a half-mile away from 34 Fairview Road at the time that it made those recordings in the GPS Apple Health data?
Right, yes, I understand he was using Waze, and it had made that recording. I understand that. That's why the finding that 3 minute and 1 second offset brings into serious doubt if that time was accurate. And when you apply that to the location offset, then the Apple Health data and the GPS all aligns. Now, I have not decoded Waze and found out what functions they were calling and all that. And I don't mean to indicate that I have, but I mean that the latest version of Axiom is bringing that up as an artifact and a timestamp related to Waze. And in the case of here, where minutes are important, I thought it proper that I bring this to the attention of the case as a possible explanation.
As a possible explanation?
As a possible explanation, sir, yes.
The 3 different clocks that you were talking about, are you aware that those are actually associated to power usage and not applications?
Right, that power usage was directly related to the Waze application.
So it's your testimony that those 3 clocks apply to the times in Waze? Is that your testimony?
I'm saying that the timestamps were directly related to Waze. It was reported by Axiom when you applied the filter and say, show me all the artifacts related to Waze. These were artifacts that came up related to the Waze bundle. So I guess you need to give it the weight it deserves. Like I said, I've not decoded Waze. That's not something that has been done, but I think we need to consider the 3-minute offset as it applies to giving significance to the Apple Health data and the Waze GPS.
Now, turning to Ms. McCabe's phone again, as far as the search, what you indicated as last view time, are you aware that that is actually related to a time that it was actually focused on the screen as opposed to your interpretation of it?
I'm aware that from that it appears to be the last time and date it was focused, and when it was no longer was focused, that's when the timestamp was written. That's what's consistent with the other data on this particular phone on this very specific iOS.
Now, with regard to looking at this search, you mentioned that you used something called an ArtX tool. Is that correct?
Yes, sir.
And are you aware that's a tool that was actually created by Mr. Ian Whiffen?
Absolutely.
And with regards to with regard to this specific issue as far as how this data is being interpreted from the browser state DB versus the knowledge C database and the wall file and all of those, the P list and all of those other kinds of things, as far as the misinterpretation of the data has then caused Mr. Whiffen in further versions of Cellbrite to revise that so that this kind of error can't occur.
Sure, happy to answer that. So Mr. Whiffen's testing was not done with this specific version of the iOS. The iOS has been known to be changing the way this artifact works. To do proper analysis, the researcher that he is, he would need to work with that same iOS. Now, in regards to the Cellbrite question, they have two versions of the Cellbrite Physical Analyzer. One is the standard physical analyzer that's been out for several years now, probably is majority use in the community. It's a tool that takes that raw data and it puts it into human terms that we can look at and understand and write reports like you've been seeing here. So they have the Cellbrite Physical Analyzer that's out there. I believe it's 7.68, but don't quote me on that. And then they have a new version that's come out called Insights, and this operates more on a where you can put multiple cases in and that. It's only the Insight versions that they have bothered updating and no longer reporting on that time. Their current physical analyzer program, and I tested this a few days ago, still reports on that search occurring, and that timestamp. So currently Cellbrite is providing examiners, law enforcement, and people worldwide with two different versions giving two different results. That I can't speak to more than that, other than I've tested that, and I see how those programs are working now.
So my question, sir, yes or no, is are you aware that Cellbrite has had to modify their software based on misinterpretation of data, as you've done in this case?
Yes, with the asterisk, they updated one of two programs.
Nothing further.
No further questions.
Okay.
All right, Mr. Green, you are all set.
Thank you, Judge. Thank you.
Sitting a little too long. Please, with your votes.
Thank you.
Yes, sir.
All right, George, that's it for today.
What is your?
All right, so juries, we are going to send you home for the weekend. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it. We are on track. We will get this case next week for your deliberation. See you on
Court, all rise for the jury.
Okay, guys, I am here for now, but we are really fighting something going on with my camera over here. I was thinking that it's getting hot, but I can't quite tell. It keeps shutting down and booting me. So if it does it, it's super annoying. Sorry about that. I'll keep trying to fix it as it happens. Well, boy, that guy, I really liked him. What a likable person. He just made it so clear how much he wanted to be able to tell the jury about the stuff, and he put that onus on Mr. Lally to be like, no, I don't want to hear that. Right? Because then the jury is like, why not? Why not? Why wouldn't you want us to hear the full explanation? Why are you trying to be tricky here? Just let him share his knowledge. And no, they're not getting that. And then even if he does get the answer, he comes back and just that's not what I asked. No, he's not the one that comes out of that looking good. I mean, he had a very consistent explanation for how the timestamp worked, which is I did it this way in this phone with this iOS, and that's how it happened, and this is what it meant. And so he's always able to come back to that testing and what he observed, the real world data. I mean, real world data is a very valuable thing. So yeah, oof, quite a day for the defense today. Once again, we ended the Commonwealth's case with, yeah, he could have been beat up. He could have been punched in the face and fallen over and cracked his head. The injuries are consistent with that. And then it was a dog bite. No, first it was there was no body out there in the morning by the plow guy, and then it's a dog bite, and now yeah, there was a Hoslong to dying cold Google search at 2:27. He hasn't backed off that. He's aware of their opinions. He's incorporated that. He's considered that. And it doesn't change his opinion. Why? Because he went and did that validation. He went and did that real world testing to see what kind of result that he would get. And it was consistent. Last result in the DB, not an early one. And what I understand him to be getting at from that is that means it's not something that was created early and then gets revised over the course of that tab history. It's created at the end. So I don't, again, I'm not a technical person. I don't know who's right or which one of these things to believe, but he certainly sounds like he's got a good explanation for it. And yeah, explaining that issue with the three clocks, that's pretty key, because that's pretty key to the Commonwealth's explanation for that health data. Couldn't be because he wasn't even there according to Waze. Well, if Waze is 3 minutes off, then yeah, that puts him there. If Waze has got him there at 12:21, 12:22, yeah, that means if it's 3 minutes behind, that means he was there. He arrived at Fairview at 12:24:28, and then immediately took all those steps. Interesting stuff. Well, I keep looking over the defense witness list to just see, if I can kind of predict what's going to happen and who's coming. So many of the defense witnesses, they've already been called, but there's a number of people on here that I don't know who they are. Michael Wagner from Foxborough, Massachusetts, Cheryl Waugh from Canton, Massachusetts, Paul Makowski from Melrose, Massachusetts, Leslie Bernstein from Canton, Rebecca Bison from Canton. They got Chief Berkowitz. Super annoying, guys. This is so annoying. So annoying. I don't know why it doesn't want to work with me today. Especially we did 11 and a half hours yesterday and it was fine. So don't know why it's giving us all this trouble today. Anyway, I'm just starting to read off these witnesses. I don't know who these people are, so I don't know what to predict in terms of are they all going to be called? What are they going to have to say? Just no idea. No idea. So, I was anticipating a lot of what we saw today because we've heard about it before. We knew that this was coming. And so what's next? What's up for next week is primarily stuff I don't have any idea what it is or what it could be. So not sure if it's Christmas morning or, what am I going to find? struggling here. I think what I might do, if this keeps up, I'm gonna try to find a backup, just like cheapy webcam, if I can, just to try to have something hooked up so I can get through the stream, because we still have so many comments and things to get through. Carolyn, can I please get a quick summary of what happened in Aruba? I missed a few days. So the testimony was from Laura Sullivan and Marietta Sullivan, a pair of sisters who were there in Aruba, and basically testified that John and Karen went on this trip. It was a big group trip that Laura Sullivan had planned, booked all these like side trips and things like that. Lots of drinking involved in this vacation. They had a dinner with John and Karen at the very beginning, where Karen picked up the tab for everybody at the table and they thought that was weird. Then on New Year's, John hung out by the pool and got really drunk. And Karen was with the kids all day. And then at the end of the day, according to them, Marietta had got back from the restaurant and was coming down into the lobby in the elevator, where she ran into John, who was quite drunk. And she was trying to help him back into the bar when Karen came and found them and screamed, basically confronted them, very, very pissed off. And she's accusing John of, messing around with this girl who denies that that's what happened. And then later on, Karen apologized and offered to pay for the girl's room. And then they had little contact with Karen and John for the rest of the trip after that. So that's kind of the nutshell of what happened in Aruba. If anybody wants to fill in other details, please go right ahead. Yeah, that's the gist of it as far as I'm concerned. Rigid Tactical, okay. Last time I tried restarting my computer. If this does not fix it, if it goes out again, I will just switch to a cheapy webcam. So I suggest We Ready by Archie Eversole. Don't know that one. I'm going to have to add it to the playlist. I will have to add that one to the playlist, but it sounds good. Entry required, filter. Hey man, nice shot, Mr. Entry required. Isn't that the filter that you use in Axiom or whatever? Or is that a song? I don't know. Jason Sorensen. This is Jackson giving Lally a taste of his clode. I don't think that tastes very good. I think perhaps that's why we're getting that bitter response from Mr. Lally. Quite frankly, Samantha Teresa, scenario: the group was discussing Karen's text to Brian Higgins before John arrived. Colin Albert said something slick about it. John reacted, fight breaks out, adults get involved, and Chloe falls back. Possible. I mean, the whole just ego battle over the woman seems like by far the most likely motive out of everything that we've seen so far to me. Drunk guys fighting over a woman and some guy, encroaching in on another one's turf. Yeah, that sounds like a motive for conflict, maybe physical conflict, much more than we fought on vacation a month or so ago, and we argued about giving the kids donuts this morning. Really does shed some light on it when you look at those full text messages, the full exhibit that's in evidence. That is, I mean, I already sent you guys to Sleuthy Goosey. Go check it out if you haven't seen that. The stuff he chose not to include, like Karen being super nice and complimentary to John, trying to talk him up like they're having a fight. John saying, I'm always the bad guy with the parents. And she's like, everything good about the kids is because of you. And yeah, but now she murdered him. Like, she is so much nicer to him over the course of this whole conversation than he is to her. But that's a motive. No, it sounds to me like maybe drunk guys fighting over a girl. Quite frankly, Samantha Teresa, imagine a wasted Colin saying something to J.O. about BH texts, J.O. throwing a punch, and family Chloe steps in. If Colin wasn't involved, I don't think the cover-up would have happened for BH alone. That is a good point. I mean, Brian Higgins is a friend, but he's not family. He's not family. And they're not necessarily on the hook for anything, even though it's in their house. If this guy is just flies off the handle, I mean, I guess maybe their insurance or something. I mean, I can't rule it out. I can't say that definitively the only concern would be Colin being there. They wouldn't have any other concern unless Colin was involved. I mean, even just in terms of like, is this appropriate off-duty behavior for a Boston police officer? If it comes out that something like this happened at his house, at his party, I could see potentially him just not even wanting to be concerned about any of that. But it does make sense. They're highly motivated if Colin is involved. They're highly motivated, and to potentially leave somebody out there to die in the snow. Yeah, that to me would take quite a bit of motivation to get you to do something like that. Dennis Jensen, do you have experience or knowledge of other judicial systems where the U.S. could take some lessons? I'd have to really think that one over. I have sort of vague familiarity with the UK, Canada, Australia, all have very similar systems, based on the Crown. And of course ours originates from there, but is very, very different in the modern era in a whole lot of ways. I think that we give a lot of protections to the accused, at least in theory, at least on paper, that other courts, other jurisdictions don't necessarily do. And then I've mentioned too, like in kind of Western European traditions, I have some familiarity with the German system because my parents lived there, and it's different in not being adversarial. It's inquisitorial, it's ministerial. The judges are the ones who are basically also kind of asking the questions and driving the investigation and stuff. And so, I mean, they're all just different. They're all just different approaches. I'm not sure how much of the problem with our system is principle and how much of it is practice. I think we have a lot of sound principles that I would hate to fiddle with too much. A lot of it is just political. The way that our system is set up, things like, what is a crime and what sort of punishment do you get for certain crimes? These are things the legislature decides. These aren't things that, a judge just pulls out of a hat and then is accountable to the electorate for the quality of that decision. They're constrained by the legislature, and legislatures never make fewer crimes. When was the last time you heard about the legislature passing a bill to take crimes off the books? It never happens. That's why when people have started decriminalizing marijuana, it's massive, right? That kind of thing never happens. Lowering the punishment for crack cocaine, dealing with that disparity, it's noteworthy when it happens because it so almost never does. There are just more crimes and crimes and crimes all the time. I've mentioned before the 5 Felonies a Day is an old book, old now, by Harvey Silverglade, and it just talks about there are more crimes than we can even count. We don't even know what they all are. We don't even know what all the law is. It's so convoluted and out of control because now the bureaucratic, the administrative state has gotten involved and they can establish crimes. And our whole system is predicated on this idea that as citizens, we are charged with having notice of the laws that we live under. But that's not realistic anymore. That's not realistic today. So I think that the way that we have exercised these principles probably leaves a lot to be desired. I would like to see things like maybe sunsetting certain laws, maybe limiting the power of the administrative state to create crimes, just more political pressure to periodically revisit these things and see if they're operating the way that we want them to. The problem, part of the problem there is just a political problem. A lot of different industry money controls, I don't want to say controls the legislature, but they certainly influence it. They certainly have a lot of power in that arena, much more than public defenders. we don't have a lot to say. The social workers don't have a whole lot to say. So I don't know that it's really the principles of our system that's the problem there, as much as it is just the way that we carry those out. James Casatelli, why is Bev so adamant about having the exhibits taken down right away? I think in part she doesn't want them sitting in the dark. Some of it just seems a little nitpicky. Like when there's a reason, like David Yanetti explains, it would be helpful for the jury if the map stays up while Lucky Lochran is talking about his route, because even if he can't see it and use the pointer, the jury can watch from the box. They can see while he's talking and look at where he's going. So the fact that he has to offer this extra explanation, it's a little frustrating, but I think it's mainly just because she doesn't want him to forget. She doesn't want him to forget that they're sitting here in the dark and there's a thing up on the screen. And so when it's time to move on, move on. It's just part of Bev's micromanaging approach to the case. That's how she wants it done. And so that's how it's being done. It will annoy her if they forget and leave it up there. And with most exhibits, it's no big deal. But, yes, I can understand if you got autopsy photos or something like that up there, you don't want to go off on a tangent and forget that it's up there on the screen. She wants you to get it done and get it off. So I have some appreciation for why she's doing that, but at the same time, it is just kind of another manifestation of these very micromanaging tendencies that we've seen. Track worker Rain Man knows his cars. Damn it, that's a little rude. He does know his cars. Fighting Usyk, most sincere dude ever. He really did. And the reason why, again, you get the sincerity, I think, is because he doesn't change depending on who he's talking to. He has the same demeanor and the same responses for both of the people. He's courteous to both of them. He's maybe a little more frustrated with one because he's not being fair to him. But that doesn't change his, well, I'm going to shut down. Now I don't remember. Now I don't have information. Now I'm going to try to get snippy back with you. Now I'm going to demand to know what you're looking at. He didn't do anything like that. He was the same guy throughout. And that exudes authenticity and sincerity. Daniela K. Lucky has no reason to lie or involve himself in this, but the people who wrote the reports do have a reason to lie. I'm on Lucky's side. Yeah. Yeah. We already have a reason to be suspicious of the people that are writing the reports, because the reports haven't been very accurate so far. In fact, even according to the Commonwealth's own witnesses, the reports aren't accurate. They got all this stuff wrong. So if my choice is between what the witness is specifically telling me and what Proctor or Buchanan wrote in a report, yeah, I'm believing the witness. Kyle Murphy, moral turpitude at its finest by Lally. He's just a jerk. Is it moral turpitude? I don't know. But he's just kind of a jerk. He doesn't understand or doesn't care about how to do a cross in a way that doesn't require you to just be confrontational and aggressive. So many other ways that you can do it. If you got the facts on your side, if there's a reason for you doing your cross-examination because there's actual information you need to elicit from the witness, you don't have to be so hostile about it. You can just point out what it is, why you know it, where it comes from, get their response. If it's a surprising response, you can express surprise at that response. You don't have to treat every witness like they're coming on the stand with an axe to grind. It's just, the common theme here. If it always looks like the person on the witness stand has an axe to grind, maybe it's you, maybe it's not them, maybe it's not every single one of them, maybe it's you. And the jury is going to see that too. Quite frankly, Samantha Teresa, is Lally going to ruin the flow of the defense with long, boring cross-examinations? Is that the strategy? No, he's just going to berate them. He's going to try to berate them and be rude to them into submission. And so far, what I like about the defense witnesses, they haven't taken the bait. They haven't gotten mad back. They haven't lost their temper. They're staying very gracious under all of this questioning, and it just creates a contrast then with your affect here, your approach here. It's uncalled for. It isn't necessary. They aren't giving you this energy back. Why are you giving this energy to them? So I think that they're doing that very well. Brian Alleman, I didn't call in the Ford Edge because I'm not a freaking knack. Yeah, he's not a knack. Not a knack. He wasn't going to knack on the Alberts. Albert, I can't, whatever. I'm terrible at accents, guys. Sorry, I'm not an actress under any stretch of the imagination. Entry required, torched by the plow, Gug. Wait for the defense experts. I like him so far. I really like Dr. Russell. Who didn't like, is there anybody in the country who did not like Dr. Russell? I mean, she's so interesting. I would love to just sit her down and talk about her life. I'd love to talk about her. I would love to know about her experience as a police officer, and then that pathway back into medical school, and the things that she saw in LA, and what does she think about all that? What kind of opinions does she have about policing and crime and stuff? I think she is so fascinating. And yeah, just very gracious. She's firm in her opinion. She's not going to be bullied off of it. But very gracious, even with, some pretty unfair and rude treatment by Mr. Lally. Mr. Green, just eminently likable. What a likable person. He's so happy. He's bubbling with information. He's happy to be there. Good at simplifying things. I don't know if he's right or not, but at least he's saying things in a way that makes sense to me. He's using my language. And I'm not a tech expert at all by any stretch. Obviously, look at my problems I'm having today. And, I got to think it's a fair assumption. The jury is likely to be like me. Maybe there's an IT person on there. I don't know. Maybe there's a couple. I don't know. I really don't. But, you can't count on that. You got to be able to put it in layman's kind of terms so that they can understand. He was extremely good at that. Everybody can understand. Yeah, I went and did it myself, and I recreated it, and I consistently got the same results. Yeah, we all understand that. And just that volunteering of information, I think knowing that Mr. Lally is going to say, no, I don't want you to go there, but signaling to the jury, I have so much I'm willing to share, so much I could tell you about all of this. Make Mr. Lally shut it down. Ugh, doesn't make him look. Okay, guys, sorry for how awful this is. And you get to see my piles of stuff here and this wide angle thing, my piano over here. Yes, it's Moonlight Sonata. We're gonna give this a shot. In fact, I'm gonna go ahead and move my mic because I don't think you can hear me from that. So if I sound terrible, I'm sorry about that. We're just going straight webcam system right now. So anyway, yes, it's all very strange. We're gonna have a weird day today, guys. It's fine. We're just here to talk. Kyle Murphy, gotta say how I like the confidence in AJ's posture. Yeah, he does. He's ready. He's ready. He's got a lot of confidence over there. It does read very secure in his case and in what he knows is coming. So good body language. Lori J, defense 1, Lally 0. This is just after one witness, after Lucky. Lucky was great. He was very good. I mean, what reason do we have not to believe him? What reason do we have not to believe him? He doesn't have a whole bunch of deleted stuff on his phone and things like that. I mean, the best that Lally had was he might have been led into the forward edge, which he absolutely denied, and then just doubled down because he can tell you exactly the difference between a forward edge and a Jeep Wrangler from behind on site. He knows his cars. It was so good. And then the only other thing they really had was just the discrepancy in one of the reports over the timing. And he flatly denied that too. And we have no reason to believe Proctor and Buchanan, who've submitted the misleading videos and have all that stuff wrong in their reports already, according to the Commonwealth's witnesses. We have no reason to believe them over him. So, yeah, he did great. Lori Leon, Rewind crew, excited for defense today. Love your homage to Dr. Cocktail Dress, rockin' it. Oh, thank you. Yes, I went with a little lace. I'm sorry, I don't have the full sleeve set. I might be the only, am I like the only Gen Xer who has no tattoos? I never got the tattoos. Never got them. It was never my thing. So, you know, it didn't go that far, but yeah, you know, I'm not against a good lace top, a good lace sleeveless top every once in a while. DeBob03, Lally hasn't seen My Cousin Vinny. Does it hold H2O? You know, I need to go back and watch that again. It's been so long since I've watched it. And, you know, I obviously remember it, but it's just, there's just gold in so many of the details of that movie. So yeah, I'm gonna go watch that again, I think. Rigid tactical defense starting with 2 likable witnesses. Very, very likable witnesses. I think that was, it was a good, strong choice. And also, yeah, now ending for the weekend. Ending for the weekend on the plow guy, the dog bite lady, and the Hoslung to dying cold search happened at 227. Yeah, I'd say that's a pretty strong strategic showing by the defense. Kyle Murphy, can Dr. Russell be my mentor? I think she's the whole world's mentor. I really do. I mean, and then it's not enough that she's working as a doctor. She's doing the extra stuff at night. Like the lady, her pace is very impressive. Sorry, I can't pronounce this. Iruwen. I am a geriatric QAPI, Quality Assurance Performance Improvement Certified. That is quite the field because you're looking at the systemic as a whole. Very important and a well-rounded practice. Good input. I mean, yeah, everybody needs quality control. I would be concerned if a medical system did not have quality control. That would be a little bit alarming to me. Everybody makes mistakes. Everybody makes mistakes. It happens. As much as you might want to try to have a perfect system, you can't, but you can improve it. You can learn from the mistakes that you've made. And so you want to see that they're doing that. James Brown, her response to pressure, not I would have said it, was I said. That's interesting. Not what I would have said, but I said, response to pressure. This is going back to the medical examiner, Dr. Scordi-Bello. And, you know, it is an interesting choice of phrasing. I saw people caught that. I hadn't caught that at the time. When they asked her, you know, would it have changed your opinion if you had, you know, did they put any pressure on you to come up with a manner of death determination? And she said no. You know, could again just be the choice of words. English is a second language. She's obviously very good at English. But when it's not your native tongue, I can understand how you don't always phrase things exactly like a native person would do it. Even after years and years and years, you can just have some conventions, some way of putting words and ideas together that aren't necessarily the way a native speaker would do it. So don't know how much to attribute to it, but I can certainly see the read that there was a little bit of a tell there. A little bit of a tell. What I did say, and not what I would have said. James Brown, Dr. Russell is coming across much more confident. Yeah, you know, again, I think the practice round helps him. I don't think the voir dire is generally beneficial for the party that's requesting it because the witness gets in the groove and they've had a dress rehearsal now and they know what's coming. So yeah, she seemed a lot more comfortable. She had a better just interaction, better kind of vibe going with Mr. Jackson. So overall, I think that tended to help them. Marcelo Frias, I blame Lally, Bev, and Elaine for the stream dying. I blame everybody. Obviously not my fault. Not me and my tech expertise over here. I'm really grateful to you all for tolerating. I can't stand the awful webcam. Can't stand it. Can't stand it. So thanks for your patience. Pine Rider, the testimony of Dr. Russell was going to hit the Commonwealth like a nuclear explosion, not only locally, but worldwide. Yeah, it was a dog bite. Everybody already knew it was a dog bite. Anybody who's looked at this arm and thought about it was like, yeah, I can definitely see that being dog bites. Okay, but to get it medically confirmed, yeah, that's good because we're not going to be gaslit. There's been enough gaslighting here. Oh, it's obviously road rash. No, it is quite obviously not road rash. Okay. I come from a cycling family. I was never a huge cycler myself. I did a lot more when I was younger. I would go like ride the time trials and ride some of the long rides that people do around here and stuff. Mostly when my grandfather was still alive, because he did that his whole life. But I got racers in the family. Like I got an uncle who was, like semi-pro cyclist for quite a few years. I mean, elite level athlete. And, the broken bones he's had, the crashes he's had, wear your helmet, people. Wear your helmet. I'll never forget the time. Pretty sure it was a mountain bike crash when he came down, landed straight on his helmet, shattered his helmet into about 1 million pieces. But his head was fine. The rest of him was pretty messed up. I have seen so much road rash on these people yet. No, that's not road rash. It's not road rash. I'm not going to be gaslit. And so I wasn't going to be anyway, but it's just really nice to get that validation from the medical expert. No, we're not crazy. We're not crazy. It's dog bites. Automata, what if any rehomed internet connection you got? I honestly don't even know who our ISP is. We run an Ethernet connection here. It's not like I'm not losing Wi-Fi or something like that. The whole fact that my computer or my camera is involved now has me a little bit alarmed. But I'm going to shut everything off, let it sleep over the weekend, and hopefully that will take care of the problems. Because I really do want my nice camera back and my nice microphone. Mad World, thought a doggo dropped one and blew your room. No, typically the dogs go to Jeff's office to fart. They're kind enough not to do that with me. They make that a boy thing. So I very much appreciate that. Andrew Hansen, Jackson looks like the Mayhem guy from the Allstate commercials to me, and Mayhem is what he's doing to the state's case. I can see it. I can see it. Definitely see the mayhem. He's not there to play nice. Not there to play nice and tiptoe around. Patrick Henry, why have they not gotten into her very specific experience with canine bite victims? My suspicion is that the Commonwealth has argued this isn't relevant. They weren't letting her get into that. At the same time that he's also trying to ask about it, really trying to have it both ways. Potential, that he could have opened some doors there, but he didn't really go that far down the road. But I think it's because the canine dogs, they are specifically trained, and so you wouldn't expect them to be exactly the same. That's not really the pertinent experience that she has that relates to this particular injury. This is just more from the experience she's had in the ER looking at all kinds of dog attacks that aren't necessarily by the trained canines. Kyle Murphy, who fumbles with papers this much? You gotta be organized, man. It would drive me nuts. I would lose my mind if I were in trial and I was that disorganized. I had to be flipping through piles of paper. I've told you guys before about my trial organization. Like I have redundancy built into my system. I have my witness binder. Every single person who is going to be a witness is a tab in my binder. Every single document that I might need relating to that witness, it is under that witness's tab. That means if there's like 4 officers that all deal with the same police report, I got it under each tab. Like I want to make sure I can find things like this. I've got my separate exhibit tab, my separate exhibit binder that has all the exhibits, numbered and tabbed. I have my own, like basically case outline, my list of my witnesses. What do I need to get from each one? What's my source of information that I need to get from each one? I would lose my mind if I were this disorganized. trying to find things at trial. No, you need to have it at your fingertips because it can matter. You don't have a lot of time to react, to remember, oh, I know I saw something like that. Where did I see it? You got to know your case inside out, and you got to know where to find your stuff. WM Penguin, bruh, she's an older person. Do we really need to explain how a majority of older people have issues with most, if not all, modern tech? Yeah, boomer, she didn't know how to use the Dropbox. She didn't know it was there. Maybe she didn't scroll down to the bottom and see all of them or something. Yeah, I don't think that was difficult. I think pretty much anybody could understand that things like that just happen. WM Penguin, to be fair, doing all that work and all that education for so long, she must be a whack job. Well, she's definitely not normal in the sense that she's not average. Definitely a lot busier and a lot more educated than average. Everage, I wouldn't have thought Lally would have lolled as much on cross as on direct. The man does not get the in and out. Also, for the love of everything good, give the man a cough drop. It's his tick. It's his verbal tick when he's uncomfortable. So, didn't like the answer you got. Okay. It's just one of those things he has, like the with regards to and sort of. It's just his verbal tick. No, he doesn't get the in and out. He doesn't get the in and out. He is more targeted on cross than I maybe, thought he could have been. He's more targeted than certainly I've seen in the past. I've seen people who are not good at cross. You literally just walk through the entire direct examination. It's really bad. He's more targeted than that. But he still has problems with knowing exactly what point he's making, especially if he's not getting the answer he wants, and so he's trying to work around the witness. No, he's still got to be reaching and just kind of sorting out his mental process while he's in the act of asking the question. It's slightly painful to watch. Quite frankly, Samantha Teresa, Lally knocked himself out with Dr. Dogbite Expert. He didn't do himself any favors with his attitude. He really didn't, because the jury liked her. What jury is not going to like that cop, doctor, pathologist, expert person who volunteered to help and is interesting and nice? Who's not going to like her besides Lally? John Scott, AJ needed to start with a sidebar and just kick that door open about it not being a car versus a pedestrian. I mean, the door was open. The door was open when Lally asked about, is this your opinion about the dog bite? Is that to the exclusion of everything else? That's opening the door to what did you consider and what did you exclude? Did you consider a motor vehicle accident? And why did you exclude that? I think in some respects they let him get away easy with some of the decisions he made with that cross. Kirsty, good evening from Scotland. Interested to see how Lally handles a cross considering he's not been a shining beacon of competency so far. Still not a shining beacon of competency on cross. Maybe slightly better than he is on direct in some ways, at least in the sense that he is slightly more targeted, so it goes faster. His crosses have gone faster than his direct, and for that, the world is grateful. Anton Ivanov, Dr. Russell equals Dr. Curry Mark II. Yeah, I mean, a lot of similarities with the Depp v. Heard. The people, they see what's happening and they're like, wait a minute, I better get in touch with those attorneys. They're not having it. Not having it with the nonsense. Dr. Curry, of course, was on the case from the outset, but very similar in terms of just having an opinion that is pretty central, pretty devastating to the other side. Dr. Curry coming out with those analyses, and just by comparison, so much more impartial, so much more objective, so much more professional and reserved and fair than Amber Heard's experts, Dr. Hughes, with all of the, only she can be a victim of domestic violence, using that gendered language all the time, spitting out things to the jury as facts when they are clearly just what Amber Heard told you, her version of events. None of that from Dr. Curry. And similar impression that I think we got here from Dr. Russell. She's just here to look at the photographs and tell you what they are. Not there to make a whole thing about it. Thrift with Joy with the super chat. Thank you very much for that. Kyle Cowden, pig DNA is a problem. SUV isn't going to add any. They're going to have to explain it, and it's just part of the irony of this case. We already now have the prosecution bringing up the NAS report. I mean, I can't get over this. I can't get over this. The hypocrisy is just mind-blowing. They'll be the first ones trying to present junk science and argue that it's okay, while the defense is over here screaming, waving their hands, going, the NAS report says this is junk. And he's going to come up with an explanation, maybe the contamination, sitting on the floor. It's not good evidence because of what they did. When any other time, if you'd have gotten solid, good DNA evidence off of that clothing, do you think we'd be arguing contamination at that point? Absolutely not. It's just so self-serving that it's just kind of obvious to me. Lori J, Lally is cringeworthy. Yeah, a lot of cringe in these crosses. Circus Monkey Mafia, I just got bit by a husky in November on my hand. The top teeth did a ton of damage, but the lower teeth did hardly any at all. It makes sense. I mean, the dogs learn bite inhibition. It's just part of the socialization of the dog. And so usually, like, the puppies will start to learn it from the mother. They play, they nip at each other. And as they get older, they learn, don't bite me that hard. And then as they start to interact with people, they learn it from people too. So, like, my dog likes to mouth. Buffy, she likes to mouth. She likes to have your hand and stuff in her mouth. But she's learned, be very, very careful with the teeth. She's very, very, very gentle with it. So, yeah, I mean, the jaw's a hinge. So to the extent they're inhibiting the bite, a lot of that is coming from the bottom. A dog that really wants to bite you, hinge closes up tight, and that bottom one is gonna go in. Because he's just going to kind of hook you from the top and have those lower teeth come up. Harder they bite you, the more damage you're going to get from those bottom teeth. So yeah, the whole mechanism of like, well, there's no injury from the bottom teeth. Really, it doesn't alarm me. That doesn't tell me a dog isn't still inflicting this other damage. Cow Palace Dave, do you think Lally knows he has virtually no chance of getting a conviction? I think that if everybody in the courtroom is being honest, they all know that. I think they all know that. I think Bev knows that. I think they all know that. I mean, they can't be that out of the loop. For all that Norfolk County District Attorney's Office seems to be quite a bubble. Seems to be really quite a bubble. Not sure they have a perspective on the way that justice systems work outside of their bubble. Hence, the things like actually thinking you're going to be able to introduce evidence that a witness tried to hire a lawyer as consciousness of guilt. That's a bubble. That is I don't know where this perspective comes from, but it is not widely shared with the rest of the world. So the question is really, does the jury share this bubble? Are they from the same bubble, or do they have more of an outside kind of perspective? I tend to think they're not in the Norfolk County DA's office. They're just normal people. They're going to see this like normal people do. And so far, what I see, how I see normal people reacting to this trial is no way she's getting convicted. Not Squirrel, Dr. Russell, I'm fast because I'm a trained ER doctor. Thought bubble, you're an arse. Yeah. She's not very impressed with Allie there, but with Lally, but yeah, they do. I mean, it makes sense. That was a good answer. Good explanation. You have to make decisions pretty on the fly. In the ER, somebody's bleeding out. You don't have time to go to the library and sort it out. So the fact that it didn't take her long to look at this injury and come to a conclusion about it. I mean, it would matter if there was some indication that she needed to spend more time on it, but we didn't get that. We just got this kind of implication that no, she didn't spend enough time. Well, why? It takes the time it takes. If it doesn't take that long, it takes her as long as it takes to review the stuff, then what else does she need to do? Not all of us are there to just pad the bill, Lally. Izzy, is Lally going to be an asshole to the two FBI witnesses? I bet he is. I bet he is. It's just his MO so far. He doesn't seem to know any other way to be. When I talk about Mr. Yanetti having one gear, I like seeing this other side of him on direct because it does give me a little bit of a comparison. And he's very similar, you know, even on direct. He does have just a very direct, blunt, gruff kind of way of speaking. But when he's allowed to lead the witness, I think it does come off as just a more friendly, or when he's open, when he's just inviting the witness to give the information as opposed to leading them on the cross-examination. I think that comes across as more friendly. So some of it may just have to do with the structure of cross, makes it seem like he's, you know, more aggressive or mean or something than he is. So a little bit of a different gear that I got to see from Mr. Yanetti today, and I did enjoy it. This gear from Lally, I don't like it. I don't like this gear. He should really find another gear because it's just not very effective. Mary Malarkey, Turtle Boy said Rick Green is next witness for AJ. I wish I'd caught that one earlier, but yes, he was. That was during the lunch break. And he was right. Turtle Boy's gotten excellent information so far. Found him to be pretty reliable. Minnesota knows closing arguments are going to be spectacular than 4th of July fireworks. The judge doesn't want to believe the government she works for is likely responsible for the death and cover-up of another state worker. I don't know what's going on in Bev's mind at this point. Bev has been in the system long enough that I can't believe she would be naive. She would be so naive to think, oh no, that wouldn't happen, couldn't happen, not true. My sense is just more she's resistant to it because of the headache it could cause her. You know, having to deal with these same cops, same prosecutors, stuff like that in the future. Because realistically, do we think there are going to be consequences? Oh, we might get Proctor tossed as the scapegoat, right? He's the one we can throw overboard and act like we've solved the problem, while not acknowledging everybody else in that group chat who was totally fine with the way that he behaved. So yeah, it's going to cause problems for Bev. It's going to be an annoyance. And anytime they end up in court with her, the attorney is going to know, you know what they did and you know who they are. So that's my read on that situation. But I am very much looking forward to these closings. I want to see. Lally couldn't give us anything in opening, right? He wouldn't commit to anything. He wouldn't tell us what we're going to see other than we're going to see witnesses and evidence. Well, you better, it's put up or shut up time as far as committing to a theory. It's time to a theory because you got to sell it to the jury. You're not going to be able to just throw every piece of information at them and not have to reconcile that, not have to deal with the inconsistencies with it. You're going to have to sort it out and decide what you think happened and what you want them to believe happened, and tell them what the proof is that they should rely on to come to that conclusion, and what the problems are. Anticipate them. Tell the jury why they're not really problems. Tell the jury why it doesn't undermine your case. I mean, it's going to be critical for him if he wants to have any hope of getting anywhere with this. I mean, David Yanetti absolutely cleaned his clock in the openings. And so if we get the same pattern in closing, that's what the jury is going to be left with going into deliberations, is Mr. Lally,'s smoking corpse there at the podium. You better figure it out fast. Good night, 1990 with the super chat. Thank you so much. Appreciate that. 74 Hodag. Lally's strategy seems to be, if you can't blind him with brilliance, baffle him with bullshit. I've said a few times that I feel like his strategy is it's to bury them. It's the trial equivalent of the discovery dump. Like, if we just put everything in front of the jury, then they won't know what to pay attention to, what not to. And then that way, if there are details in there that are bad, like, I don't know, for example, deleted calls in the call logs, maybe they won't notice it, and it's like he doesn't realize that the defense is then going to go ahead and pick up that opportunity to point out all that stuff to the jury. And then you look bad. You look bad for not dealing with it. And the defense is going to point out your inconsistencies. You're not going to be able to go to the jury and be like, here's the key cycle we relied on in the mileage. And by the way, she also went to Fairview that morning, which wasn't accounted for in the mileage calculation. You don't think the defense is going to call that out? Of course they're going to call that out. So yeah, it really does seem like he's just throwing everything out there. He doesn't have an answer. He's hoping that the jury will come up with the answer themselves. And that's, honestly, it's a little rude. It's a little rude and disrespectful to them. That was your job as the prosecutor. Build the case, argue the case. If you don't have the ability to do that, then maybe you shouldn't be bringing the case. Danny Chirinos became a member. Welcome. Appreciate you joining the crew. Baz4241, I think the timeline from the defense will be devastating. Well, so far the timeline we got from Richard Green, it's not super comprehensive, although I was very interested at this location data that was deleted in April of 2022. That was very intriguing to me, because that's after it's in law enforcement custody, right? John O'Keefe's phone. Does kind of raise some questions about why would they be deleting stuff? And can we be confident that's the only thing they were deleting? But even without that, yeah, the raising the issue with the timestamps, with the different clocks available in the phone. We got that previewed with Guarino, and Mr. Green just delivered that today. Yeah, these are the clocks. They're from Waze. No, they're not from the phone's power log. They're literally from Waze. And shows you that that 3 minute time discrepancy. So that's a good explanation for that step data. And then if the step data is not discredited, and he's telling us it's accurate, it's been studied, it's accurate, I tried to recreate it, it's accurate, well, then those steps at 1231, 1232, those are a problem. Those are a big problem for the Commonwealth. Michael Faraday. Lally's conduct towards Dr. Russell was disgusting. He's incapable of dealing with anyone with a contrary opinion. The jury will despise him. It's just so unnecessary. It's so unnecessary. You don't need to attack everybody. But he doesn't seem to know how else to deal with it. I realize it's not fun to lose and to be embarrassed on especially on a national stage like this. I've never done a trial on a national stage like this. I don't know that I would want to, honestly. I mean, yeah, high pressure, but you should have brought the goods. You should have brought the goods. It's not Dr. Russell's fault. You didn't have the goods when you brought this case. Tara Rayner, hilarious. The K also inverted. Looking down her nose may make sense. Andrea, I posted on X to you last night. Read the tab. Reload claim might need to re-dye. The K tattoo. I think we're talking about the neuropathologist from the other day, Dr. Stonebridge. I don't know what that means. I don't know what the tattoo means. I don't, you know. Whatever, it's important to her, it's meaningful to her. I'm obviously not a tattoo person, so nothing has really had enough significance and meaning to me that I want to put it in ink on my body. It's just not how I think things through. So I don't know what that K means to her. But I'll check out, if I can, what you posted to me on X. I'm having a very hard time keeping up with messages and notifications and stuff right now. These have been some long days. So if I miss things, I do apologize. Sylvia's daughter, if the bites were not from Chloe, why did they give their beloved dog to another? I'll keep saying that I don't take issue with the timeline of the rehoming the dog. It makes sense to me. They had her for another year, and then she had that dog attack, and then she bit the person in the course of it. Then they got rid of her. It makes sense to me. Yeah, I think if your dog bites another person, you would have to. There's a chance that dog could be put down. You know, I don't know what the law is in this area. It can vary all over the place depending on where you are, but dogs biting people is taken extremely seriously. And so, yeah, there can be situations like that where the option is going to be you rehome the dog like ASAP, or the dog is going to be seized and the dog is going to be put down. And yeah, if you love the dog, you might just go ahead and rehome it at that point. To me, that makes sense with their time frame. I don't think that it's related to John, because I don't think they ever predicted any of this stuff with John was ever going to come back on them. They thought they were in control. They thought they were in control of the message, of the narrative, of the investigation, of the charges. They were going to lean on Karen. She was going to plead guilty, and that was going to be that. So that's my personal read. I don't think the rehoming Chloe had to do with John. I think it had to do with that later incident, because they did get rid of her like right after that. Kathleen R. AJ or DY could have whispered to Little to pursue the doctor's statement. Yeah, they could have. They could have. It's not the same necessarily as like knowing how to do it, you know. You can't give her a full course on like, here's where to be careful, here's the pitfalls. Like you just get that from experience. But at the same time, the read on this doctor, she was not super dangerous. This was not an Isaac Baruch on the stand who is going to punish you when you give him an opening. God, he was such a good witness. Oh, to this day, he might be my favorite witness I've ever seen in a courtroom. He was just so good, so effective, so authentic, and not taking any crap from Elaine. He knew how to rumble. That was not this witness. She was extremely agreeable with the defense. And so hard to see a real big trap there, you know. But they could also think maybe the door is open enough. That's enough. I would hesitate with that, but they're the ones in the courtroom. They got to make that call. Linda P., do you know when the ME rendered her undetermined cause of death opinion to the police as related to the discovery over days of taillight pieces? I don't think she told us exactly the day that she signed the death certificate, but it was when she signed the death certificate that she made that determination. And she did say that she had contacted them with follow-up to get more information because she didn't have all of her questions asked. So at the very least, the 129 search would have happened, the one that was the same night as the incident. As far as after that, I just don't know whether, you know, they're continuing to find plastic and her determination was after that or before it. But I don't know if it would have mattered, because she would have known. CERT found stuff that night that they were saying was taillight connected to Karen's SUV, and she certainly would have known that, you know, Karen had the cracked taillight on her SUV at that point. Michaeline McWilliams, after the acquittal, what court case are we going to follow next? I have enjoyed your coverage. I don't know yet. I might take a little break for a little bit. Get off of the full-time stream thing. I'm definitely continuing to cover Koberger. I'm in that one until it's done. I'll be following that one to the end. I've mentioned before, I've been watching the Delphi case, the State versus Richard Allen over there in Indiana. I am planning to go to Indiana for the trial for that one, because it's not going to be live streamed. The judge is extremely hostile to the cameras in the courtroom. And it's a lot of crossover with this case in terms of there's just some sketchy stuff by law enforcement and some failures to investigate, and then compounded by leaning on the defendant in ways that are kind of disturbing. So it's one where there's going to be a real need for good information coming out of the courtroom, because that's all that we're going to get. We're not going to be able to see it with our own eyes. That right now is set in October, so it's still a little bit down the road. In the meantime, I don't know. I don't know yet. I'll look around. I'll see if I see anything. And then I'll let you guys know. Bass 4241, Lucky knew he probably would have lost his job if he had towed the Alberts car. 100%. It was a courtesy to the Alberts. In other words, yeah, I didn't want to get my boss up on me. What are you doing towing that car? Terry B, extremely unlikely an expert would be willing to reconstruct something that couldn't happen, hence the overkill on Google search panic. I mean, yeah, if you tried and it didn't work, it's discoverable. It's gonna come out. The other people could have tried it too. But they didn't have the right iOS, they didn't have the right phone, they didn't do it with the same material, the same items that were relevant to the evidence in the case. So that's, you know, not ideal. Not ideal. Typically, you want to compare apples to apples and get as close as possible in your reconstruction. You know, if we were going to try to reconstruct this car accident for backing into somebody with a taillight at 24 miles an hour, it wouldn't do any good to do it on a skateboard. You know, you need to be comparing same to same. So yeah, it seems like an obvious approach to take to validate these different opinions. See if you can recreate them. And according to him, yes, using this exact phone, this exact operating system, you can reproduce it the way he says it works. And so that kind of puts him ahead of the other experts, at least on a kind of common sense level. James Brown, snowplow driver's timeline doesn't matter. He would have gone down Fairview all night. He would go down the most traveled street all night. He was clearly in the neighborhood a lot, you know, multiple times. And if he's going back by, you know, around the time that the first responders are there, then, you know, yeah, he's there in the early morning. He said he drove by before that. That would, yeah, probably be a 5:30, 5:45 time frame. And then when he comes back, he saw the emergency vehicles there. And when he came back for his second pass after he turns around at the end, he couldn't get there. It was blocked. So don't see big problems with this timeline for me, but I think your point is well taken. He's on those main roads repeatedly throughout the night. So not squirrel. Yes, I can tell the difference between an Edge and a Jeep. How? The taillights. Drop of irony. The Albert's car ID'd by its taillights. That is pretty good, isn't it? He should be our taillight expert. We should have him go ahead and look at all these different videos of Karen's car before and after the cracking of the taillight and tell us what he sees. Does this look like that reconstruction to you? No, of course he couldn't do that. But it would be funny, and that is beautiful irony. I do love irony. I do love irony. That's a good one. Michael Muddragon, defeat you by Smash Mouth for the playlist. This playlist is dope, man. We're gonna have to like market this or something. I think it's gonna be good. Not squirrel. Lally and Commonwealth gave the 12:36 a.m. alibi for Karen Reed. As EDB says, this is Titanic. Lally, you had the report in your hand. I can see Emily. I can see her face. I haven't even watched it yet. But I can see her face when that 12:36 landed. Excuse me? That's big. That's big. I don't know how you weren't out ahead of that. Your own guy volunteered it on the stand, and you haven't worked that into your timeline at any point so far into your case. Were you hoping the jury was going to forget about the timeline of Jen McCabe's texts? Because they're a problem now. He's there at 12:24. Why is she texting him at 12:31 when Karen would have already left? She would have already left. OCD Shaggy. The trial showed how much power the Alberts have. 100%. Yeah. A lot of influence. A lot of influence. I do wonder if we're going to hear more if you know, so many of these witnesses on the defense list, Canton, Massachusetts, Canton, Massachusetts, Canton, Massachusetts. I don't know who they all are. The only ones I know at this point have some idea about are the Beatties, and I only know them because Jen McCabe told me she tried to call them. It's another you know, family of kids in the same age range as these other kids. So that's a local person. I gotta wonder how many of these other people are local people, and yeah, what they might have to say. I just don't know. Steve F. Andrea, back to Ian Whiffen. He declined swearing under God. Do you see this often? Could it affect jurors' perception of trustworthiness? I have seen this before. There's basically two reasons why it happens, which are kind of polar opposite, right? You might get an atheist who just isn't going to do anything under God. Not something that you know, they're going to sign on with because they don't believe in that. But it's actually more common because the atheist just won't care. You know, the atheist, you know, God is meaningless, so they don't care about a swearing. It doesn't have any special significance to them. It's actually a little bit more common that there are certain like branches of Christianity where they will not take an oath. They don't believe in taking an oath. Not 100% sure. When I was in Walla Walla, there's a large Seventh-day Adventist population right nearby in College Place, Washington. I vaguely remember that some of the Seventh-day people maybe would not like to swear. They would prefer to affirm. They don't like to swear oaths to God. It's like considered a little bit sacrilegious. It's kind of like taking God's name in vain. So I don't know that the jury is going to draw anything from that because I'm not sure that you can really tell what you're supposed to draw from it, you know. Now I say that from, you know, having seen it. It's not a regular thing by any means, but it's you know, it happens. It's not like crazy that it happens or anything like that. The jury, are they necessarily going to know that? No. So I don't know. I don't know. They're going to be instructed, you know, only the evidence is the evidence. So maybe they won't take anything from it at all. It's kind of hard to say how something like that would land. Just maybe depends on the religious backgrounds of the people on the jury as well. Desert Cat, I love your cocktail dress type top. Well, thank you. I think it's a little rock and roll myself, you know, little black lace. But, appreciate that. KB, I would love to see Lally's face during the witnesses of the defense speak. Come on, camera person. Not that I necessarily want to look at Lally anymore. I don't necessarily want to. But you do have to wonder, is he sitting there turning purple? Is he sitting there pressing his lips together, raging there in impotent anger at his table that he can't make it stop? Gotta wonder. Maybe he just doesn't care. Maybe he's defeated Lally by now. He's still fighting though. He's still fighting. If he's defeated Lally, he's still dangerous. He's still dangerous. You get a guy on the ropes, you knock him good, get him stunned, get him hurt, ring his bell. That's when he's the most dangerous. You can't just run in. And try to beat the guy. There was, we have a story floating around my gym because one of the guys who used to fight way back in the old days, he had something like that happen. He just landed a great shot on this kid. Knocked him down, got a standing 8 count. Kid's bell was clearly wrong. In amateur boxing, they do a standing 8 count. They don't do that in the pros. But it just gives them time to recover from a particularly hard shot. So he gets a standing 8 count. Kid's okay to continue, wants to continue. So ref lets it continue. Guy rushes over to get that knockout. Boom, runs right into him, gets himself knocked out, and the fight is over. So people are very dangerous when they're hurt but not finished. Dollyhood, Jeff's a probable babe and definite machine grade mod. What a fun week with the Burkharts despite Lally. XOXO. Well, thank you so much. I'm sure Jeff thanks you for that too. His babe reputation is now out there and official. Valcata. What if they threw his phone outside at 12:32 and then Jen calling him and texting was searching where the other Dumbos threw it recklessly? It could be so many things. It really could. It really could. I mean, the searching for his phone makes a lot of sense. He dropped it. He left it somewhere. If the fight was, like if they got in a fight out in the yard, that would make a lot of sense to me about how the phone could come out of your pocket or whatever, and you don't know where it is. You'd have to go and hunt it down. Somebody threw it. I mean, it's possible. It's possible. All I can really conclude is that it does seem like if that's what happened, the phone got lost. Jen called it a bunch of times so that they could find it. That was important. They would have had to find it in order to, dump his body on top of it. I can't see a coincidence, where the phone fell out of his pocket or he dropped it, getting out of the car. And then that just happens to be where they dump him to. That's too remote a possibility, I think. So a lot of different ways he could have gotten separated from that phone and leave them to need to hunt it down. Entry required. Bifocals love mine except walking downstairs. I'm so grateful to have still good eyes. I don't wear contacts, don't have glasses. I'm sure it'll change. It does for everybody, right? But it looks like kind of a pain. It looks like kind of a pain. Nikki B, how does defense prep their witnesses in this situation to deal with attitude of Aunt Bev and Lally's questions? So Bev, the only real prep you can give them is just, you got to do what she says. Leave the arguing up to us. Don't argue with the judge. Just follow her instructions and take your lead from us. With Lally, it's going to be part of any sort of witness prep to prepare them for cross-examination. Now, I don't know if they know what to expect from Lally, before today in terms of just demeanor. Like, how is he going to be? It's not the most unpredictable thing in the world to predict, hey, this prosecutor is going to be kind of petty and a jerk over stupid things. So just be cool, take the high road. Don't engage with him. He'll end up looking bad over that and not you. But they definitely prep on the likely subjects of cross-examination. So yes, like Mr. Green, he knew that what Ms. Hyde and Mr. Whiffen said in their testimony, Mr. Lally was going to come at him with that. Of course he knew. I mean, that's kind of his job, to know that that's coming. I don't know about Mr. Loughran, Lucky Loughran. With that report that Lally had put under his nose, trying to change the times, he didn't seem like that was familiar to him. He very clear he didn't that's not what happened. So he doesn't remember ever saying that, because that's not how it happened. Don't know why he would have said that. It does make me wonder. Maybe he wasn't prepared for that. I don't know. Not sure entirely. But yeah, you generally can anticipate what the weaknesses in your testimony are going to be, and so give the witness a heads up. This is how they're likely to come at you. Lally's not going to have a lot, so he's likely to come at you with this qualification stuff. Be prepared for that. That's very predictable. He's going to nitpick your publications. Very predictable. NAS report, probably didn't see that coming, but she's a smart lady. She's going to understand the issues with the forensic odontology. So yeah, she was prepared to deal with that already. Did not work very well as a gotcha. Rigid Tactical, call her Chef Bev because she is always trying to cook for the Commonwealth. Yeah. It's a pretty thin soup that the Commonwealth has cooking here. Even with all of the extra seasoning Bev is trying to add into that pot. It's just cooking away, not really giving us the flavor that we need. Entry required. Numbers of tech people reside in the Boston metropolitan area. Some may be in the jury and may know the tech like I do, as described by defense witness. Yeah, I mean, very possible there's tech people. Very possible there's tech people on the jury. Don't know. The parties do, because they went through the voir dire. They know that basic background information of the jurors that they got. I didn't see, I'm not 100% sure, like, how much information they get in Massachusetts. In my state, yeah, you fill out a questionnaire and you say, what is your profession and what does your spouse do and who do you do it for? It's just part of sussing out their potential connections, really, as much as anything, who might they know? Might they have crossed paths with any of the witnesses or something like that? So we find that stuff out. I kind of assume that they find that stuff out too. So they're going to know if these people have an IT background. And it makes me wonder if that's an upside or a downside, and for whom. Who would want to strike the IT people here? Do you think it would be the Commonwealth, or do you think it would be the defense? I'm not entirely sure. Duncan, Idaho, basically on the replay crew at double time today, but Lucky Loughran, I'm paying attention to the sides for any side traffic, pedestrians, or God forbid, any animals. I really like that guy. He's my people, yeah. The traffic and the pedestrians would be bad, but the animals, okay, hitting the animals, nope, not acceptable. That's not going to work. That's my kind of guy too. Rudoka, Lally is the Deepak Chopra of computer speak. He makes it sound fancy, but it just doesn't really say anything at all. I don't know. Seems like the expert had a hard time understanding what he was talking about too. That's one of the challenges as the lawyer. You're so dependent on your experts to be able to guide you on these types of cross-examinations, to be able to know what questions to ask, but you have to understand what you're dealing with well enough to, you can script out the question without having to understand it, but you got to understand the answer, or how can you follow up? Or if he doesn't understand what you're asking, you kind of got to know how to rephrase your question. So just didn't really seem like he had a particularly deep understanding of what he was talking about. Bruce West, I have an iPhone 11 and what this man just said is true. I drove from Missouri to Michigan and it not register a single step while I was seated in the car. I mean, I don't know. He says studies say 98% accurate. I don't know what these studies are. If Apple did the studies, I'm going to kind of side-eye them a little bit anyway, because yeah, they have every incentive to structure their study in a way that makes it look, like this technology is maybe better than it is. But if this is forensic people that are doing that type of study, they don't have that interest. They just want to know how much can we rely on this or not. So if there was an issue there, Lally could have brought that out. These studies that you're referring to, isn't it true that it's Apple that did that? And wouldn't it be the case that Apple would have an incentive to present their data as more reliable than in fact it is? He could have brought that out if that's the case, so I don't know. Don't know. Stephanie L., excellent coverage, Andrea, and I adore your lace top. Très chic. Ah, merci, madame. Merci beaucoup. Kyle Cowden, maybe I misunderstood. Late search was a new tab. It kind of sounded like that's what he was saying, that the 624 How Long to Die in Cold Search, that would have been a new tab. I didn't quite understand. I mean, I don't know. Yeah, the Commonwealth expert's explanation, it was just so convoluted. Like, I can make sense of it. I can see what she's saying. If this is a special type of tab that is created when the tab is open, but then is only finalized when the tab is closed, then I can see how it would register those different things at different times. It's just strange to me how that would happen then, how that would work. How do you create a tab in the first place? Is the wall file like just constantly being overwritten as that tab is being used? Or are there just a series of wall files that are created? Or if it's just one, how is it created without the search term entry? I don't know. I just don't understand enough about the tech to be able to make sense of that explanation. This guy's explanation, it seems sensible. Don't know why I should reject it. Nunzio, here is a little something to get you a fan for your camera. Haha, happy Friday. I actually, during one of these, running back to try to get it fixed, I have a fan set up here blowing on it. Maybe it helped, maybe it didn't. I don't know if it's heat. I don't know what the problem is. I'm going to shut everything down, see if I've got updates to install, whatever. See if I can get it fixed over the weekend. But thank you very much. I do appreciate it. Wilder's Honey, the plow guy is definitely going to stick with the jury. He was just a great witness. Very, very likable and sincere. He had those instant answers. He doesn't come across as having guile, as being deceptive, having to think through what his answer is. No, he gets it. And it's the same. Same for the defense, same for the prosecution. He's the same guy. Yeah, I think they're gonna remember that. Nunzio, Haas long for camera to die. Well, the webcam at least is working, as terrible as it is. So worst case scenario, you get this awful view of my room next week. But no, I'm going to try to fix my nice camera. Haas long to die camera. Mike weighs 3 minutes off, same iOS ball game. Kind of seems like it. Kind of seems like he upped the ante in terms of the quality of what he was presenting. How these other people never, I mean, granted, they weren't asked, the scope of Jessica Hyde and Ian Whiffen. It didn't encompass all this other stuff. It was just limited to the 2:27 a.m. So it was on Trooper Guarino to validate that timestamp in the Waze search if he was going to rely on that. And doesn't look like he did. Doesn't look like he did. And then being able to recreate this activity with the browser state DB wall file by doing his own searches in the same iOS, yeah. To me, that's very persuasive. Being able to recreate it, yeah, big issue in science. Replication is like, being able to do that is kind of a big part of the key. So you can tell me all the theories that you want all day and make sense out of it, but if you can't make that actually happen, then I have to question your theory. Your theory is good in your mind, but if it's not playing out in the real world, then I just don't know how good your theory is. I would almost prefer not understanding how it works, but being able to recreate it over having a fancy theory that I can't validate. Maybe that's just me personally. Jason Sorensen, I meant close, not Claude Taste or his close. Lol. A misspelling. It was close. Well, thank you for clarifying. Aulophobia. Have you heard of the Rachel Nichol murder, London 1992? Interesting example of what can go wrong when LE gets stuck on a suspect. I have not, but I'm going to write it down. Rachel Nichol, London 1992. And I'll check that out. I mean, there are so many examples of this, oh God, the Olympic bombings. Richard Jewell is an example of this. They get their idea and they're going to chase it down and they're going to lean on these people no matter what. I've brought up the West Memphis 3 before. It's 40 years past those murders, and still the state is not interested in looking at anybody else besides them, even when all of this evidence has since come out that would tend to exonerate them. It tends to be exculpatory. The DNA, not theirs. Not theirs. Who is it consistent with? One of the kids' fathers or stepfathers. Something like that. Not good, but they're not interested in going down that road. And so, yeah, love to say it's a rare thing, almost never happens, but it's just I think everybody wants to follow the evidence. Well, everybody, I'm speaking generally. Most cops, in my opinion, are good cops, and good cops want to follow the evidence. They're not trying to go down the wrong road, but it's just how bias works. It's just how bias works. Once there is something in there that catches your attention and makes you think this might be the guy, that is now going to drive your decision making. We're just not perfect, impartial robots or whatever who can take in all of this information and be unaffected by it. So we got to have better ways to be able to identify that and deal with it and work around it. I don't know what those answers are at this point, but yeah, it does happen. James Brown, Lally, no substance, confuse and deflect. A lot of that tricky questions that the guy can't answer. He wants to give you so many explanations to your tricky question, and you are literally telling the jury that you don't want them to hear that. You don't want them to hear his full explanation, just the little partial one that you are limiting him to. I mean, if I'm on the jury, does that impress me? No. No, it doesn't. Why would you not want me to have all of the information? It makes it look like all of the information would be bad for your case. Michael Lawless, how is judge sustaining objection without stated basis? Because she wants them to do it that way, and she decides what she thinks the objection should be, and then rules on that. And then that way, if they have any questions, they go to the sidebar and they work it out. But for whatever reason, we are not to know what the thought process is behind the objections, what the basis is for her rulings, the limitations she puts on the evidence when she sustains them. We are not to know that. That's how Judge Bev wants it done. K. Lally was aggressive almost in a personal way, not substantively. He's more aggressive than the defense, but much less effective, and it felt mean. I like the way you put that, because I think I see that too, that it's one thing to be aggressive if, like, the person is so wrong that the facts just don't support them, and so then it's like offensive that somebody would get on the stand and say something that's just so completely misguided, right? But that's not what he has. That's not what he has. He has people whose facts seem, at least, to be well substantiated and consistent. They have good explanations for them. So coming at them like that, yeah, he's not coming at them with substantive issues. He's coming at them with, credentials. You haven't been an ER doctor you haven't done an autopsy since 1990 something. I mean, okay. You haven't ruled out all the universe of other possibilities. Well, actually, yeah, she had. That was such a good answer to that one. Actually, yeah, to a reasonable degree of medical certainty. And then Green, of course, I mean, Green is the big one. He's trying to go toe to toe with Green on the substance, but he can't. He can't. He doesn't know it well enough. He doesn't understand it well enough to be able to go toe to toe with him. And so Mr. Green just completely outplayed him with that being so willing to volunteer more information than he wants. He gets the upper hand in that, and it makes Mr. Lally look small and petty and just kind of mean for being so dismissive of him when you're cutting him off, you're interrupting him, you're not letting him give his full answer, and he's just staying perfectly happy and jolly about it. Yeah, I like how you put that. It does seem a little bit more personal than substantive. Jason Sorensen, these are what prepped and good witnesses are. Well, they know what they're going to be asked. They know what the point is, and they're getting good questions. They aren't getting these questions that they have to follow like on a roadmap from Canton to Dighton to understand what is he even trying to get me to say. I felt so bad for those forensic experts from the Commonwealth because they seemed perfectly nice. You know, those they were all young women. The Maureen Hartnett, and I forget the other names, but the lady that did the taillight, the one that did the DNA swabs and stuff like that, they all seem perfectly nice, but having to try to follow his questions and then like they feel sorry. They're apologizing. I'm sorry I couldn't understand that. It's not their fault. It's not their fault. It's squarely on the person who just doesn't know what point they're making, and that does speak to preparation. If you had prepared this thoroughly, you would know what points you would need to make, and then you wouldn't have to stumble around like you're coming out of the bar or the waterfall at 12:15 trying to find your question. Charles Argo, I think your camera is overheating. Use a fan. It might be, the fan was not helping. We'll see. It's weird that it didn't do it yesterday and it did it today. Kirsty became a YouTube member. Welcome, Kirsty. Thanks so much for joining us. Jason Sorensen, Lally is trying to be Jackson and it shows. You can't be something you are not. You end up being a cheap imitation. Yeah, he doesn't do as well with the "that's not what I asked you." When Jackson pulled out the "that's not what I asked you," it's because the witness is evading the question. He's answering something different than what Jackson was specifically trying to focus him on. So it's his way of redirecting the witness back to, here's what I asked you. For Lally, it's you're giving me more information than I want to hear. And it does not have the same effect at all. It doesn't have the same effect at all. We can critique Jackson's strategy too, as maybe sometimes being harder on the witnesses than it needs to. Maybe this technique for redirecting could be softer. You know, you can always nitpick stuff like that, or just have differences of opinion about what's effective and what's not. But yeah, ultimately everyone is going to have their own style with that type of thing. But the bottom line is that that's the difference between his use of that particular phrase, that way of handling the witness, and Mr. Lally trying to use that just creates such a different impression because he's not using it in the right context. These aren't redirects. These are, you're trying to cut the witness off and limit their answer. El Stinko farce, what a difference competent questioning makes. 100%. I loved that contrast that we got from Mr. Yanetti. Mr. Yanetti showed us prepared. He already knows what exhibits they're going to. He already knows what paragraph they're going to. He has got this planned out. That's how you plan a cross, and then you don't have to sit there and trip all over your own feet trying to come up with what your question is. He already knows where he's going, and then from there it's very simple. Critter Watcher, is it a common cross-exam tactic to try and gaslight like Lally did with the length of the Boston Globe subscription? No, it's borderline unethical to do that because you're supposed to have a good faith basis for the questions that you ask the witness. You don't get to go up to them and suggest, well, you know, isn't it true that you beat your wife before you came here to testify in court? No. You don't get to just make stuff up on the stand. You have to have a basis for being able to ask it, and you can be required to give an offer of proof for asking the question that you asked. So if he's knowingly doing that and making stuff up, that's not ethical behavior. If he just made a mistake and didn't remember and thought she had it right, okay. But you look bad. You know, you look bad. He doesn't have any way to substantiate that. Like, I don't know what he was gonna do with this. You don't have it in a transcript to come and stick under her nose to impeach her, to say, yes, you did, here it is. Do you want to change your testimony about the length of the subscription? That's how you impeach a witness. You don't impeach a witness with, well, I thought you said this the other day. It just made him look like he didn't know what he was talking about because it didn't shake her at all. So no, it's not a common a cross-exam tactic, not a good one at all. Don't recommend it. Don't do that. It's not good. A geezer. Something bothers me about the cell phone times. When was there time for a fight, especially Apple Health data? I mean, I don't know where it would fit into all of this, right? It does seem like if Jen is making the phone calls to try to find the phone because the fight has already happened, then that means it happened within, 15 minutes of him going in the house. Which I guess, I mean, I could see it. I could see it happening fast. The 1231 to 1232 Apple Health data was the last that they had, right? So they had the initial steps. He arrived at 1224:28. The Apple Health data first recorded steps between 1221 and 1224. So he got the 87 meters, the 80 steps, and the 3 floors during that time frame. So that's up until 1224:37. Then the last bit of John's health data was from 1231:56 to 1232:16. That's when we had 36 steps taken over 25.46 meters. That could be a fight. Fits the time frame. Fits the activity. the reason why there's no activity after that? Yeah, because his skull is fractured. He's not moving anywhere after this. He went down and that was it. And that's why there would be no health data for then why he ends up back in the front yard, because the health data isn't going to record it as steps if he's dragged or if he's hauled or something like that. This is where it ends. So I think that's an argument for where it fits in the time frame. 12:31:56 to 12:32:16. 36 steps. Quick fight. Quick fight. That's 20 seconds. 20 seconds can be a long time in the ring. 20 seconds can be a long time in the ring. Oh man, last time I got in the ring, I've been out of the ring for quite a while. I haven't sparred much since the beginning of the year. I'm getting a little old for it, but I did get back in a couple weeks back. I've had a couple sessions since then, just, a few over time, but not nearly the volume I used to. So I'm very deconditioned for the ring. There's being in shape and there is being in fighting shape. And these are very, very different things. Just being able to access the gears to work at that intensity. If you don't do it all the time, you lose it very, very quickly. So I do not have the gears in the gas tank that I had a year ago, when I was sparring a couple times a week. And we had an all girls class at the gym, and so me and my friend Heidi, who is I send your Heidi Elkington on Instagram, the maker of my fish, so much art around my house and stuff like that. I love this girl. Met her through boxing. She is one of the toughest girls I have ever met. I outweigh her by a good 50 or 60 pounds, and she has beat my ass for years. She is just, she is solid, hits like a truck, very aggressive, really, really good in the ring. I love her to bits. Anyway, we were doing a spar just as like a demo, basically for people girls that had never sparred before, but were interested in doing it. So we decided what we'll do is we'll just do a 1 minute round so we can go super high intensity, right? And then, get an idea for people can see what that pace is like when you're just letting it all go. And we got the bell for 30 seconds and I was like, it's been a lifetime already. It's been a lifetime. 20 seconds in a hard fight can be a very, very long time. So I can see this fitting the time frame. And then after this is when Jen McCabe starts making those phone calls to find the phone. Let's just look it up because I got all the notebooks right here. Let's just go ahead and find Jen's testimony about that. Because I think she denied it. Didn't this come up on cross and she denied that she was making any of those phone calls? Because then they confronted her within the grand jury. She said they were butt dials. I think that was her butt dials. So the texts were at 12:22, 12:31, 12:41, 12:42, and 12:45. I do remember the 12:31 was the pull up behind me. Karen would have already been gone. And she said she definitely got up and down the first 2 times, and she wasn't sure if she was still looking out the window for the other 3. So anyway, those are the text messages. Where did we get to the phone calls? Didn't use your phone. first we listened to the voicemail. We got the calls to Nicole at 6:07 and 6:08, and she admitted calling her, but says they weren't answered, which was a little strange. My sister never answered the phone. 6:23 call to Brian. We're kind of going in reverse order because they really jumped around with her. All right, call records. 12:14, you called John, it was answered. 12:18, John called you and it was answered. So that's the asking for directions, right? That's the asking for directions. That makes sense as far as if the time frame is off, he's put it into Waze and calls her, and then she gives him the directions. 12:29 a.m. call to John, unknown if it was answered or not. Didn't speak at 12:29. 6 more calls between your phone and John's up to 12:50. So yeah, that's our time frame then. 12:29 to 12:50. 7 calls. Yeah. That fits the time frame for that to be the fight. So that would make sense to me. That would make sense to me. 12:31:56 to 12:32:16 is when there was a fight, according to John's health data. Wouldn't be surprising to me if they argue that in closing. Entry required, came for artwork behind you, stayed for legal analysis. You get a little different view of the art here, right? My fish. You can kind of scoot my chair out of the way. You can see the whole little school of them. So she did something super cool. These are all metal cutouts that are then powder coated. But she did some new ones that I'd love to find a way to be able to bring in here. But right now I've got them hanging outside. They're 3-dimensional. They're so cool because she's got the 2 pieces of metal now and they're joined together. Looks super cool. She does the coolest art. Check out her stuff if you haven't. Heidi Elkington. Anton Ivanov. AJ said only 3 witnesses left, closing on Tuesday. Wow. I wonder who they're going to be. Wonder who they're going to be. And I wonder who all these other people are. I'm going to be forever curious. All these people from Canton that are not getting called. I don't know who they are. But that's quite an aggressive time frame. It means they're very confident with their case. 3 witnesses. I wonder if any of them are going to be Karen. I guess I'm doubting at this point that any of them will be Karen. I realize that is the common wisdom, not to call her. You don't need to, but I would like it. I would like it, but I would be satisfied if she just writes her book. Karen, write your book. Write your book. We all want to read it. We all want to read it. It will be a bestseller. Debbie O, I used to be a legal secretary. We over-organized for court the way you described. You have to, or things can go downhill quickly. Exactly. It's just so much better to be over-prepared than under-prepared. Everything else being equal. And granted, you don't have infinite time. You got to use things wisely. But the reality is that for you to be prepared to go to trial anyway, you need to be going through all of this anyway. Like you need to be doing this work. So it's very little from there, from just reviewing everything to taking the step to copy it, put it in the right place in the binder, have it get organized. It's just becomes a little bit of the routine. But yeah, when you can't find the things that you critically need, that's a bad place to be at trial. Bruce West, she lacked Trooper Proctor's integrity to Lally. Yeah. I think we're talking about Dr. Russell here. That in Lally's world, yeah, she should have been more like Trooper Proctor. If only she had been group texting with her friends about how awful these Commonwealth witnesses are. Probably Lally himself, right? If only she had been group texting about how he's got no ass. Spidley, I bet Bev faults her husband for lateness because his 15-second delay relocating keys after waiting on Bev dicking around for an hour and a half. Could be, could be. Move it along, please, Mr. Canoni. Would you move it along? Can you get to the next question? Are we ready to go yet? I'm not very good at impressions. Hopefully you understood who I was even trying to get at there. Yeah, the whole blaming the wrong person. I can see it. AKA the cat lady. So many still think Karen was drunk. I really blame a lot of this on the Trooper Buchanan testimony. I blame it on the Trooper Buchanan testimony because people listened. It was late in the day. It's in the Lally days. It's kind of boring stuff. They weren't watching the video for themselves. They didn't watch him gaslight us to our face. Well, we sat here and we watched the video with him and we did not see what he told us was on the camera. So I think if people didn't do that, then yeah, what they're aware of is she drank drink after drink after drink, and it's recorded. And then there was the blood test later in the hospital, and and they did the math on it, and it was just massively high. And even if it was the low end, it would have been so much higher, back the night before, assuming she didn't go home and start drinking. So yeah, I think a lot of people do think that. And that's the benefit of watching it for yourselves. That's why sometimes you got to watch the stuff for yourselves. If you're going to have a strong opinion about it, I don't have a problem with, everybody follows things sometimes and has an opinion just based on what they read, based on the bits and pieces that they see. It's just a question of how strong is your opinion? How much hubris do you have in your perception versus how much do you have the humility to recognize, I didn't watch the trial, so I don't know. I don't have strong opinions about the Murdaugh case because I didn't watch the trial. I've seen pieces of it. Based on the pieces that I've seen, I have some opinions, but are they firm, definitive? No. I'm not informed enough to be. Just enough for me to kind of question. Not really. I don't think they really put a gun in his hand, but they definitely nailed him with that Snapchat thing. He was there. He was definitely there. He knew more than what he was letting on. He lied about all kinds of things. I've seen enough to have an opinion that I'm not sure they put a gun in his hand, but you could change my mind, if there's something in that trial that I didn't see. I didn't watch the whole thing. So that's the upside of watching it for yourself, is you get to have confidence in your opinion about it because you are as informed as you can be about the situation. Timmy Sargent, Andrea, how does your common sense tell you that they turned fight charges into murder and not call 911? Well, because they needed to protect themselves. A fight that results in somebody's death is probably a felony assault at the very least. If not a manslaughter, if it's not intentional. So whoever got in the fight at the house, if it's somebody they care about protecting, that's why, because it's him or you. That's what it came down to. It's him or you. And, yeah, he couldn't survive if he was going to have potentially, bad things to say about how he got into that state. I'm not sure, given these injuries, that they would have been survivable, or that he wouldn't have had such severe brain damage that he wouldn't be able to communicate. I don't know. It sounds like his brain was super messed up. But how much of that is because of the fact that he was left, didn't get the immediate medical intervention, help alleviate the effects of the brain swelling and stuff. It's just hard to say. But I think that's the answer. It was them or him. And so, he lost. He's not family. He was lower in the hierarchy of concern there. I think we got a little doggy blow by there. And they thought we can lean on Karen and make her, make her scared and she'll just plead and then they'll get away with it. And that's what they thought. Bruce West, in closing, show the Ring video taillights and ask the jury how the red taillight wound up on the lawn. Yeah, I think there's just a lot of things like this that they can do to just really drive the point home. Didn't happen the way the Commonwealth is trying to tell you that this happened. Have the call logs up there, deleted. I would like to see a demonstrative of their time frame now that I feel like we have enough of the bits and pieces from the defense side to be able to understand what they're saying happened. I mean, I do. I think now we can pinpoint the fight. We can pinpoint when he got to 34 Fairview, and then that can tell us when the fight is. And Karen's already gone at this point. And then they can show the cover up. They can show how this overlaps with the phone calls to the phone and the texts, pull behind me, and then how that all got projected onto Karen. She's fabricating stuff. She's going in and deleting things. I'd like to see a demonstrative like that breaks down their timeline, because they have a much more cohesive theory here than the Commonwealth does. The Commonwealth can't make up their mind if she went to Fairview and kills the key cycle theory, or if the key cycles work and therefore she couldn't have gone to 34 Fairview. Entry required: baking shirts on butcher paper 4 weeks or more, dog saliva DNA would be destroyed. Saturated fat from ham sandwich would not be. Fat encapsulates DNA. There's just so many ways, being out in the snow and in the environment that the shirt is soaking wet, that can destroy DNA. You're not always going to get DNA when you think you might. It depends on the shedding, depends on, all kinds of different factors. The environment's a big one. But yeah, I can definitely see how leaving it out not necessarily going to be helpful. Brenda Lentz with the super chat. Thank you so much. Power 64, what do you think about the case for DUI? Did they ever have bar receipts? Not that came in. So what we have is the video that the jurors can watch for themselves. And I would hope that the defense in closing would invite them, would point out what Trooper Buchanan said is on the video is not on the video. Go and verify that for yourselves. Because otherwise, that's what they have. They have the video, they have Trooper Buchanan's testimony, and then they have the blood draw. And so that's really the strongest case I think that the Commonwealth has, is to be able to say we drew her blood at, 8 a.m. the next morning and it had alcohol in it. And from that, we can do these equations and stuff like that. The defense had hinted that her MS could skew the results because it has to do with lactic acid formation, and what that test that the hospital is doing is not a direct test for alcohol, it's a test for metabolic byproducts, and those metabolic byproducts can result from other compounds in the body, including lactic acid. If we're only getting 3 witnesses left, I kind of doubt that one of them is going to be an expert, to spell that out for us. So I think that they are just relying on their ability to have planted those seeds during that testimony. One, that the results could be skewed because of her medical condition. 2, from the guy that did the retrograde extrapolation, who said, yeah, this can vary for any individual person, and the assumptions can be off and so forth. Just hammering on how he himself kind of conceded this is very limited information that relies on a number of assumptions, and assumptions are not proof beyond a reasonable doubt. And then the third piece had to do with the way that they did the blood draw. Did they sterilize it with alcohol? It's a normal thing to do. If you're going to pull blood from somebody's vein, you sterilize their vein you sterilize the area with alcohol. That's the standard process, but you can't do that with an alcohol test. That can skew your results. You got to do something else. The hospital guy was so insistent. Yes, you would use betadine for something like that. Common to do that, iodine or betadine. But he was so emphatic that it must have been that way. Like, it's so important that it be that way that they took all the alcohol swabs out of the ER. But at the same time, they rarely do this test. It's just, I don't know, it didn't add up for me. I don't really buy that, but maybe the jury will. So that's how I expect the defense is going to have to attack it. Now, I could see a scenario where if there is somebody on the jury or a couple people or whatever, if there's a split. Some people on the jury are in favor of the Commonwealth. They want Karen to go down for something. Other people on the jury are in favor of Karen. They don't think she did anything wrong. Could see a compromise verdict on the DUI part, but I don't think that gets them to the manslaughter. I don't think that proves that she hit him, and all of the charges that are going to the jury are about her hitting him. They got to get to she hit him. The DUI only matters. They're not asking for a lesser included on just straight DUI. Maybe because that would be the obvious compromise there. So the jury has to come to she hit him if they're going to convict, and I just don't know that they're going to get there. Tina T, because my Apple Watch run out of charge quickly, I will leave it to charge and will go out for a run, and my Apple Health doesn't record the exact run, steps, and climb versus my Apple Watch. I mean, it makes sense that the watch is going to give you more detail about that, because the watch is picking up more data, it's picking up different data, and the watch is specifically designed, to do this. Its purpose is to pick up that type of information more than the phone is. With the phone, it's like it's an add-on, it's a bonus. If the phone didn't have it, would people not get iPhones? I kind of doubt it. It's just an extra little perk that you get. Rube, Dr. Russell also happens to be an expert on gang tattoos. Great article on her in LA Times. That's interesting. I did see the article. I didn't get a chance to read it, but I did see. I also saw, coincidentally, she also raised a niece and nephew. So lots of funny overlaps in the case. But an expert in gang tattoos, yeah, I bet she has seen a lot of gang tattoos. And yeah, you can learn a lot. You can learn a lot about people from their gang tattoos. If you know what they mean, what they symbolize and stuff like that, they can tell you a lot about a person's history and where they've been, and who they affiliate with, and all that kind of stuff. RB0426. Yanetti said after court they have only 3 more witnesses, the 2 ARCA experts and Sheridan. Okay, so we know who they're getting then, the crash reconstructionists. Sheridan, I don't know who that is. Somebody can tell me in the chat who Sheridan is. I saw that it came up with Dr. Russell's testimony, because that was one of the things that she was asked to look at, and she hadn't like addressed that in her testimony on the voir dire. But I don't know who Sheridan is, so I'm waiting to find that out. Kim McGuire says he's a pathologist, so well, then that will be helpful, right? That's going to get back to if the reconstructionist can't get to inconsistent with a car accident, then I would think the ARCA guy is going to. I'm sad that means no Karen, but I certainly understand. Beach Rando, I want a cartoon series based on Frankentruck. Great idea. Great idea. Frankentruck could be a big star. I could see that being a lot of fun. Cheryl Fodal, how did Jen make so many butt dials while it was plugged in charging as witness stated? Young lady. $1 million question. All these butt dials. I saw somebody suggest it would have been great to ask them to recreate on the stand how these butt dials happen. Could you try to butt dial? No, Bev would never allow that. But yeah, just so many problems with the testimony. The whole Brian Higgins and Brian Albert one too. You butt dialed him, he butt answered, butt dialed you back, you butt answered, and you know, like, no. We're not idiots, people. We're not going to be gaslit here. Beach Rando, Piss Lally spent as much time on Jen's timeline only for Commonwealth's expert to totally discredit timelines. KO dropped JO off and left no 20-minute lag. He did. He put that whole bunch of information out there about the going up to the door in the back, and all of the witnesses spent so much time trying to expand that window up to like 1240 because they had to, because of her texts and her communications. Just for his own witness to blow it apart. Couldn't have happened. She is back at One Meadows Ave at 1236. Yeah, I don't blame you. I would, if I'm the jury and I've been trying to make sense of all of this and piece it all together from this information. Yeah, I'm kind of annoyed too. Because this whole time I've struggled with the timeline, and now I know it doesn't matter. She wasn't even there. And in fact, all of these texts and stuff like that, they were happening after she was already gone. Arla7247, in my opinion, it was a bat put J.O. in the pool. Could be. I mean, yeah, a bat is going to cut your head open, abrade your skull. Maybe you'd have more of a crushing injury. I don't know. It's blunt force trauma. They couldn't get any more specific than that. So, but it will be interesting if the Sheridan is the defense pathologist. It will be very interesting to see what he has to say about these injuries. Entry required. Gave wife her phone, told her to butt dial me. She said, I can't do it. Ask everyone else to butt dial their spouses. The only person who has butt dialed me that I can think of in the last 20 years is my mother-in-law. She is no longer with us, but she would butt dial us, but it wasn't because like it's on the nightstand and she's butt dialing us. No, she's messing around on the phone, and she was a little airheaded. She could be a little inattentive, and yes, would be doing things, stick it in her pocket, and then before the phone screen locks back up, it's making all this contact. You end up getting called, and then you listen to her for like 20 minutes going about her day. Because I would listen, it's just kind of funny when it happens. You try to call out, hello, okay, can you hear me? And she's, doesn't hear all that well either, so she wouldn't know. It's been a long time since I've been butt dialed. I don't think I've butt dialed anybody. Probably about the same, about 20 years. Solo YOLO, if defense brings weakest witnesses first, imagine what's coming. I'm not sure the defense has weak witnesses, honestly. If they're leaving it to six total, when they had, 40 some? How many did they have on their list? I'm gonna look it up just to remind myself. They had 71 witnesses on their list. Now that's given, a lot of repetition with the Commonwealth's witness list as well. 71 people that they've narrowed it down to 6. That's how to do it. That's how to target your case. Okay. You don't need everything. You just give us the best. I bet they're all the best. Mavka, Haas, could you forget the name of test chart? Yeah, test chart. I forgot. I do forget people's names. My bad. It's one of those things, like, I'm not proud of it. I would like to be better at remembering names, but you can meet me, shake my hand, tell me your name, and 2 seconds later, it's gone. It's gone right through. I have to say the name out loud, and preferably a couple times for it to stick. It's just not, names don't stick with me. That's why I take so many notes. The squid. I find it odd that Lally not only doesn't know how to properly ask questions, he also seems to hire generic witnesses while the defense outclasses him in every way to include experts who are the best. You know, so many of his witnesses are police officers. You know, the experts are police officers. That's a kind of, you get what you get. You know, you get what you get when it comes to police officer experts. I was not unimpressed with Hyde and Whiffen. They seemed like they're highly qualified. You know, I didn't have an issue with them as far as being underqualified or anything like that. The forensic scientists, I didn't have an issue with them being underqualified. It's just, I think the problem for the Commonwealth is that the more qualified the witness, in general, the more they were willing to admit the limitations of the information that they can give. You know, the dog DNA lady is going to acknowledge absence of evidence is not evidence of absence. She's going to acknowledge garbage in, garbage out. I didn't control the swabbing, you know, and so it's not helpful for the Commonwealth. The medical examiner is going to acknowledge, yeah, this could be consistent with a lot of things, including getting punched in the face and falling back and hitting your head and, suffering those injuries. Yeah, it's consistent with that. Didn't she even say the arm could be? No, they didn't ask. I wanted her to go ahead and push and ask the arm. Couldn't that be a dog bite? But she didn't do that. I did want that question to be asked. She just seemed so agreeable. Why not? What's the worst thing she says is no, and then you bring on the dog bite expert to say, yeah, it is. I don't know. But I think that in general, like, I didn't have a problem with the qualifications of Jessica Hyde or Ian Whiffen. And to the extent I was able to follow it, I was happy with Jessica until they gave me Ian. And now I've got this different theory. And I don't know which one is right. I don't know why they don't reconcile. Like, it was too much information. It was more than I needed or wanted. So I don't understand that decision to put them both on. It's just that compared to the defense expert, they were so much more difficult to understand. I feel like I was able to track them, but it took work. It took work. It shouldn't be that difficult. That's the whole point of having an expert is being able to put things in terms that the jury can understand. So in that sense, yeah, I think the defense did a little bit better with their selection of the experts there. Very much looking forward to these crash reconstructionists because these guys are already dangerous. They are already dangerous. We saw it in the voir dire. Doctor will be fine. Oh, gold. Gold. Arla7247. KR not crying at JO picks may be bad with jury. I don't know. It's been a long time. You know, she has seen a lot of this stuff already. I can't imagine that the jury is expecting her, you know, that like if she's not super reactive to the photos, that it's a terrible thing. There's always a possibility, yeah, there could be somebody on the jury that thinks that. But I personally think it's better for her to just react authentically than if she doesn't have the impulse to cry at the photos. Don't try. Don't go all Amber Heard on us with your fake no tear face scrunching thing. It doesn't work. It's way worse to try to fake than to just be authentically something that people maybe don't like. People can disagree with me on that. That's just my call. I tend to think that with the jury, the absolute number one priority is honesty, sincerity. They will sniff out bullshit. They will know. They know when you're not being sincere. So it's just rule number one, be sincere. And if being sincere means you can't get on the stand, you better not get on the stand. Bruce West, they used facial ID and all of them were shit-faced. Yeah. Yeah, could have been. Could have been. They did. I mean, this is one of the questions. If they have John passed out, they have John's phone there at the scene. Well, they have John's finger to be able to open up John's phone and try to mess with stuff. I don't know that we have any proof that they did. I mean, I think what's there in the phone is pretty damning. But I still am very curious about the April 22nd location data that got deleted. How and why did this happen? It's very peculiar. WM Penguin, you guys are misunderstanding. You have to be having intimate moments with others to be able to butt dial people with such efficiency. I don't know. Jen was pulling off a pretty good series there right at the table. Nothing intimate going on there, we hope. Oh, no, we're not going there. We're not going there. Guys, what a week it's been. I can't believe we finally got to hear those magic words. Magic words. The Commonwealth rests. We've waited for so long. So long. So we'll come back on Monday. It'll be day 30. We'll come back on Tuesday. It'll be day 31. And it will rest. And the defense will show us mercy. They're not going to over egg the pudding here, bringing all these unnecessary people in to tell us all kinds of duplicitous things over and over again. Repetitive, boring stuff we don't need to hear. They're going to give the jury the meat and send them into deliberations. What a contrast. What a contrast. The jury is going to see that. 29 days for the Commonwealth versus 3 for the defense. 10% of the time that the Commonwealth is spending on their case is all it takes for the defense to make their points. If I'm Karen Reed, I'm feeling very good right now. I'm feeling very good. We knew she wasn't going to get the dismissal as a matter of law. We knew that wasn't going to happen. It's just not realistic. That's not this case. It's not that those motions never get granted, but it's just extremely rare. It's just extremely rare. It's usually because maybe the prosecutor abandons a charge along the way, just stops being a priority, so they stop trying to prove it. A witness changes their testimony. If you've got like a he said, she said kind of situation, and your witness recants, changes some of their details or something like that, yeah, that can affect your ability to prove a different charge. Those are the types of situations when it happens most often. That's not what we have here. We just have a case that is highly lacking in credibility. And being reasonable people, we can look at the case and project. The jury's going to probably see it that way. The jury is probably also reasonable people that are going to look at this and see, wow, a lot of problems here, not proof beyond a reasonable doubt. But that's not the standard for throwing it out. The jury's got to do their job and pass on that evidence, make that determination that it is unreasonable in order to acquit. And frankly, the acquittal, is a little bit more vindicating than a dismissal anyway. Not that, of course, you wouldn't take it if you can get it. You avoid the jeopardy at any opportunity. But, I feel pretty confident in projecting that. You can never be 100% sure what a jury is going to do. You can never be 100% sure what a jury is going to do, but I think you can look at the case and see the writing on the wall and have a pretty fair degree of confidence in what's likely here. So I think Karen is feeling pretty good this weekend. Don't necessarily pack your bags for 4th of July weekend yet. Don't want to get out ahead of your skis. But yeah, next weekend, this could be all over. Could be all over. Well, guys, I've enjoyed this time with you. I'm starting to almost reminisce already, like because we're so close to the end. You know, this good time that we've had here, this good chat. I've appreciated it so much. Z says Arca and Sheridan are important, but wanted to hear from Tom and Aaron Beatty, Trooper Kathleen Price, Google, leave Morrissey and Berkowitz for DOJ and FBI. I would have liked to hear from the Beatties. I would like to know what they had to say. I can understand how if they're just there to kind of add on to the impeachment of Jen McCabe and the McAlberts and so forth, you know, not putting them on the spot and putting them out in that position if it isn't absolutely necessary is potentially better for them. You know, it's not your only consideration. Of course, when you're the lawyer, your first consideration is the client. But, you know, they if they're going to experience blowback, if they're concerned about that and you don't have to, then yeah, you don't put them on the stand. Just because Andrea Burkhart really wants to know what they have to say. Trooper Kathleen Price, Google would have been very interesting. I definitely would like to know what Google has to say. But I just don't know. It could have been boring. It could have been just records custodian for, you know, location data or something like that. I would like to know too, but I guess we're gonna maybe have to wait for the book. You gotta wait for the book. Karen, get us that book. I'm telling you, girl. Everyone will buy it. Teresa Kaufman, thank you so much, Andrea. How do you feel about the lesser includeds thought? So I'll send you over to my Substack if you haven't checked that out. I did write up a piece on the lesser includeds. As far as like, are they likely in this particular case? I think the fundamental problem with the lesser includeds here, they all require the conclusion that she hit him with the car. The rest of the details are around the edges. What intent did she have? Was she intoxicated when she did it, et cetera, et cetera. You have to start from the standpoint that she hit him with the car and that the Commonwealth has proved that beyond a reasonable doubt to convict her of anything at all that's on the table. So I don't think they've met that burden. All they have, their proof is Trooper Paul with his, I think it could have been like this, with the arm hit like this. It doesn't make sense on even a common sense level, and we are going to come back on Monday, and it's going to be absolutely demolished by these people who have experience with evaluating that kind of thing. They are going to the extent there was not already reasonable doubt in Trooper Paul's theory, they are going to blow it apart. I have quite a lot of confidence in that. So I just don't see a good pathway to convict her of a lesser included. Now, it's possible the defense could propose lesser included. The defense, for example, could ask for that straight DUI. That could be their invited compromise. Get her on DUI or just let her go. But they don't have to. There's nothing wrong with going for an all or nothing strategy here. If Karen really doesn't think she was drunk, they have all the witnesses, including police officers, okay? Including police officers who investigate driving under the influence, saying she was fine. Didn't seem drunk, didn't have any concerns about her driving. You got a pretty good argument that she didn't do anything wrong. And so it can be a high risk strategy to do the all or nothing, right? But I just don't see that in this case because the proof that she actually hit him with the car, it just isn't there. It just isn't there. So you don't give the Commonwealth a gimme in this situation. I don't think you give him a gimme in this situation. That's what you hammer on to the jury. Didn't hit him with the car. Doesn't matter what she said. Doesn't matter who she called. Doesn't matter what she did at John's house after. Doesn't matter what they were fighting about. None of that matters because she didn't hit him with the car. And that's all you need to know to decide all of the counts in the case. So that, broadly speaking, is my thoughts about it. Well, hopefully my camera gets a little rest over the weekend. I'm not even used to looking at this one. I'm used to looking at this other one. I'm all out of whack today. It happens. It happens. But yeah, I'll try to get that all sorted out over the weekend. Be ready to see you guys back on Monday morning. Thank you again for joining me. Thank you for all your good questions, your fun conversation. That playlist, man, that playlist's fire. We're gonna put that one together. We're gonna be rocking that this summer. I loved it. All these good walkouts. That's the stuff. That's what we come here for. And I will look forward to seeing you guys on Monday and getting the rest of what the defense has to offer here. So far, David Yanetti is right. I'm glad I waited. I'm glad. I think I'm going to continue to be glad, and I'm looking forward to Monday. Look forward to seeing you guys all then as well. Have a great weekend. Take care.